Yes. Yes. Mentioning.
Appellate.
Appellate side, wait for the appellate side. Yes. Call on the list.
Item number 1.
Alright, it is appearing at my request, my lord, for a correction in the judgment. 19th of February. I'm carrying 2 copies, my lord.
Order sheet টা কোথায়? আচ্ছা না ও কারেক্টেড কপিটা দিচ্ছে ওটা নিয়ে
Corrected copy is here, my lord. Kindly. আচ্ছা, corrected copy. Total correction করা আছে? I have indicated the corrections, my lord.
What are the corrections? Which pages?
The date of the order of the lower court has been wrongly mentioned. It should be 27th of August. Instead, it has been mentioned at 20.
Only in the last page?
Only the last.
Only that?
Only that.
Great.
The order date is 19th of February.
Thank you. In the judgment dated February 19, 2025, comma, in paragraph number 117 at page 33 thereof, comma, instead of August 27, 2021, comma, it was transcribed as August 21, 2021. Full stop. Let it be deemed that the said date be read as August 27, 2021. Full stop. Let this order be deemed to be a part of the said judgment for all practical purposes. When you apply for certified copy, apply for certified copy of this order also.
Yeah. Also to drawn up and the.
Because we don't want the orders of court to be corrected by the office. That's why you don't direct that. That would maybe more beneficial. We don't want to encourage that.
Applied for the drawing of the decree. It was then pointed out that the date of the trial.
Right. That is very crucial.
Oblige.
Thanks. Okay. Mentioning call code.
Mention it. Order 31.
The inclusion in the list.
Pardon? What is this? What is the matter?
My lord,
Under what heading?
order 41, my lord, rule 11.
Well, yes. Yes.
Yes, numbers are somewhat.
What is the number? Which page?
I have indicated it here, my lord, in the.
What the name? Which paragraph is Mukhopadhyay?
It's paragraph 42, my lord. 166,777 it would be instead of 77, my lord.
Oh.
And there is permanent from transferring 2290.
Right.
And mandatory.
So you have these mistakes occurred in transcribing from the prayer. You have checked up this. Your corrections are in consonance. No, need not. You have checked up that this is.
Yes, my lord. And there is 740 share, not 750, my lord.
Yes, these are mistakes. This part we don't check ourselves. We leave on our officers. Anyway, Learned Counsel for the appellant rightly points out that in the judgment dated March 13, 2025, comma, in paragraph number 42, comma, certain errors in transcription cropped up while setting out the decree. Full stop. The said errors are as follows. Colon diye, in clause small a within bracket, comma, 1667750 shall be read as 166777501-8600. Full stop. Next para. In clause small b of para 42, comma, in the second line, between the words double inverted transferring inverted close and within double inverted equity, comma, the number 2290 shall be incorporated, and in the third line, comma, the number 166775001 be read as 166777501. Full stop, next para. In clause C, instead of the expression injunction, comma, the term order shall be incorporated in the first line. Full stop. In the third line at page 13 of clause small c, comma, after the number of the title suit, comma, the following phrase shall be incorporated, colon দিয়ে double inverted, in the name of the plaintiff stroke appellant, PRA capital. Next para, in the first sentence, first line of page 14, comma, instead of 750, comma, the number of shares shall be depicted as 740. Full stop, the entire expression shall be read as double inverted, remaining 740 shares or issue duplicate shares in lieu of all the 2290 shares, double inverted close. So next para, in the fourth row of schedule A at page 14, comma, the number 9658541 in the second column shall be read as 765841, and in the third column, comma, the number 166777552 shall be read as 166777551. Full stop. Next para, the aforesaid corrections be deemed to stand incorporated in the judgment dated March 13, 2025. Full stop. Next para. The decree to be drawn up on the basis of the said judgment shall also incorporate the above corrected position. এটা থাক। অনিন্দিতা, ওই দেখে যখন করবে দেখে এটা দেখে করে দেবো, পেন দিয়ে করবে। Yes. Item 2 with 3. Yes.
Or in this matter, my lord.
Filing written notes. No, you have already.
No, my lord.
Yes, so filing written notes.
Additional notes.
Notes, my lord, how in this fashion we can do-
Additional notes.
how we
No,
can do
we
it?
asked you to file composite written
Only
notes of
copy the
arguments.
judgments.
Now, if your lordship, my lord, this copy of the judgment has been incorporated in the additional notes.
No, we don't understand.
The judgment has been.
You have already filed a written notes of
Yes,
arguments.
Here-
Notes
These
of
are additional to that,
additional.
and you are handing over the
Additional to
copies.
that, with regard to additional document, the additional judgment.
Additional documents of
No, additional judgment, my lord. To that effect, my lord, additional notes of argument, my lord, I have.
no, these judgments you did not cite at the time of hearing.
I have argued, my lord, but those judgment has
No,
not.
if you did not cite the judgments, you don't.
But I have argued, my lord, with regards to value, you lordship may
You cannot cite, Mr. Dotto, this is basic. You cannot cite a judgment in your written notes which were not argued in open court.
My lord,
If you did not cite, too senior for this.
my
Please
lord,
don't do this.
my lord, only
No, juniors should learn the wrong thing.
my lord, I am.
You have not cited those judgments, you are adding those in your additional written notes.
I am, my lord, paying for leave to my lord. My lord, this is the law point, my lord, involved in this matter regarding section 5.
Whatever may be the law point, if you did not cite the judgments, how can you incorporate
But
it in additional notes?
I have argued, my lord, your lordship, that
No, you have argued the points, you did not cite these judgments.
I have not cited, I have argued before.
How can you add those in your written notes?
I have argued this
We'll
point.
fix it for further hearing on those additional judgments. Learned counsel appearing for the state, comma, unfortunately, comma, seeks to incorporate further judgments which were not cited at the time of oral arguments, comma, along with the additional written notes of arguments. Push up, it is rightly pointed out by learned counsel for the respondent that such permission cannot be granted, comma, since the judgments were not relied on at the time of arguments. Push up, next para. However, comma, for the ends of justice, comma, let the matter be fixed under the heading hearing on April 8, 2025 for further hearing of the parties on the additional judgments now sought to be cited by the state.
8 তারিখে কিছু আছে না ওখানে?
Come back on 8, we'll hear it again.
Yeah.
Part হিসেবেই থাকবে।
Lord, only thing I am telling you, Lord, I
You-
have, your lordship asked me, I have distinguished all the cases in.
Mr. Bera, whatever judgments they cite, we have to give them opportunity because they are wanting, but we'll rehear them on those judgments only. And
But I
please
have
give
to-
the
you are
copies.
not covering those judgments he has supplied, but very well on that day I will
No.
file.
You have to answer to that.
Yes.
And Mr. Dotto, please supply the citations to
I
you.
have cited, I have given that.
Next.
on the last occasion, নতুন কোনো written
না, না,
note আছে কি? নতুন কোনো written notes আছে কি?
না, রিটেন নোটস আপনি দিলে আমি দিলাম, আপনি আমাকে একটা দিন, আমি দিচ্ছি।
Next.
No, my lord, without doing that, your lordships can take those judgments. I have dealt
No,
with
no, no,
this.
Ms. Sabera, we want to, yes.
Then on the on
This
that day-
practice should be deprecated.
Yes, my lord, on this, I have also, my lord,
Orally just submit for
Yeah.
2 minutes on the next day to
only,
take
my
it.
lord, I have dealt with those cases in my notes,
Very well.
distinguish those cases, but may I
We will
submit
hear you
this
on the
the
next.
last, on the
New judgment we won't take
My
without
lord.
hearing.
My lord, I am appearing for the respondent in
three,
this
yes,
matter.
yes.
It has come at my instance.
Yes.
Your lordship kindly consider the order passed by your lordship on 4th of November and point number 6 and 7. Whereas in that, my lord, your lordship directed that paper book is to be filed within 3 weeks
Order
in
গুলো কোথায়?
default 4th November.
Order.
4th November 24.
ওটা শীটটা দেবেন তো।
Point number 6 and
Sorry,
7,
which is the date? What is the date?
4th November 24.
What number? Yeah.
Lordship kindly consider point 6 and 7. Your lordship directed the paper book is to be filed within 3 weeks.
Yes,
In
yes.
default, the interim order will be vacated. They have not filed the paper book, so naturally the interim order has been vacated. And the appellant, my lord, has vacated my plat. And he has taken no objection from the appellant's advocate. So, my lord, I'm praying that there is no merit and does not
Can you
want to.
please file a 2-page application on this? We'll pass an order. An application for appropriate order. We'll take
I'll
note.
file an
These have to come on oath
I see.
that they have vacated and all these things.
Yes, my lord. I'll
And
file.
that they have not complied.
Yes,
we have
my
to
lord. They
take
have not
note of.
complied.
Please do that.
I'm grateful.
Learned counsel appearing for the respondent submits that no paper books have been filed in terms of the order dated November 4, 2024, and as such, the interim order stands automatically vacated. Furthermore, comma, certain other facts are brought to the notice of the court, comma, inter alia regarding the appellant having allegedly left the suit flat. The respondents are granted liberty to file a short application seeking appropriate prayers on such pleadings upon service of an advance copy of the same to the appellant, to the learned advocate for the appellant, liberty to the respondents to mention such application as and when filed.
If
Whenever it is
that
filed, just
appellant advocate is not available, they have taken no objection from him. He says, I will not appear.
আচ্ছা, to the appellant যেটা বললাম, appellant, comma, direct to the learned advocate না করে, to the appellant, comma, directly and to court through the learned advocate for the appellant in this court. You can serve directly also.
Number 5, my lord, I'm appearing for
Yes,
the
Mr. Chatterjee, but
my lord,
that matter.
yes, we have prepared
is appearing for the respondent.
we have prepared a written notes.
Yeah.
My lord, I shall stitch and page mark. My lord, it's my lord, I shall
You are not using
understand
that
it.
is that.
now, my lord, only few submissions I will make with the written notes, my lord. My lord, I have relied upon, my lord, an UNICEF document where, my lord, Mr. Rai was also trying to argue, my lord, the concept of kafala. My lord, if my lord finds kafala is, my lord, sponsoring a child. That is accepted by UNICEF, and UNICEF.
Mr. Chatterjee, we found two ways out in this JJ Act. One is that sponsorship and the other foster care.
Yes.
So these will look into that whether something can be carved out for you through those channels.
Yes.
But you have violated the law in holding the child for 2 years. You have to report within a particular time. Otherwise, criminal consequences are there.
I'm going to tell your lordship, my lord, while considering this 84, which is the parent judgment, Lord, I was going through, my lord, the Supreme Court says the only way out is the guardianship in case of adoption given by this
84 is the
institution,
judgment where this CARA was directed to be formed.
where guidelines were framed by the
Yes,
Supreme Court.
by
And,
virtue
my
of
lord, by
that,
virtue
JJ
of
Act,
that,
yes, JJ Act was,
2015 was,
yes.
my lord,
But
brought
that
in.
is pre-JJ Act. After JJ Act, you cannot look
But
into that.
If now, my lord, if considering this judgment and the JJ Act 2015, if it's looked into, my lord, for the purpose of intra-country or international adoption, my lord, this 2015 Act was brought into force.
That
By
was the
amendment.
purpose.
That was the purpose.
But this applies to our country as well.
Our country. Now, my lord, with respect to guardianship, my lord, paragraph 9 of this judgment, if my lord.
No, Mr. Chatterjee, it's very difficult for us to rely on that judgment because that has culminated in a law now. We have to look at the law.
Yes, yes, absolutely.
But I will look into this.
Yes, my lord,
What
just
does
I'm
it say?
making- It says, my lord,
Keep it with you, yes.
my lord, it says that, my lord, for guardianship, my lord, court has the ample power to restrict, my lord, what has fallen from, my lord, with regard to this trafficking issue. Now, my lord, it has expelled, my lord, in the number of citing
Mr.
provisions.
Chatterjee, that was prior to the act. That was
Yes.
prior. Now the
Now,
act is in force,
my
we
lord,
have to go by the act.
by the act also, my lord, it says if when
We have
this
to look
act,
at the provisions of that. Wherever there are loopholes, we can enter.
and my lord, another thing, my lord, I would just indicate, my lord, I was indicating, my lord, the term, my lord, under 14.2.5, my lord, the term unfit and incapacitated, my lord, is not defined under this act. Now, my lord, if it is not defined, my lord, I take aid of the Black's Law Dictionary, my lord, which says, my lord, it says something related to, my lord, mental incapacity or incapacity to take responsibility.
Yes, yes, absolutely.
Now, my lord, this relates to a family law. My lord, JJ Act, my lord, doesn't say so. JJ Act, then, my lord, what happens, my lord, a parent who is a poor, my lord, right is given to him to surrender the child. Not the JJ Act will come and collect the child. My lord, so if there is no surrender, my lord, that's what this 84 also says. My lord, in Indian country, my lord, there is a right given to surrender. Now, parents are to be counseled whether really you want to surrender child to here.
Surrender is not the only provision. Abandonment is also there.
Now, my lord, abandonment, this 214.6 now, my lord, which comes into, my lord, will look into, I have written in the written note, that abandonment, the child is not abandoned because ostensibly support in kafala concept is also there with the child. That is the, my lord, means, my lord, by which the child was growing up. Now, my lord,
Either way, the child becomes a child in need of care and protection.
my lord,
We cannot avoid that regard.
written down certain safeguards to come out, my lord. I have said, my lord, bi-monthly, bi-quarterly, I can report to the local PS and, my lord, file a report on the progress
You
of the
cannot
child.
rewrite the law, Mr. Chatterjee. Only foster care and
My lord,
sponsorship.
under Guardianship Act with the provision, because the court has the power to even remove a guardian suo moto.
Guardianship Act does not apply. We tried on level base, there is nothing. JJ Act prevails on every nook and corner. We have seen throughout to the act. Seen, gone, I mean, whatever we have. But we are thinking in the line of sponsorship and foster care, but definitely we'll take into consideration because you're citing this, we'll see that whether we can carve out any, on the basis of this, whether we can carve out any interpretation, whether can be in the light of this. Definitely, that's a good point. Good. Learned counsel for the appellant cites the written notes of argument as per previous direction. First of the same is kept on record and the matter is reserved for judgment. Thank you. This is probably love's labor for you. Yes. Sponsorship or foster care কম scope.
6 minutes, I'm appearing for the applicant, my lord. My lord, this is, my lord, can 8 is the, my lord, can 8 and 9 is the, my lord,
Have the file first. Yes.
application
You
for
know, you are moving can 8.
can 8, can 9, my lord.
Acha.
Application for restoration of appeal. My lord, appeal was dismissed. My lord, after, my lord, paper book was filed and, my lord, appeal was admitted, my lord. Admitted and paper book was filed, my lord. Appeal was dismissed before the Lojima bench for non-compliance of some technical
Paper book was filed
formalities.
means appeal was admitted. Must have been
Yes, 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 my lord.
Lodging means for non-compliance of what?
Non-compliance of, my lord, is such an deposit requisites, etc., my lord. That is, my lord, lordship, kindly see my application, can number 9, my lord, annexure A, page 9, my lord.
Thank you. Page 9 of
Relevant paragraph, page 11, my lord.
of can 9.
Yes, my lord, can 9.
First, tell us what is the reason for the delay.
My lord,
Why so
reason
long?
for the delay, my lord, I have explained, my lord, my client was not informed, my lord, at all.
What is the delay?
My lord, 320 days delay, my lord. And my lord, appeal was, my lord, restoration application allowing application for condonation of delay was filed before the single bench. My lord, now, my lord, lordship, kindly see the order dated, my lord, 3rd April 2024, my lord.
Yes.
3rd April 2024, passed by, my lord, honorable single bench, my lord.
No, application was already filed there.
Yes.
These applications only those have been sent to us.
Yes, my lord. Yes, my lord.
That delay you don't have need to explain.
Yes.
Your explanation shall be confined to the filing of the.
Yes, my lord. Yes.
After that, what happens is not your head.
Yes, my lord. My lordship, kindly see, my lord, can aid my application.
Page 11, we have come there. Page 11.
Yes,
of
page
can 9.
11, my lord, there is, my lord, order for. order for my lord,
Acha, did not
dismissal.
use-
Order of
This was the compliance you did not do.
yes, my lord.
Putting in the requisites for that only.
Yes, my lord. On page 22, my lord.
Why didn't you put in the requisites?
My lord, this is my lord, change it, my lord.
Anyway, page
Um,
22 of what?
Page 12, my lord. Page 12, my lord, matter was dismissed, my lord, by
Obviously.
Lojima bench, page 12. 30th March 2022.
Lojima bench.
Yes, my lord. Well, that was confirmed, my lord. My lord,
One second. Lojima bench dismiss তো করতে পারে না।
page 12, lordship kindly see.
Oh, without further reference to the bench, ওটা record করেছে। So we have to recall the division bench order. Lojima court cannot dismiss of itself. It was only a recording that it has automatically stood.
My lord, division bench, my lord, observed, my lord, in the event, my lord.
Division bench
Complaint-
observed that in default the appeal will stand dismissed without further reference to the bench.
Yes,
So the dismissal is by virtue of the division bench order automatic.
yes,
The Lojima court, the registrar cannot dismiss for
recorded.
default.
yes, recorded.
The rules prevent that.
Yes,
The registrar rightly recorded that it has already stood
yes.
dismissed. করে দিচ্ছি। How soon can you put in the postal requisites? File it by today. That is the condition. That was the reason for which it was not done.
Yes, my lord.
File the requisites by today. We'll direct you. That will be the fresh condition.
No, lordship kindly see, my lord, at least today, my lord.
How much? What is the which code? Not 24 Parganas. How much would be the requisite? When you file the application, you should be ready with that money. That would be the first condition we impose because that was the reason you are given time you failed.
Yes,
And this was passed in Lojima final order stage.
yes.
We won't give you further time.
2022, my lord, it was.
So what?
My lord.
You have
it
to
was
be ready
recorded.
with the money.
Yes, my lord, that's,
Deposit it today. That will be the condition of allowing this.
yes, my lord. And my lord, can 10 is the my lord restoration. Well, in pursuance to the order.
Can 10 restoration. Can 9 is restoration.
No, can 10.
Caption of can 9 is an application for restoration of the appeal and the connected appeal.
Yes, my lord. Can 10 is the my lord, substitution, my lord. Substitution of one of.
Substitution will come after.
Yes,
Who has died?
my lord, that my lord, respondent number 2, my lord.
When did he die? Before filing these applications?
You know, he died in my lord.
Can 10 এসছে? Can 10 কোথায়? এসছে? এখানে আছে? One copy has been filed.
Yes, my lord, because my lord, the matter was my lord, going in the before the single bench, my lord. That's why, my lord. But my lord, additional copy, I think, my lord, I have filed. Additional second judge's copy, honorable
So you
second
have
judge's
not
copy.
filed. File an additional copy. We'll take up the rest of. No, we cannot allow unless the substitution is allowed. When did the death occur? Prior to the dismissal for non-compliance, or before that? At least tell us that much.
My lord,
চেঞ্জ ব্রিফ পড়ে আসবে না তো চেঞ্জ নেবে কেন তাহলে চেঞ্জ ব্রিফ আমি যেদিন নেবো সেদিন চেঞ্জ ব্রিফ প্রথম কথা আমি নিতাম না দ্বিতীয় কথা চেঞ্জ ব্রিফ নিলে আমি রেডি হবো না ওটা কোনো কথা হলো তাহলে চেঞ্জ নেবো না চেঞ্জ নেবো না যদি না রেডি হতে পারে চেঞ্জ মানে অন্য একজন উকিলকে গালাগাল দিয়ে আমি চেঞ্জ নিচ্ছি
actually, my lord, in pursuance to the order passed by my lord, honorable single bench, my lord, I have served notice, my lord, upon all the
Please
respondents, my
forget
lord.
the single bench order. You
Yes, and my lord,
answer our query.
from the postal endorsement, my lord,
When did he die?
my lord, that's why it came to our knowledge from the postal endorsement that my lord died, my lord. Postal,
Who are the heirs? How did you come to know about the heirs?
that my lord, I have instructed by my client that my lord is the yes. But my lord, I have served all the respondents.
Date of death you have to give. Can 10 of 2023 is an application for substitution. Full stop. However, surprisingly, the date of death of the deceased respondent number 2 has not been disclosed therein. Full stop. Next para. Leave is granted to the appellants to file a supplementary affidavit disclosing such exact date of death of the deceased respondent. Full stop, such supplementary affidavit, comma, along with a second judge's copy of the supplementary affidavit. Along with the second judge's copy of this supplementary affidavit shall be filed within a fortnight from date. Full stop. The matter shall next be listed under the same heading on April 9, 2025. Please come back on April 9 with that supplement. Unless the substitution is allowed, you cannot. আচ্ছা আরেকটা লাইন অ্যাড করে সেকেন্ড জাজেস কপি
No, I have filed.
ফাইল তো
Yes.
This is the second one. The Honorable Second Judge's copy of Can 10 of 2023, which is filed in court, be kept on record.
Lord, may I take one indulgence to the previous matter? My Lord, I forgot to paginate the written notes. May I be permitted to
Yes,
paginate?
আগে written note যেটা ফাইল করেছে দুজন জজের কপি দিয়ে দিন প্রেজেন্ট করে দিন। একটু written note দুজন জজের কপিতে করে আলাদা করুন।
No, I am for the petition, I will, respondent petition, I will.
Yes,
The opposite party, appellant.
you're for your application.
No,
No,
it
my
is
Lord,
their
application is the mine, my
Your
Lord.
application, yes. What is the application for?
Lord, application has been filed, my Lord, for. my Lord,
Which application are you moving? Can 2,
Can two, my Lord.
right? What is the appropriate order?
I'm not getting maintenance, my Lord, since 2018.
Please just use the microphone.
I am
Yes,
not getting maintenance, my Lord, since 2018.
maintenance.
On the plea that the matter is pending before this honorable court. The marriage of 2010. Appeal is 210, my Lord.
The appeal is against what?
And my Lord, against the my Lord.
You obtain a divorce decree?
No, appeal has been filed by, my Lord. The
First, let him finish because
Lord,
both of you cannot
my
speak.
Lord, the suit has been filed by the husband against me, against the wife.
Obtain a degree.
No, my Lord, it was dismissed.
Acha.
It was
Please
rejected.
appeal.
It was
Please appeal.
rejected. Against that, my Lord, husband has
Very
paid his
well.
appeal.
So you filed an alimony application in this appeal.
In the, my Lord, in the trial court, I filed the alimony application, section 24. My Lord,
Section 24 is interim alimony.
my Lord, that was.
That
my
is
Lord,
exhausted, spent its force with the dismissal of the suit.
Lord,
You have to file a
my
fresh
Lord,
application for alimony, along with affidavit of assets as per Rajneesh versus Neha.
Lord, this is the application, my Lord, for maintenance. My Lord, I am paying maintenance.
No.
Which was, my Lord,
We can treat this as an application for maintenance, but you have to file an affidavit of asset also, as per Rajneesh versus Neha. There is a judgment, Rajneesh versus Neha. You know that probably.
my Lord, I will take the, my Lord, file the, my Lord, that as affidavit of assets, my Lord.
Do that. We'll grant you time.
Lordship, may we to
You will
file
file your opposition to that,
the opposition.
and also your affidavit of asset,
Yes, Lordship.
right?
Praying for 4 weeks time minimum.
No 4 weeks, 2 weeks maximum. Maintenance is not getting maintenance.
Please, Lordship.
No question of 4 weeks. Why 4 weeks?
I have
What
to-
is the reason for 4 weeks? You'll manufacture assets now and liabilities.
No, Lordship.
Then
If it
why 4 weeks?
is a change brief, I have to contact my client and.
Refuse the
lodge a
change brief. If you can't get yourself prepared, refuse change briefs. Why do you take change briefs? Is it a ground? Is it a ground before a court of law? It's a change brief. That's your problem, ma'am. Don't take change briefs. Why do you take change briefs? Whenever you're taking a change brief, you are casting aspersion on a colleague of yours. And if you take a change brief, if there is real reason, you should have to be prepared fully on that application. The day you take the brief. The present application bearing Can 2 of 2025 has been filed with the caption within double inverted for appropriate order, double inverted close, although the prayer portion reveals that the same is an application for alimony pendente lite. Full stop. Accordingly, we treat the application as an alimony application. Full stop.
Grateful, Lord.
The respondent stroke petitioner stroke wife shall file an affidavit, her affidavit of asset in support of the application within a fortnight from date. Full stop. A composite affidavit in opposition to the said affidavit of asset as well as the alimony application shall be filed by the husband within a fortnight thereafter. So you get 4 weeks. Full stop. Along with the said opposition, comma, the appellant stroke opposite party stroke husband shall also file his affidavit of asset within the said period of fortnight. Full stop. The parties shall exchange copies of the pleadings between themselves. Full stop. Reply, if any, shall be filed within a week after the affidavit in opposition and affidavit of asset of the husband is served on the learned advocate for the wife. Push up next para. The application shall next be listed on May 6, 2025. You file your affidavit of asset. You will file your composite opposition to that affidavit of asset as well as the alimony application. You deal with all those allegations. And you will file your independent affidavit of asset. They'll file composite reply to the entire thing. 2 weeks, 2 weeks, 1 week. Yes. Yes, what is the application?
Lordship, it's a first appeal with respect to a preliminary decree.
Right.
Which was passed on 30th August 2016 by
Right.
the Civil Judge Senior Division, Barashat, Lordship.
For the respondent, before my learned friend starts, my lord, before my learned friend starts, my lord, let my learned friend take,
Use the microphone, Mr. Woods.
let my learned friend takes instruction about, my lord, whether respondent number 3 is alive or not. My lord, she is the elder sister. We don't have any touch. My lord, our instruction is she has expired much, my lord, prior to the filing of appeal.
So you have to give specific date.
My lord, I am appearing for 2 brothers, 1 and 2.
How can you say she has died then?
Lord,
On
Brothers, my lord, told me.
presumption is ask the brothers what is the date of death.
My lord, she was married long back, no touch with the family members.
No, but then we have to, if you have to record your submission, you have to be
Then,
specific.
Lord, service, let them serve, my lord, at least. Let them wait for the, or lordship kindly ignore it, my lord. Ultimately, my lord, this is a partition suit. He has to serve all. I am only appearing for 1 and 2. My lord, if the service reports comes as deceased, then my lord, he will take steps.
If it comes as received, then
Partition
you catch
suit.
your brothers.
No, no.
If you are not sure, we are not
Then
recording
I'll-
your
I'll-
submission, Mr.
I'll-
Bhattacharya,
I'll
because you have to take
Kindly-
responsibility for that
Kind,
submission.
kind ignores that. Kind ignores that.
Your choice. I mean, we are
Kind
not
ignores that.
compelling you to
No,
either way.
Because
But if you say that, we'll record that and say that he has
all
to.
the brothers are, my lord, old. This is the, my lord, eldest sister. My lord, she was married, my lord, 55, 60
So it's a
years.
presumption of death.
No contact at all. No contact at all. But kindly ignores that.
You have instruction to apply
1
for.
and 2, 2 brothers. Ashok and Pradeep.
You have got copies.
Yes.
Of all the what are the 3 applications? Section 5.
Lordship, one is Section 5, one is a normal stay application, and one is a memorandum of appeal, Lordship. And the
No,
recent-
there are 3
recent-
applications.
Lordship, the recent application that in the midst of pending of this particular appeal, there was some wrongs done by the respondent number 1 and 2, for which I've approached the learned. This is a fresh
We'll
application.
direct you to file all the copies of all the applications on the rest of the respondents.
Lordship.
Since the respondent numbers 1 and 2 are represented through their learned advocate, comma, for the service of copies of the applications are dispensed with on the said respondents, full stop. However, comma, Kolkata municipality was a party in the partition suit.
Kamarhati municipality.
Kamarhati municipality, why?
Lordship, pro
They are
forma
also
response.
stakeholders in the property.
Lordship, it was made by the
Construction, my lord, since issue of construction was there, should not have been made.
The appellant shall serve copies of all the applications on the respondent numbers 3 to 5 and file an affidavit of service to that effect on the next returnable date, full stop. Service on the respondent numbers on pro forma on the respondent number 6 is dispensed with for the present. Full stop. Next para. The applications shall next be listed together for hearing on April 9, 2025. Serve immediately on the rest of the respondents.
Defendant number 1 is the appellant in a suit for partition. My lord, I'm challenging the preliminary decree.
Usual order.
Usual.
First time.
First.
The present appeal arises against a preliminary decree of partition. Push up. Next para. Learned counsel for the appellant shall serve copies. Partition should serve on all. Shall serve copies of the application on the respondent number 1 as well as the pro forma respondent numbers 2 to 6, here also block plan
Yes, my lord, that
2 to 6, indicating that the applications shall be listed next on April 21, 2025, when an affidavit of service to that effect shall be filed by the appellant, full stop. Service on the pro forma respondent number 7 is dispensed with for the present, full stop. Till during pendency of the application, comma, the learned trial judge shall proceed with the we shall continue with the final degree proceedings, but shall not draw up any final decree without prior leave of this court.
grateful.
For the respondent.
Yes.
Well, there was a direction, my lord, for my lord filing my opposition.
Alimony.
My lord.
Alimony
Alimony, and my lord, there was a direction, my lord, for me to, my lord, pay the cost. Done so, my lord.
What cost for filing opposition?
Cost for filing opposition at a belated stage. My lord, only one, my lord, difficulty I am facing, my lord. I have, my lord, prepared, my lord, the affidavit of asset, also, my lord, served upon, my lord, my learned senior.
But
difficulties, my lord, due to the, my lord, the format, my lord, probably, my lord, the affirmation section, my lord, it could not be affirmed, my lord, due to, for the affirmation section could not affirm. My lord, they are, my lord, stating that this is the format of the trial court. This affidavit of asset format. Not I have notarized it. If your lordship, my lord, either accepts it or my lord gives me a leave, I can, my lord, affirm and come back, my lord, with this.
Let us see the format.
There is no, it's a format has been set in the judgment of Rajneesh versus there.
Yep.
That format has been followed.
এনক্লোজার বলে এইভাবে করেছিস? কোথায়?
পার্সোনাল ইনফরমেশন এখান থেকে শুরু।
হ্যাঁ, পার্সোনাল এটাই তো রয়েছে।
এটাই এই ফরম্যাটটি করা।
No. Ultimately, it's affirmed by a verification. It has to be in the you can copy from their format. I mean, it has to be in the form of an affidavit, usual affidavit as you file, like an opposition, and there disclose these charts or whatever. All these will be there, but there has to be the first verification need not be there. No, filed in appropriate format. They are right.
Subject to correction, my lord, I am objecting to filing of that. Kindly see your lordship's order dated 10th March 2025.
What was that?
Yes, kindly see your lordship's.
এটা ফেরত দিয়ে দিন এই copy.
Kindly see, my lord, paragraph 8, my lord.
What was there? Tell us.
Yes, 10th March 2025. Such direction, it is clear, was passed since the husband has been avoiding final disposal of the alimony application. However, for ends of justice and in order to give the husband a final opportunity to file affidavit of
We'll
asset.
impose further costs. What was the cost granted on the last day? 10,000.
My lord, tomorrow I can come back, my lord, with this.
Pay 10,000 more and come back tomorrow.
No, not on the cost, my lord.
Kindly consider, my
Lordship
lord,
had made it, my lord, mandatory, my lord.
Last time.
Yes, extend the time till March 17, 2015.
It is not that they're not filing.
my lord, kindly consider my bona fide, my lord. I have already, my lord.
Not at all bona fide. Kindly see the paragraph 10. In the event the affidavit of assets of the husband or his opposition is not affirmed by March 17, my lord, at least the copy which has been served upon us, it says, it appears that it has been affirmed on March 18. Therefore, lordship's dejection was peremptory.
Yes, my lord. My lord, the difficulty was, my lord, I went to affirm. My lord, it was, my lord, pointed out that it could not be affirmed.
That is
After
their
that,
responsibility.
my lord, kindly consider, my lord, I'm not at fault, my lord, with this, my lord.
And my lord,
previously I was at fault, my lord, I accepted my fault.
and my lord, another
With this,
thing,
my
my
lord,
lord,
I'm not at fault.
there is another direction upon my client to, my lord, come and say to your lordship whether I'm ready and willing to go for a mediation. Yes, my client is ready and willing to go for a mediation.
Subject to alimony.
For the fact when they from the affidavit of assets, for the first time my client, she is devastated after knowing there was an earlier marriage and there is a son from the earlier marriage. And this is a negotiated marriage, not a love marriage.
It has been disclosed in
the
their
affidavit of assets. For the first time, my
son has been shown as an asset.
Son has been as dependent upon the father.
Liability.
Millard, for the first time, Millard, my client has come to know, and Millard, it has Millard for that Millard. Now Millard client can recollect that on the date of marriage, only husband
take
and
it as a reward. This 10,000 cost as a reward, an appreciation of your ingenuity.
My lord, kindly consider, my lord.
It is an appreciation for your client's ingenuity. You have ably wasted so much time for which 10,000 cost was granted and all this. No. Learned counsel for the appellant husband files his affidavit in opposition, which is kept on record. Full stop. However, learned counsel for the appellant husband submits that although the affidavit of assets have been verified as per the format of law, the concerned department of this court has refused to accept such affirmation on the ground that the same is not in appropriate form. Full stop. A perusal by us of the proposed affidavit shows that the same has merely been verified.
My lord, kindly, my lord, is the format, my lord, is verification.
Merely, देखिए, না ভেরিফিকেশন চলে আছে তো বলছি যে রজনীর কাছে নেহাতে যদি ভেরিফিকেশন থাকে তাহলে আমরা এটা করতে পারি দেখে নিচ্ছি। That is the format before the family court, stroke district court, stroke magistrate court. Department is absolutely right. কোনখানটা ছাড়লাম এসব and not affirmed on oath. Full stop. Next para. Learned counsel for the appellant seeks to impress upon us that as per the judgment of Rajneesh versus Neha, reported at 2021, volume 2, SCC 324, the formats as given therein require only a verification to be filed and not an affidavit as such. However, we find from paragraph number 129 of the said judgment, which is cited before us, that the affidavit of disclosure of assets and liabilities annexed as enclosures 1, Roman 1, Roman 2, and Roman 3 of the judgment, as may be applicable, are to be filed by both parties in all maintenance proceedings, including pending proceedings, before the family court, stroke district court, stroke magistrates court concerned, as the case may be, throughout the country. Full stop. As such, it is evident that the said format, as given in the judgment, applies to the court of first instance. Full stop. Although it is beyond doubt that the ingredients specified therein have to be present in the affidavit of assets filed before any court of law, since the format of an affidavit otherwise is different from a trial court in our chartered high court, the affidavit, the department of this court is justified in pointing out that an affidavit in appropriate format has to be filed, therein incorporating the necessary ingredients of the applicable enclosure as given in Rajneesh versus Neha Supra. Full stop. Next para. However, we find that since there was scope of bona fide doubt on such score, although a last chance was given to the husband to file affidavit of asset, we condone the delay in filing the affidavit of asset, since we are of the opinion that there is no malafidez involved on the part of the husband regarding the format, more so since the format is drafted by an advocate and not by the client himself. Full stop. Next para. Accordingly, we grant time, we extend the time for filing of affidavit of asset by the appellant husband till till April 1, 2025, when the application shall next be listed under the same heading. Full stop. An advance copy of the affidavit shall be affidavit, to be affirmed in appropriate format as in the light of the above observations, shall be served on the learned advocate for the respondent wife. Full stop. Keep the ingredients the same because you are already prepared.
Already copy has been served. Ingredients
Only affirmation.
You personally check that,
Yes,
Mr.
yes,
Banerjee.
yes.
You check the format.
Yes.
You settle the draft.
করলেই হয়ে যায়। Confirm করে post এ দিতে হবে।
কোনখানটায়? ওই হয়নি? Yes.
Lordship, for recording of death, can two lordship during pendency of the suit lordship, the defendant number one in the suit lordship died. Though lordship, no recording deleting the name of the defendant number was recorded lordship by the learned trial court. No lordship, in that court lordship, the
Defendant number one had died during pendency of the suit.
and it all their heirs lordship are already on record. Now,
Yes,
lordship,
already on record.
in this regard, lordship, learned trial court lordship, 151 application was filed for recording of the death.
What happened there?
I have just one copy lordship that has been recorded. And for that reason, lordship, the file is showing as defective and the
Oh, name was expunged,
name was
but
expunged.
it is appearing in the decree.
No, lordship, his name was
No, unless it is.
yes, his name was appearing in just decree because lordship, his name was not deleted lordship from the decree.
But this order was passed before passing the decree.
This is before passing the decree.
The decree has to be sent down for correction also. From the office report, we find that the name of the defendant number one in the trial court has not been incorporated in the memorandum of appeal. Whose of next para, learned counsel for the appellant, comma, in support of Can 2 of 2022, comma, which is an application for recording the death of the said defendant, comma, submits that the heirs and legal representatives of the said defendant are already on record. Whose of next para, learned counsel hands over for the perusal of the court the certified copy of an order dated April 20, 2023, passed by the learned trial judge, whereby the name of the said defendant number one was directed to be expunged, which, comma, however, has not gone down in the certified copy of the decree. Whose of next para, accordingly, Can 2 of 2022 is allowed, comma, thereby recording that he is not a party, his heirs are party. Recording that the defendant number one in the trial court has met his demise during pendency of the suit, and since his heirs and legal representatives are already on record in the appeal, comma, no further steps need be taken in that regard. Full stop. There will be no orders to cost. Full stop. The trial court's decree be sent down immediately for the purpose of effecting necessary corrections by expunging the name of the defendant number one pursuant to order number 106 dated April 20, 2023, passed in the said suit, that is title suit number 280 of 2010 by the learned judge, comma, 10th bench, comma, City Civil Court at Calcutta. Any other application?
Other application lordship, injunction application already hard lordship, it has been.
So where will let it go down then? You furnish a photocopy, at least one photocopy of this right now. I mean, immediately after this. উনি ওই অর্ডারের কপি দিলে ওটা ঢুকিয়ে দেবেন। Thank you.
This is an application for injunction.
Your Lordship, I beg to appear on behalf of the respondent number one. My lord, the respondent number one didn't receive any copies of this appeal and not the pending application.
Yes, sir. This is the first time it's.
My lord, no, this was, my lord, admitted, my lord. Initially, injunction order was there, my lord. But since, my lord, checker is involved, my lord, some, my lord, parties, my lord, they, my lord, continued the construction work. And they filed this.
So what about service on respondent number one?
Initially, it was served, but this application has not been served. This is fresh application. After, my lord, the respondents are added, the subsequent purchasers.
You want an extension of the injunction order on?
No, that has been expired, my lord, fresh. Because, my lord, Lordship can have a look to the, my lord, annexure, my lord.
There are three applications, 1, 2, and 5. What are the three applications for?
From the status report, I find that two other applications has been disposed of.
Oh,
Those also, I don't know of. One is for addition of party, that was the
The
last
two
order
others have
that
been disposed of.
But addition of party has been allowed, my lord. They have
allowed
been
on
added as
November.
party.
Which can is that?
That is from the status I could find.
Understood.
We don't know.
My lord, that is my lord, can 1, 2, 3.
1, 2, and 3 all have been allowed.
That is my lord, by the order that you lost, my lord. Apart this order.
Can 1, 2 appear করছে কেন অনিন্দিতা?
4th 11. 4th November 2024.
1 আর 2 তো appear করছে লিস্টে। অর্ডার থাকবে চেক করে দিয়ে নেবে। Very good.
Can
Then we
3,
have
my lord. Can 3 was allowed. Can 3, my lord, addition of party.
you are saying can 1, 2 and
No,
3?
my lord, my lord, record.
Can 1 and 2 are still pending?
Still pending.
What was can 3 and what are can 1 and 2?
Can 2 is my lord, recalling or modifying the earlier interim order. That is my lord, my learned friend's client has filed this application.
My lord, no, my lord, I didn't file any application.
No, the
It
previous
transpires
learned
that
advocate.
learned counsel for the parties are not sure about the about which of the applications appearing today have been disposed of and which are pending. Full stop. Moreover, comma, learned counsel having instruction to appear for the respondent 1, 6 copies of the applications. Full stop. The learned advocate for the appellant is requested to serve copies of all the pending applications on the learned advocate for the respondent number 1 by tomorrow. Full stop. The matter.
The disposed of application, if they can, I can make the copies from them because I need to get the entire picture what has happened prior to me coming before your
Is the
lord.
That they don't have any liability. That you
That
have to take.
request I'm only-
It's a change with my lord. Previously, my lord, the learned advocate appeared, my
Otherwise,
lord.
I have to
That we cannot direct. If he is graceful enough, he can hand over.
or I can.
We can direct only the pending
35
applications. We
copies.
cannot pass orders on.
Not, I understand.
যেটা বললাম সেটা full stop. The matter shall next be listed on April 1, 2025 under the same heading.
My lord, so far, my lord, the injunction order is concerned. Lordship kindly appreciate, my lord.
You come back on that date,
That-
give
but
copies
they
of
are
all the
making
applications.
construction, my lord, I have, my lord, annexed our photograph.
Let them make construction for these 3 days.
But this is joint.
But you please go through the records and ask your learned junior to ascertain which are pending, which are not, which have been disposed of. Please be sure on that and serve copies of the pending applications. And if they appeal to your grace, then also give copies of the disposed of applications. We have not directed you regarding the
No, no, I
disposal.
will, sir.
But you should serve because otherwise he'll be handicapped.
Right.
What is the
I
use
will
of?
serve.
Yes,
I will-
13.
Appear for the appellate, my lord.
Yes, Mr. Vardhan.
This application is one for restoration, my lord, which was dismissed at the order 41 stage.
Deficit court fee has been paid. That is one
My
defect.
lord, we were not aware of the any my lord, defect as regards deficit court fee because when the matter appeared on the date it was dismissed, the cause list does not show this. That I've checked up. My junior has checked up and I've. So now we'll put in the DCF. In any event, my lord, till the appeal is restored, I guess we will not be able to.
No, you have put in the DCF because you are not at fault because
50 rupees.
oh, it's 50 rupees. You have put in that.
No, no, no. We've not put in because this defect did not
Put in
appear.
that, we'll take it up on Monday.
My lord, but the appeal has been dismissed for default, my lord. Till the time is restored, I will not be able to put.
Oh, this is an application for
Yes,
registration?
yes, yes.
Which
Within
section?
time, my lord, 20th of August, it was dismissed, filed on 17th of September.
We don't allow registration applications which have been filed within time. We have grown a habit of taking up only section 5. Unless it's accompanied by a section, it does not appear to be complete. Does not appear to be complete. Anyway, being satisfied with the reasons shown for the absence of the appellant on the relevant date, comma, can 1 of 2024 is allowed, thereby recalling the order dated August 20, 2024, passed in SAT 75 of 2024, and restoring the said appeal to its original file and number. Push up, the appellant shall deposit the deficit court fees of ₹50 during the course of this week. Full stop. The matter shall be listed under the heading. Now order 41 is under the heading order 41 rule 11 on April 1, 2025.
I'm so grateful.
Yes. Please, your lordship. My lord, defendant number 1 is before your lordship, challenging the decree. My lord, there's
Defect is this is section 5. Yes.
Section 5 is that.
So that is the only defect probably. So
Yes, lordship. Lord, section 5 initially, my lord, wrongly an appeal was filed before the district forum.
valuation
Didn't have the yes.
Was it dismissed by the district court?
No, no, no.
How did you come to know according to your application?
application, we have stated that
What is the period of delay?
we had stated, according to us, it was only 24 days. But the department has assessed some, it was 464 days. Lordship, the appeal was preferred before the district court on 25th of April 2022.
That was within 30 days. District court limitation is 30 days.
And the appeal was disposed of on 4/9/2023.
Was the appeal filed?
On 25th of April 2022.
25th of April 22.
Yes, yes.
When was the judgment passed?
4th of September 2020. The judgment was passed on, my lord, judgment was passed on 5th of March 2022. Final decree was passed. The last page of my appeal, memo of appeal, the order is there. The order of 4/9/2023 that is passed in the appeal.
In your application, where have you stated how you learned first that it is?
No, I was contesting that.
You filed the appeal.
Yes,
How did you come to know that it was a wrong code? That
But
is
the
most
order is
crucial.
there. My lord, kindly, my lord, take the memo of appeal, the last page. On 4/9/2023, the order was passed by the learned court below. 4/9/2023. Wherein it
You
has
have to
been
state
stated
that in your application for section 5.
application you have stated.
Where?
Yes.
We are asking you repeatedly that question only. We want to
My
know
lord,
the source of your knowledge regarding it being a wrong filing.
at page 4, your lordship,
Right.
paragraph D, E.
Dispose of the appeal.
On 4/9/2023.
Say that the appeal was disposed of by
Yes.
the judge. On that ground only.
Yes, your lordship, stating that it no pecuniary.
But you have to serve a copy of this application on the other side.
My lord, we served, your lordship. My lord,
There was a direction for service.
No.
Without direction, there is no service unless they appear.
will serve them, your lordship.
The petitioner shall serve copies of both the applications. We can take up together.
Yes, Lord.
The petitioner shall serve copies of the applications of both the applications on this arises from a partition suit.
Yes, lordship.
On the respondents as well as the pro forma respondent number 3, indicating that the applications shall be listed for hearing on April 8, 2025, when an affidavit of service to that effect shall be filed by the applicant.
Obliged, your lordship.
One humble indulgence, my lord. Lordship. One humble indulgence, your lordship, with regard to item number 5, the written notes of argument that I have taken.
That written notes you have
Yes, sir.
paginated? Yes.
Yes.
I am for the applicant
Yes. For the first time.
for the first time.
What is the application for?
For still
Of? What is the suit?
partition suit final decree.
Final decree. What is your ground in the appeal? Base ground. What is the base ground in the appeal? Final degree scope is limited.
On the date of minor final degree, the appellant was not present, my lord.
That is not a ground. You chose not to be present. What can be done?
And my lord,
We have to have a ground. Otherwise, we have to show some prima facie case. Now we are being strict in these stay applications regarding first appeals also because there is no order 41 screening. At least some semblance of a prima facie ground has to be shown. Final decree, it has to be on the defects of the commissioner's report or allocation, primarily. You cannot reopen the shares.
commissioner's report,
What is the defect in the commissioner's report?
my lord, the valuation is decided, my lord, 84, but it is actually not 84. My lord, only land is 1 katas, my lord, 6 chatak, 10 square feet.
The present appeal has been preferred against a final decree of partition, full stop, In view of a prima facie case for hearing of the appeal on merits having been made out, comma, we grant stay of put into execution.
My lord, subsequently possible execution.
Stay of operation of the impugned judgment and decree dated September 5, 2024, as well as all further proceedings in any execution, comma, if levied in terms thereof, comma, till disposal of the application. The petitioner shall serve copies of the application on the opposite parties, indicating that the application shall be listed next on April 21, 2025, when an affidavit of service to that effect shall be filed by the applicant.
Good.
Objection file করার টাইপ কত পেজ ছিল
In Lord, I am for the appellant.
Yes.
Madam Lord, this is the first appeal arising of.
You alone or somebody else who for whom I have to
I'm led by Mr. Orindam Banerjee. My lord,
Thank
who is-
God. Yes.
Now, Lord, I filed a suit where there was a counterclaim. The suit is of the nature that my father executed a registered deed of settlement, wherein, Lord, my mother and 3 brothers, myself one of them, was, Lord, the beneficiary of one of the properties, which is the subject matter of the suit. But the provision was that, Lord, the settler during his lifetime, Lord, he will be the beneficiary, reside in the property. After his death, the wife will reside during her lifetime, and thereafter, Lord, it will devolve upon the 3 sons in the shares that has been described with the deed of settlement.
You are one of the sons.
I am one of the sons and the plaintiff. And Lord, the defendant was, Lord, one of the predeceased sons, Lord, wife, and Lord, the son. Now, Lord, they also took out a counterclaim to say that I have transgressed into the property which has been earmarked in their, Lord, the schedule of the counterclaim and sought for recovery of possession. Now, Lord, it was my case that I wanted, Lord, a declaration to that effect that after, Lord, the demise, or Lord, at that point of time when, Lord, the suit was filed, the father, the settler, was alive as a pro forma and he was arraigned as a pro forma party.
So how did title devolve on you then?
Lord, because of, Lord, the settlement.
No, the
Now the mother and father both are dead.
Achha.
Now, Lord, during the pendency, Lord, in 2004,
Yes.
Lord, the father had died. And thereafter, Lord, subsequently.
No, but it was to devolve on you only upon demise of your mother.
The mother had, Lord, a life estate.
Yes, but the suit was premature then when it was filed.
No, I filed it because, Lord, the provision, Lord, contained that, Lord, that I have a right to reside in the property. The beneficiary.
But you sought a title in that property.
No, I said that I have a right flowing from, Lord, the settlement deed.
Very
But I just showed,
anyway,
Lord,
so that your suit has been dismissed.
My suit has been dismissed, and, Lord, the other side, Lord, counterclaim has been allowed by saying that I am to, Lord, vacate the B schedule property and deliver up possession to
B
them.
schedule was introduced in their counterclaim.
In the counterclaim.
Achha, why was your suit dismissed?
But
Basically,
the learned just says that the prayer has become infructuous as on date because, Lord, on the death of, Lord, both the parties, the property, the trust has come to an end.
Both the parents.
Yes. I'm sorry, both the parents. The trust has come to an end. But therefore, my prayer, Lord, at that point of time, which I sought, has now become.
Apparently, you have a good case because the trust
the other thing
rather
is that,
fructifies after their death.
Lordship. Now, Lord, the question here is, Lord, by virtue of the trust deed, whether, Lord, there has been an effective partition between all the parties or not. This is not the moot question here.
That is also one of the grounds on which.
Lord, that is the Lord, that what I raise here, because the learned just said that I am to deliver possession of, Lord, a particular demarcated portion.
But he did not seek partition in a suit also.
No, it was only for a declaration.
Then you are claiming exclusive title.
I could not have because father was alive. He was arraigned as a pro forma party.
Did you introduce partition later on?
So the case of a, Lord, recovery of possession is a counterclaim case.
No, Mr. Mukherjee, you are seeking your declaration regarding a specific demarcated portion.
No, I say, Lord, in respect of the Schedule A property, that is the entire property.
Oh.
And they say that I need a recovery of possession because of, Lord, the settlement deed speaks of a specific.
All right. Now, what is the you are seeking an injunction here?
Yes, because there is a direction, Lord, that I am to acquit and vacate.
You have filed 2 appeals.
2 appeals, 16 and 17.
So this application is in connection with.
This is, Lord, in where my suit has been dismissed, and the next one is where the counterclaims to allowed. Right. Oh, I'm just the way.
Anyway, just give
the other way.
Reverse, yes. This is 16. 16 and 17 দুটো একসময় বোর্ডে শো করুন 16 FAT 74 is out of time also, that is being shown. এখানে দিন, এখানে।
Can 2, I am told.
Can 2,
17 days delay.
Yes, Mr. Banerjee vehemently opposing the condonation application.
Yes, my lord. With all
They
the,
say 17, but the report says 29.
with all the vehemence at my call.
Very good. Will also come down with a vengeance. Can 2 of 2025. Very
Can
good.
2 of 2020.
Can 2 of 2025 filed in connection with FAT 74 of 2025 is an application for condonation of the delay in preferring the appeal. Full stop. Upon hearing learned counsel for the parties and perusal of the averments made therein, comma, we are satisfied of the sufficiency of reasons shown for the delay. Full stop. Accordingly, can 2 of 2025, comma, filed in connection with FAT 74 of 2025, comma, is allowed on contest, thereby condoning the delay in preferring the said appeal. Full stop. FAT 74 of 2025 is accordingly deemed to stand registered and admitted. Full stop. Can 1 of 2025 now.
Stage, my lord, may I make a humble submission?
Yes.
I have spoken with my client. This is a case, I think, subject to, my lord, what falls from your lordships. Perhaps one sitting with a wise man in between can help solve it. If I am not going to proceed with the execution, your lordship need not take an undertaking from me.
You have two wise men in between your clients.
Now, if this can be sorted out, one.
So, but if you do something in the meantime,
I won't.
You are raising a big wall in front of the bedroom of the plaintiff, and you are asking.
No. That part I think has been. Huh? No, that part has been already, my lord, looked into. That is what I am told. The injunction was vacated subsequently, and then, my lord, the action was taken at that point. It will abide by the result. It has been regularized.
Don't
by
change the
case.
nature character at least.
Decree, my lord, that I am.
No, I'm saying this. I'm saying this. Not any kind of. I'll tell you, lordship.
But I'm not
But
averse
with
to my
great,
learned friends'
No,
suggestion.
obviously.
with great respect, I'm telling you, lordship. Lord,
I need also a
if an injunction, any kind of injunction, will be a very unfair advantage to one party in the settlement mode, not here.
Come back after how much time?
Maybe 2 weeks. Nothing will happen in between. Would your lordship send it for a very quick official mediation? Official mediation.
Cannot say very quick then if you send it for a.
No, I mean, Justice Alok Chakraborty, maybe someone else. ABC.
One of you is a trained mediator, at least one of you. We don't know whether both of you.
Mr.
He knows it cannot, if it say quickly, it cannot be done so quickly.
Then at least 4 weeks. But I'm telling your lordship, the moment there's an injunction along with that, then that person, whoever is protected by that injunction,
So not injunction will grant direct parties to maintain status quo regarding nature and character.
That is
Otherwise
also
it
an injunction
will,
of sorts. I'll tell you, lordship, why.
both by equal to
the
both.
moment he
Article
feels-
14 is not violated. Both sides maintain status quo.
The moment he feels
You have not asked
vulnerable-
for an injunction, we are granting you injunction against them also.
moment he feels vulnerable.
No, Mr. Banerjee. If
I
it's,
think
if the
he is
status quo is changed, the appeal will be rendered infructuous.
No, I will not change the status quo.
Nature character, we will grant nature character. Then we will record that undertaking of yours.
Please give me a sec. Because that will perhaps make the parties sit together eye to eye. Otherwise, it will be angle of inclination or angle of declination.
No, status quo regarding nature character won't give an angle, any angle.
You say, see now what I have done, etc.
No,
My lord
no.
knows.
You ask your client. You are appealing for whom? 1 and 2?
Yes. We our undertaking be? Instead of there being an order of injunction, on the next occasion, if it fails, in the unlikely event it fails.
No, yes. So he is the respondent number 2, the person present in court. Chirodeep Datta, he's Chirodeep Datta. He's Mr. Chirodeep Datta. At the juncture when the application, when Can 1 of 2025 is taken up for hearing, comma, learned senior counsel appearing for the respondent numbers 1 and 2 submits that there is a chance of settlement between the parties and the matter be sent to mediation. Push up. Next para. Upon the specific query of court, comma, on instruction from one of his clients, that is the respondent number 2, comma, who is personally present in court today, comma, Learned senior counsel appearing for the respondents assures the court that the respondents shall not change the nature and character of the suit property during the process of mediation. Full stop. Next.
And also the possession. Because the possession
As
is subject matter of degree.
Possession, I don't know, Milord. No one's
The
going to
subject matter of that.
Nature and character as well as possession of this in respect of the suit property until further orders passed either by the mediation council or this court, whichever is earlier. Full stop. Next para. Learned senior counsel appearing for the appellant, comma, in his usual fairness and on instruction, comma, agrees to such proposal. Full stop. Accordingly, let the matter be sent to the what should be the mediation council, Mr. Mukherjee? What is the mediation council of our court?
But it is High Court Mediation Center. That is where it has.
Very good. Let the matter be sent
High
to the
Court Mediation and Conciliation Committee.
Thank you. Let the matter be sent to the High Court, Calcutta High Court Mediation
and Conciliation
Committee or
Committee.
কমিটিতে তো ওটা সুপারভাইজ করার জন্য আছে কমিটিতে তো জজেরই কমিটি
কোর্ট মিডিয়েশন এন্ড
ওটা সেন্টারে বোধহয় করতে হবে
সেন্টারটা হলো 5 কাউন্সিল হাউস
সে তো জানি
ওটা পড়ছে
কিন্তু কি নমেনক্লেচার আছে দেখো
to the Calcutta High Court Mediation and Conciliation Center for the purpose of exploring options of mediation.
The exact
Yes,
name of
if there is any changes, হ্যাঁ কমিটি তো আমাদের জজেদের কমিটি সেটা ইয়ে করে তাদের কাছে পাঠাবো
Committee, High Court, Calcutta.
Acha, to the mediation and conciliation committee, comma, thank you. High Court at Calcutta. Full stop. Next para. The file be sent immediately to the said council, to the said committee for such purpose. Full stop. It is expected that the committee shall resolve the issue and reach a culmination to the mediation procedure at the earliest, comma, preferably within 6 weeks.
2 months, it generally.
Preferably within 2 months from the date of transmission of the files to the said committee. Full stop. It will be liberty is granted to the parties to mention the matter after the process of mediation is over and to intimate the court as to the outcome of the same.
Great. And there's another complaint about that they are blocking my entrance to the property. They should not block my
nature and character and possession would cover that.
This is incorrect.
They are trying to block the
nature and character. That's why you put that in. Nature and character and possession would cover that. Would cover that.
It's I'm told they are separate. The entries are separate. There's some perhaps some incorrect instructions have come. Anyway, my lords have protected him.
That is not.
None.
এটা আবার জল পেল সেটা হয়ে গেছে অজয় মুখার্জিকে বসে ওই দিনই শেষ করে থ্যাংক ইউ You have not deposited ₹4, Talabana.
Since I am new in this,
and you're wearing a sad look and over and above that. Put in that ₹4 first, then come back. What is the application for?
My lord, it's an application in challenging an order, my lord, by the learned district judge, my lord, by which, my lord, the learned district judge was pleased to dismiss an application for revocation of a probate, my lord, granted by the learned district delegate.
On contest?
On, my lord, it's at the preliminary stage, it has been dismissed.
Why dismissed?
The learned district judge was of the view, my lord, that it is not maintainable.
I mean, why?
It's an error of law, as he described in the order. It's a very cryptic order, my lord, few lines.
But put in there, Talabana.
There is one urgency, if your lordship.
What are you? What is the interim prayer you are asking for?
My lord, I am seeking a stay of the operation of the order of probate, my lord. Because, my lord, there is a
probate is a judgment in rem. We won't. You can ask for injunction. We can consider that.
There is, my lord, a eviction suit hanging over my head, my lord. And your lordship will, if your lordship permits me.
Eviction suit, why?
By virtue of that probate, my lord. It's my brother, my lord. We live in the same family. My brother.
What is the stage of that eviction suit?
My lord, I have received the summons, my lord.
No, we'll pass an injunction restraining both parties from directing the parties to maintain status quo. We can do that or injunct them, but file a proper application. Is there any averment regarding that?
Yes, my lord. The eviction suit is also part of the pleadings, my lord.
Let us see that.
My lord, I'm so grateful.
Or
My
you are
lord,
in threat of.
Eviction suit will be appearing, my lord, at page 63, my lord.
No, in the pleadings.
Pleadings, my lord. My lord,
Anything that you are
my lord, paragraph 14 will be relevant, my lord. Thank you.
You're apprehending this person or something like that.
Yes, my lord.
No, this is something else.
Oh, I'm sorry, my lord. It's 16, my lord. Paragraph 16.
16. Yes. We'll grant you liberty to modify the prayer portion and the.
My lord. So grateful.
The present appeal has been preferred against the dismissal of a proceeding initiated by the appellant for revocation of a probate. Push up next para. Although the present application has been filed with the caption for appropriate order, comma, the same is substantially one seeking stay of operation of the probate granted in favor of the respondents. Full stop next para. However, comma, since a judgment of probate operates in rem, comma, we are not inclined to stay the operation in a blanket fashion of such deemed decree. Full stop. However, comma, we find from the averments made in the application that a sufficient prima facie case for grant of an injunction has been made out, comma, more so, comma, since the appellant is under a threat of eviction pursuant to the probate decree, comma, as an eviction suit has been initiated against the appellant on the strength of such probate. Push up next para. Accordingly, we grant liberty to the learned. You are the advocate on record. We grant liberty to the learned advocate on record to modify the prayer portion. Will do. Modify the prayer portion of the present application by incorporating the prayer for injunction, comma, during the course of the day. Push up next para. The respondents shall remain restrained till disposal of the application, comma, from disturbing the peaceful possession and enjoyment of the subject property and or create any third party interest in the said property, comma, covered by the disputed will. First of the appellant stroke petitioner shall serve copies of the application on the respondents, indicating that the same shall be listed for hearing on April 21, 2025, when an affidavit of service to that effect shall be filed by the appellant. Push up the above order, comma, however, comma, is subject to the appellant curing the defect by depositing the tolobana of ₹4 by March 28, 2025. Do it today, right now. Go out and deposit that from your pocket.
So grateful.
You'll have to deposit 5 because there is no ₹4 now. Or two coins are there.
So grateful, my lord.
Maintainability না, maintainability না। Revocation maintainable question of law। পেপারে হয়তো মানে question of law বলেছে হয়তো কোনো revocation এর দিয়ে এগুলো citation হয়নি বা wrong হয়তো fulfill হচ্ছে। দেখতে হবে। কেন করতে পারবো? সেটা বলেছে এক কথায় allow হয়ে যাবে। Sorry, yes. 19. So order for turn. Let us see the defect first. What was the defect in the first place? Yes. Your part you have done.
This is the judgment of affirmance.
Yes.
But wherein, Lord, that the executant to the gift deed had challenged that she, being a Pardhanashin lady, the gift deed was executed on misrepresentation of execution of a certain other document pertaining to, Lord, the property in question. I am Hashurto. And, Lord, she was instigated by.
She had children.
She didn't have.
Her husband was alive.
Predeceased. And, Lord, the gift deed was executed in the year 1990. It's a registered gift deed.
Right.
Now, my lord, the easiest point first, my lord, because that is my lord, I need not, my lord, take your lordship, my lord, to.
Yes.
Now, my lord, the suit was filed initially in the year 1993. Within 3 years, my lord, from the date of execution, because eventually I'll be taking your lordship to Article 59. Then, my lord, the plaint was, my lord, returned. After return of the plaint in 1993 itself, the plaint was, my lord, refiled in 1999 beyond, my lord, the 3 years period. That your lordship will find from, my lord, the endorsement in the decree which says the date of institution of the suit. Now, my lord, this is a case where the executant comes and says that I am a Pradhanashin, I did not know about the character of the document, and therefore, my lord, the burden shifted upon the defendant, my client.
Why was it returned, Mr. Mukherjee? Valuation.
Pecuniary jurisdiction.
Second.
Pecuniary. But, my lord, she waited for, my lord, 6 years, my lord, for refiling this. But this is one aspect. Your lordship will find that plaint, my lord, page 18 of, my lord, the stay application,
Limitation.
Paragraph 7. My lord, the admission as to, my lord, the knowledge of execution of the deed is not stated because the period of
But if it's a
limitation.
question of misrepresentation,
Yes.
she knew about the. Let us see Article 59 once.
From the date of knowledge.
Yes, but no. 59 is when the facts entitling the plaintiff to have the instrument or decree cancelled become first known.
Very well.
So she only came to know when, yes.
Now kindly come to a statement in the plaint.
Because she knew that she had executed a deed, but she says she thought the deed to be something else.
Lordship. So, my lord, the deed that is sought to be cancelled, my lord, that comes to her knowledge, my lord, according to her in, my lord, 4/10/1993 at paragraph 7, page 18.
No, she learns about the misrepresentation then.
No, then she knows about, my lord, the
Must know about the
তফসিলে বর্ণিত তথাকথিত দানপত্র দলিল.
Very
The
good.
deed, which is the subject matter of
October 1993.
4th October 1993.
Naturally, she filed the suit also in 1993. After
That was not the first suit, but the
yes, the first suit. First suit.
After
No, the first suit could not be filed unless she had knowledge. So therefore,
yes, it was her first suit. I say it was within jolly well within the time.
the question is whether it's a continuation of that suit or return of plaint.
Here
What is
it
the
is a
effect of it?
case of lord refiling after lord 6 years because the date of institution. If your lordship have a look at the decree, lord, the date suit instituted on 1999. I'll show the decree.
And you cannot wait indefinitely. I mean, even
There
if
are
the
other
plaint
points,
is returned.
Lord, because the Pardhanashin lady having executed other sale deeds, but whether she can claim, Lord, the benefit of being a Pardhanashin.
How did the appeal court, the courts below deal with that?
The court
Other
was
deeds?
of the opinion that she is a Pardhanashin lady. As to the
Others were read over and explained.
And read over and explained, Lord, the learned just said that there's nothing, Lord, on record to show that it was read over and explained. And, Lord, so far as my additional evidence concerning other deeds that she had executed, Lord, that was turned down by the first appellate court.
Mr. Mukherjee will come back in 5 minutes and take up the matter. We'll come back in 5 minutes and continue with it. Mr. Mukherjee, plaintiff was returned in 93 itself.
Lordship, Lordship.
What other grounds?
That your Lordship will find not about in the decree at the top, it is stated on the date of institution of the suit, the
1999.
present suit. Then, Lord, the other point is, Lord, there was some, Lord, a judgment of the Supreme Court arising out of this matter concerning, Lord, observation about, Lord, the additional document that I wanted to file. The additional document, Lord, there were certain documents which are already on record to show that, Lord, the executant of the gift deed also executed sale deeds. All the deeds were on commission basis. Registrar came to the house and it was done on commission. I wanted to adduce, Lord, other documents in the nature of one gun license which she applied for being transferred in her name. Other, Lord, the sale deeds that she had executed. And, my Lord, certain other documents which appears at page, my Lord, 72 of my Lord's brief. But that is an application, my Lord, that I had filed.
So this is to dispel the notion that she is Pardhanashin.
Yes.
She applied for a gun license.
Lordship, because, my Lord, she inherited. Her husband had it. Under section 21, Lord, it's required to be deposited under the Arms Act, and thereafter, Lord, on the ground of Lord inheritance, Lord, she can apply for it.
But what would be the effect of the other deeds being executed? Those might have been on commission and read over and explained. Just because
lady, Lord, when she says about, Lord, she loses the character of a Pardhanashin, but she can only take up the character about the misrepresentation if, Lord, she is not aware of the character of the document that she is executing.
Yes.
But, Lord, additionally, if, Lord, a Pardhanashin, Lord, a defense is taken, meaning thereby that she is not worldly wise. So, Lord, the learned judge, the distinction.
That order for 27 was rejected by the appellate.
By this, Lord, the appeal court.
That is another ground.
That is another ground. And, Lord, that was, Lord, without due diligence. As a Supreme Court judgment. Page 46 of, Lord, the stay application is the Supreme Court judgment between the same parties arising out of the same procedure.
Supreme Court said what?
Lord, that is, Lord, the documents, Lord, may be considered by the court. Paragraph 17, Lord.
No, but court does not say anything on that.
Lord, the first, the plaintiff, according to the appellant, was in fact literate. Prior to that, in connection, there is a contention raised by the appellant that the plaintiff has executed a number of documents by way of sale deed. Paragraph 17 about
yes, yes.
It was remanded to the first appeal court. And again here, Lord, as the appeal emanates from the suit of the year 1999, the last paragraph of the Supreme Court judgment.
No, but the new document, the order for 27 was never allowed.
No, it was not allowed. It is on the strength of this, Lord, we took out an application to say it was our.
So after this, you took out the.
Yes. When it was, Lord, after the remand. Because we wanted to produce those documents before the Supreme Court to say that.
So we'll admit on these two grounds.
Lord,
other ground, yes. What?
The Pardhanashin or 29 order 41 tinte ground. But Pardhanashin, whether, Lord, she can at all have the, Lord, the defense as that of a Pardhanashin lady. Order 41 rule 27, whether the court has, Lord, rightly rejected, and, Lord, Article 59. Lord, these are, Lord, my respective summary.
The present second appeal will be heard on the following substantial questions of law. Roman 1. Whether the suit, after its upon its fresh presentation in the year 1999 before the appropriate court was time barred, comma, in view of the limitation period having been exhausted in the year 1993 in terms of Article 59 of the Schedule to the Limitation Act, comma, despite the plaint having been returned in the year 1993 itself. Next, Roman 2, whether the learned first appellate judge erred in law in rejecting the application filed by the appellants under Order 41 Rule 27 of the Code of Civil Procedure without considering the legal effect of clause small b of Order 41 Rule 27 of the Code of Civil Procedure, as well as on the ground of lack of due diligence. Roman 3, whether, comma, in the facts and surrounding circumstances of the case, comma, the learned courts below were justified in applying the cloak of protection available to a Pardanashin lady to the original plaintiff has died in the meantime. She is the respondent.
She's dead.
Which one?
But she is dead. Yes.
To the original plaintiff, namely, what is the name of the?
Gauribala Devi.
Namely, Gauribala Devi. Any application for stay or?
But yes, there is an application.
What is the decree stay of?
The gift deed, my lord, that
Declaration.
The declaration that the gift deeds are, my lord, and recovery of possession.
Will stay the recovery of possession, Mr. Mukherjee, but gift deed, if those are, they will be revalidated and you will be able to deal with the properties on the basis of that. That will be allowing the appeal in that respect.
Kindly stay the recovery.
Definitely, recovery will immediately stay. Can 1 of 2023 is an application for stay of operation of the impugned decree. Full stop. There are two components of the impugned decree, comma by the first comma na the hyphen first comma a declaration that the impugned deeds were void or not binding.
Void. Executant asked for declaration as a deed void.
As void, and the second comma granting eviction against the appellants. Full stop. Insofar as the declaration of the concerned deeds as void is concerned, comma, the grant of stay at this stage might operate to revive the said deeds, which would permit the appellants to act on the same, which might tantamount to adjudicating the appeal itself at a premature stage before it is finally heard. Full stop. However, comma, in view of a strong prima facie case for hearing of the appeal having been made out and the second appeal having already been admitted on substantial questions of law, comma, the appellants have made out a strong case for grant of stay in that regard. Full stop. Accordingly, there shall be execution case has been levied.
The execution has been levied.
Accordingly, there shall be stay of operation of the component of the impugned decree of both the courts, impugned judgments and decrees of both the courts below, whereby eviction has been granted against the appellants, as well as all further proceedings in any connected execution case, comma, if levied on the strength of such decree till disposal of the application. Full stop. Next para. The appellants shall serve copies of the application on the respondents, indicating that the same shall be listed before the appropriate learned single judge having determination, subject to being mentioned by the parties for inclusion in the list before the said bench. Full stop. Next para. An affidavit of service to that effect shall be filed by the appellants before the said bench on the returnable date.
But there's one correction. I should have not. But there's no direct degree for recovery of possession. but my client says that there is an execution pending. But I kindly have a look at, my lord, the decree. At
Just
page
see the
14.
decree, yes.
It is a permanent injunction interfering with the possession. Page 14 of the page 14.
See the decree itself.
But the page 14 of the trial. Execution
Execution. We'll just check up the memo টা কোথায় গেল memo থেকে ডিগ্রিটা পেয়ে যাবো ডিগ্রি অ্যাপিল কোডটা রয়েছে
So, Lord, your lordship will kindly come to Lord, kindly have a look at Lord, in the memo. Lord, internal page
we are still
14.
seeing the memo.
Internal page
We are
14 of
trying
the
to see the decree portion itself.
Yes, ordering portion your lordship kindly sees.
Aforesaid origin deeds say no. Decree and ex parte, it is hereby declared that gift deeds
Avoid. Then
are hereby cancelled. Cancelled and restrained
thereafter,
permanently
Lord,
from
declared that the Gauriwala has a right title interest and possession over the
and permanent injunction stay of that would open up the permanent injunction negative order.
interfering with the possession of the plaintiff in respect of the
So
cost.
if you grant stay of that, then
The plaintiff is no more as of today. She
anyway
has
the heirs inherit their decree.
Yes, and aforesaid.
So if we lift that, that stay of operation will mean that the permanent injunction is lifted. You will be able to disturb the.
Lord, first of all, Lord, I made a wrong statement before your lordship about the recovery of possession based on what he was saying.
The cannot stay will grant you liberty to file an injunction application, Mr. Mukherjee. Is there any averment in the application? Let us check up whether any averment in support of grant of injunction. If you find that, then they're doing something. Maybe execution regarding the permanent injunction, they're disturbing. Maybe execution regarding permanent. That is the only possible execution which can be levied in.
That is, Lord, maybe Lord, they are disturbing, Lord. That's
File an execution case, you have given the number also.
Tabular statement
Title execution case, if that is stayed, you will be able to disturb the position.
Tabular statement একমাত্র column number 11 এ পাবি nature of.
If you stay the execution case, that tantamounts to us permitting you to violate the injunction.
That is. No, what I'm more worried about is, Lord, after the cancellation of the deed of gift, Lord, the plaintiffs, Lord, they inherit the property by intestate.
They can deal with the property.
Where I am not really apprehensive about that.
Deal with the property.
Encumber the property, then that will be.
That is what we are seeing. There is no averment. We file a short application. We'll give you liberty in our order itself.
That is an appropriate order, Lord, in this.
That is only the only appropriate order. এটা কেটে দিন যেটা স্টে অ্যাপ্লিকেশনের উপর বললাম তার আগেরটা যা অ্যাডমিশন হয়েছে can 1 of 2023 is an application for stay of operation of the impugned decree as well as stay of execution case filed in connection with the permanent injunction component of the decree. Push up next para. However, comma, if at this juncture we grant such stay, comma, it would tantamount to allowing the appeal before it is heard on merits, comma, since the execution case has been levied apparently in respect of the permanent injunction, comma, which is in the nature of a prohibitory decree, and as such, comma, lifting the said injunction would tantamount to permitting the appellants to disturb the position of the respondents. Be that as it may, comma, although we find that a prima facie case has been made out, a strong prima facie case has been made out for hearing of the appeal on merits, comma, stay is not the appropriate relief for the appellants. At this juncture, comma, learned senior counsel appearing for the appellants expresses his apprehension on instruction that taking undue advantage of the impugned judgments and decrees, comma, the respondents may try to deal with the property and not encumber the same in favor of third parties. Accordingly, we grant leave to the appellants to file an appropriate injunction application in that regard. If such an application is filed, comma, the same will be considered by the learned single judge having determination independently without being influenced in any manner by any of the observations made by us above.
Agreed.
Can one we are dismissing, can one of 2023 is disposed of in the light of the above objects?
Sir.
Could we direct you to put in requisites and all?
সঞ্জয় কেউ দাঁড়িয়ে ছিল? Create আছে?
No, check up when the injunction is moved, then. Because we can put in directly to put in special message cause for the trial court record.
That we can do. That we can. That
একটা line add করে দেবেন, the appellant shall.
Other directions without the respondent.
Very well. The respondent, the trial court record shall be brought by special messenger at the cost of the appellants to be deposited within a week from date.
Sir.
Which of the appellants shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant.
Agreed.
Item number 20 with 21.
Yes.
For the appellant, my lord, I am led by Mr. Tanmay Mukherjee in this matter.
Section 5, 30 days delay. I don't think I should bother your lordship with that. They can move the.
Who is leading you?
Madam, Mr. Tanmay Mukherjee.
What is the ground of the delay?
On the last occasion, my lord directed us to serve the CAN application as well as the memo of appeal and file the affidavit of service, and that has been done.
CANটা কোথায়? এটা কোথায়? Section 5 কোথায়?
Section 5, your lordship will allow.
CAN 1টা তো stay.
No, I think CAN 1 is the.
দুটো appeal আছে?
Two appeals.
Why two appeals?
I'll tell you, lordship. In the
Degree counterclaim.
Cross appeal. Suit for reasonable eviction on the ground of reasonable requirement.
Your suit.
My suit. Trial court comes to a finding I am entitled to a decree but dismisses the suit on the ground that the suit property has not been appropriately described in the plaint and therefore it is hit by Order 7 Rule 3. Dismisses the suit. I file an appeal. They file a cross appeal against the other findings which go against them.
How can they file a cross appeal?
I don't know, my lord. We had taken this point, but the cross appeal was registered in the court below and a memorandum of cross objection was filed. My appeal succeeded. Their cross objection was dismissed.
One appeal would suffice. Anyway.
But so far as the grounds for eviction, my lord, concurrent findings of fact, so far as reasonable requirement is concerned.
They will allow the section 5 right now and then keep it whenever.
Keep it whenever it is convenient for Mr. Mukherjee. I am a.
It can 1 of 2024. Upon hearing learned counsel for the parties, we are satisfied of the sufficiency of the reasons for the delay in preferring the appeal. Accordingly, can 1 of 2024 is allowed, thereby condoning the delay in preferring SAT 145 of 2024. Pushar, let the appeals be placed under the heading, under the same heading. No, the appeals are, the appeals shall next be listed under the same heading on April 1, 2025 or March 31, 2025? March 31st,
March 31st, my lord, I don't.
Oh, April 1, 2025.
If there is an application for stay, that may be served on us because the execution has been levied. Police help is going.
Not direct that. That will tantamount. That will be constituted as admitting the appeal. If they give a copy, give a copy.
Very.
You can write a letter to them asking for a copy.
Very.
Write a letter and get the copy by the end of this week.
If your lordship admits stay will be automatic, it will only be question.
If we direct him to serve a copy of stay,
No.
and if he lose determination after that, when it goes to some other bench, the first argument will be it has been
If
admitted.
your lordship ultimately admits the appeal, the question would only be of
Occupation
fixing the
charge.
occupation charge.
Occupation charge. That's why you require a copy of that.
Get.
Number 22.
Yes.
22 pursuant to my lord's direction.
Service. Good service.
Yes.
Appearing.
Lordship, I am for the respondent. Lordship, I am led by Mr. Parthasarathi Das. Lordship, one thing, Lordship.
Yes.
Mr. Oshim Bisha should be made a party.
Who is he?
Lordship, the entire property
Huh.
sold to him while the partition suit
My lord,
was going on.
Let her complete then, yes.
While
Yes.
the partition suit was going on through a gift deed to Mr. Shamul Ocean Vishwas, and then
Partition suit was filed by whom? Them or you?
partition suit was filed by me.
Yes.
Then we saw that the partition suit, while the partition suit was going on, there was a gift deed from
By
gift
you?
no,
Them?
by the defendants to Ocean Vishwas, Mr. Ocean Vishwas.
Then the Ocean Vishwas was not added as a party?
He
Why?
is not a party in this.
Where do we get that it was sold and gifted?
From the last order number 44.
Where do we get that? In which application?
Last second. Lordship, third last page.
Of the stay application?
No,
Of what? That is your own copy.
no, that is their copy.
What? Where do we get that?
23.
23, yes. 23 of what? Stay.
Stay.
That is the beginning of the plaint.
Yes. Post title, my lord will find Ocean Vishwas.
Oh, Ocean Vishwas was there.
Yes.
So he has not been implemented yet. Why?
Lord, I am coming.
Huh?
This is no. This I have challenged the order passed in title suit 147. This is title suit 33 of 2023.
Why have you annexed that?
Yes. I'm coming. He started there.
Yes, come.
My lord, there is a delay of 67 days.
No. Before condoning the delay, we have to see whether it's bad for non-joiner of parties.
My lord, they filed a title suit, partition suit. In the partition suit, they made an application under Order 22, Rule 10, impleading the assignee as a party and expunging my name.
Acha.
That was allowed. In the written objection, we stated that we have filed a suit, PS 33, 2003, 23, wherein we have stated in the suit, the injunction application has been passed.
The suit was for? Your suit was for?
For declaration, the deed void on
Those deeds are void. Acha, very good.
representation.
Ah.
In that suit, 33, court passed an order. That order is at page 33. My lord, kindly have a look. And one.
So this present challenge is in respect of the partition suit or your suit?
Partition. Order 22.
Your suit is still pending.
Yes, both are pending.
Both are pending.
This is against what?
Which one?
This present appeal?
Presentable partition suit.
Both are pending, you say? Preliminary?
No. This for.
We ask you whether this is against your from the partition suit or your suit. You said both are pending.
Pending.
So how can there be a first appeal then?
Order 22, Rule 10.
It should be a first miscellaneous appeal then.
First miscellaneous appeal, it is.
FAT number has been given here?
No, thereafter it was changed.
Oh, see there. So this. Let us see the impugned order first. To ascertain only whether they are necessary party.
This is at page 21.
Very well. So you are challenging the order whereby Oshim was added and you are deleted.
And mine and deleted.
Then Oshim need not be a necessary party. If they win this appeal, then Oshim won't come in. Section 5, what is the ground of the delay? What is the delay, first of all?
The revision was filed, thereafter it took some time.
What do you say? Section 5. Very well. The ground taken in Can 2 of 2024, an application for condonation of the delay in filing the appeal, is that by due to bona fide error, a revisional application was filed against the impugned order, whereby an application under Order 22, Rule 10 of the Code of Civil Procedure was allowed. First of next para, upon detection of the fact that an appeal lies, the present appeal has been preferred. First of upon hearing learned counsel for the parties, we are satisfied as to sufficiency of the explanation given for such delay as indicated above, since there might have been a bona fide misconception in that regard. First of next para, Accordingly, can 2 of 2024 is allowed, comma, thereby condoning the delay in preferring FMET number 240 of 2024. Full stop, there will be no order as to cost. Now, what is the ground in the appeal? We take it up for hearing under order 4111. শুনে নি তারপরে এই পোর্শনটা পড়ে দিচ্ছি। Yes.
My lord, kindly come to page 33. That is injunction order passing, title 23, 33 of 23. Page 33 is the order.
Yes, 33.
From the above, it reveals that plaintiff, being an aged person, filed the instant suit for cancelling one gift deed and one sale deed, allegedly executed by misrepresentation. Though the defendant number 1 categorically denied factum of misrepresentation, but surprisingly kept mum about the allegation of non-payment of consideration money of sale deed in respect of Schedule B property executed by plaintiff in favor of defendant number 1. Consideration money is one of the key ingredients for a valid sale, and silence on part of defendant number 1 somehow established the prima facie case of the plaintiff. Considering the principle of prima facie case, irreparable loss, injury, convenience.
The prima facie it has been held in your favor.
My lord.
And the documents
expensed my name.
Documents themselves are sub judice. At least you could have been retained along with Oshim.
Yes, that's my case. Because earlier they.
Ma'am, take instruction. If you agree, we can dispose of the appeal. We are telling you why. Because the transactions by them in favor of Oshim is in doubt, in at least sub judice before a court. Prima facie view has been taken, although this is not a final view. Prima facie view is there, it's sub judice, that remains. So expunging them would altogether, that would tantamount to pre-deciding that suit also. So we'll modify the order, we'll add Oshim, but keep them also.
Yes.
So if you agree to that right now, we can dispose of the appeal itself.
Can I take instruction, Lordship?
Take instruction. We are admitting the appeal and granting stay, but we are keeping in. No. Let her take instruction. Let her take instruction.
Because in earlier occasion, she was driven out of her house by the order of the court and police. They restored the possession because during pendency, even if the injunction order.
Anyway, I mean, the appeal is taken up for hearing under order 41 rule 11 of the Code of Civil Procedure. Full stop. Next para. Learned counsel for the appellant argues that the impugned order, comma, expunging the name of the appellant and impleading alleged transferees of the appellant was passed on the premise of certain transfer deeds which are themselves under challenge in a separate suit filed by the appellant. Full stop. While granting temporary injunction in favor of the appellant in the said suit bearing title suit number 33 of 2023 pending before the learned civil judge junior division second court at Ranaghat, comma, the learned trial judge held in favor of the plaintiff stroke present appellant having a prima facie case, comma, inter alia on the ground that the payment of consideration money for the alleged sale is one of the key ingredients and could not be established. Full stop. Next para. As such, comma, there is sufficient doubt as to whether the plaintiff stroke appellant could be expunged at this juncture, comma, in view of the veracity of the sale deeds being in question, transfer deeds being in question in a different suit, comma, which gives rise to an arguable issue in the appeal. So accordingly, the appeal is admitted and shall be heard on the above question and the other grounds taken in the memorandum of appeal. So next para. At this juncture, comma, we find that the scope of the appeal is limited, is extremely limited, and the relevant papers are annexed to the stay application filed in connection with the appeal. Full stop. As such, comma, a query is put to the learned advocate appearing for the respondent as to whether the respondent would be agreeable to final disposal of the appeal along with the application without calling for the records and without preparation of formal paper books. Full stop next para, learned counsel for the respondent seeks an accommodation to take instructions on such count. Full stop accordingly, let the matter stand adjourned till April 1, 2025, when the matter shall be listed under the same heading, with the understanding that the appeal may be taken up for hearing along with the application. We are giving you this option because you can impress upon your client. Otherwise, if you grant a stay, the entire thing will be stayed. Your suit will be stayed. The operation of the order will be stayed. She'll have to wait for we don't know how many years. Impress this upon your whenever it will become then indefinite when the appeal will be heard of. If it once it is admitted and goes to our vault, then we don't know when it will be decided. Agree to this.
My lord, one more where on the last occasion, names of the advocate are wrongly recorded.
Write in the slips legibly, it will not be wrong. Yes. Yes, Mr. Gupta. You are not there on the last occasion, the matter could not be taken up. And your learned friend waited for so long and just because of you,
I had informed him.
you have to treat him to a cup of coffee at least somewhere.
It has to be more than that.
The cheapest cost possible coffee which is available around, treat him to that.
Yeah, that is peanuts for him.
Yes, we want him to be treated to peanuts only. Yes, Mr. Gupta, what is the case? FMAT against what?
Yes, the appeal arises out of an order by which an Order 39 Rule 1 and 2 application has been disposed of finally, granting a status quo. My lord,
Your suit is for?
Their
suit is for? Sorry.
Their suit is for declaration that we.
The rest of you, please take your seats.
Their suit is for.
Yes.
Their suit is for declaration that we do not have any right to disturb their possession, and my lord, it's really suit for injunction, but there are prayers for declaration also. My lord, initially what happened was, my lord, when the Order 39 Rule 1 and 2 application was filed, we had appeared. But on the day when the application was finally taken up for hearing, my lord, my advocate on record was stuck in a matter in before this honorable court and couldn't be there. So, my lord, without the written objection being filed, the application was disposed of finally. Now, your lordship would find
that was the only opportunity given to you, or you had previous opportunity?
No, there was one previous opportunity, and this one we couldn't avail of. So, my lord, we were really not aggrieved by the order in the sense that we were not minded to disturb them anyways without any due process of law. So we had not challenged the order immediately. And there's a section 5 and why there's section 5 and I'll tell you lordship why. My lord, thereafter they serve with a notice for contempt and they file an Order 39 Rule 2A application. That is when, my lord, my clients came and, my lord, we discovered that in the suit, in the schedule, the entire property was put in, whereas they were occupying only one shop room. So, insofar as plaintiff's shop room is concerned, we do not have any problem that they should not be disturbed. We do not join issues. But in the schedule,
you had a copy of the plaint all along. This cannot be an explanation.
But we really didn't want to disturb their possession without
respect of the suit property.
Yes, that but what they are doing now is
injunction was granted in respect of the entire suit property. You knew from the beginning.
Yes. So injunction.
What is the number of days of delay?
5 days.
3.5 months odd. Well, what had happened was, may I just indicate?
Praying for affidavits, Lord. Because
yes, may I indicate?
Mr. Gupta, this is not a proper explanation. You knew all along whenever you.
Why I am aggrieved by the order?
Copy of the plaint and.
May I indicate? I am putting a signboard outside my shop room. This is why they are saying that I have acted in violation of the order.
They claim that they're in possession of the entire, all the shop rooms.
No.
That is the premise on which injunction was granted.
There's no claim as such.
The suit is the claim. The plaint is the claim.
Kindly see the pleadings and the schedule.
Show that.
If your lordship kindly takes a look at.
Yes.
Paragraph, may I place from the plaint?
Yes, yes.
If your lordship kindly takes a look at page 15. But this would be can 2 from the stay petition, page 15. Now, there are 3 applications. One is a section 5, one is a stay, one is a order 41 rule 27, because we want to rely upon certain documents. We couldn't file the written objection, so we filed.
Yes.
But if your lordship kindly looks at the plaint once,
yes,
that is at page 15, your lordship would find it's a suit for declaration and permanent injunction. But here, the plaintiff proceeds that the plaintiff was running a partnership, proprietorship firm under the name of Svelte. Thereafter, if your lordship kindly sees,
paragraph 3 that he was carrying on business. Then paragraph 6, if your lordship kindly sees, that the plaintiff is occupying the ground floor and carrying on the business as well.
Details were referred in the schedule.
Yes. Now this schedule includes the entire property and not his shop room.
Yes, so you knew that from getting a copy of the plaint.
So we were
all that piece and parcel of commercial space situated on the ground floor,
but
entire ground floor.
Yes, but
you knew from the inception
plaintiff
it was
is
your
not
shop room.
occupying the entire ground floor. Plaintiff is occupying one shop room.
That is your case, Mr. Gupta. But you knew on the date of the
The
injunction that
plaintiff's document also doesn't prove anything contrary.
we cannot
but-
go into that question. We are only on the question of delay now. You say that you were under a wrong impression that your shop room was not covered. But the plaint itself, all the allegations are regarding.
I was not
aggrieved
by the order because I didn't want to disturb them. But when I am doing something in my
You
shop,
didn't to want to disturb them regarding the entire schedule property. It has to be.
but
Because the entire schedule, the
my
ground floor is in the
occupation is different. Where I am doing something, this is their
If that is your case, you would be aggrieved.
Yes.
From the inception.
Now why?
What change occurred subsequently? How did it dawn upon you that your shop room was also included? It's there for.
It's there in the schedule.
There in the schedule in plain sight. I mean, the injunction
Yes,
was
but
obtained
if your
regarding the
lordship
entire
kindly
schedule.
sees their
There is a
injunction
qualification.
application, if your lordship kindly sees their
There is no
injunction.
qualification that only regarding one room I am asking of this such and such.
Yes, my lord, if your lordship kindly sees the prayers in the injunction application, where your
Yes.
lordship would find at page 32.
32 yes. Suit premises, suit building. Entire thing is regarding suit building. Peaceful possession regarding suit building. That has been granted.
So that is why, my lord, we have
suit building encompasses your shop room also, the entire ground floor.
the entire ground floor. But
So you knew from the inception, how could that be a ground of your section 5? Because the length of delay is not important, but the ground is.
but my ground, if your lordship kindly
All of a
sees the-
sudden, you cannot wake up and say, no, my shop room is also covered. You knew that from the inception. You got two opportunities to file written objection.
Yes.
From service of the plaint and the injunction, you knew the suit property.
But what we had thought of, my lord, that we are not, since we are not disturbing, so we had not assailed that.
That not disturbing has to cover your shop room also then.
But I am not. I am putting a signboard. They are relying upon the injunction order, saying that I cannot put my sign.
There is no ground for the delay in preferring the appeal. You are aggrieved, whatever you are aggrieved with, you are aggrieved from the inception. Because you had a copy of the plaint, the injunction application, you had two opportunities to file objection, you did not avail of the same. And all along you knew about the suit property covering the entire ground floor.
If your lordship kindly sees the order, which is the impugned order.
Impugned order, yes.
Yes. Kindly sees the memo of appeal. There is a direction to maintain status quo
regarding the
with
suit
regards to
property.
possession, nature, and character of the suit premises.
So where is the question of your having a misapprehension that it does not cover your shop room, which is also on the ground floor?
No, their cause of action was that I am disturbing their possession, so I should not be disturbing their possession.
Possession
That
is not
their
an
clearance.
unqualified statement. Possession has to be in respect of something.
So lordship
Their
kindly
possession
sees
is in their allegation in the plaint, in the injunction application is you are disturbing their possession in respect of the suit property. Suit property is found in the schedule as well as referred to in paragraph 6, and paragraph 6 refers back to schedule. So it's very clear from the inception when you got a copy of the plaint, you saw the suit property covering your shop room as well.
entirety. I'm covering the
Entirety means your shop room, as per your allegation, your shop room also. You got two opportunities to file written objection, you did not file. So order was passed ex parte. You wait for 3.5 months or 110 days, whatever, and now come up with a section 5 application saying that I was under the impression that my shop room was not covered, my position would not be disturbed, and that I did not want to disturb their position. If you say that you did not want to disturb their position regarding the suit property, scheduled premises, then you don't have a cause of action even now.
I carry.
So there is no question of any.
I carry a business from a different shop.
There is no ground for the condonation of the delay.
But I carry business from a different shop room. He carries business from a different shop room. But I am
That's
putting.
your case. We are not even bothered with that because there is no written objection also as on today. Even if there was a written objection, if that was your case, injunction was granted. We are only on the section 5. Injunction was granted. Status quo was granted on the first day. Status quo. If that be your premise, then you are not aggrieved even today. Where is the cause of action for filing the appeal then? You are not aggrieved with the status quo.
But I am aggrieved by the status quo.
If you are aggrieved, you are aggrieved from the first day when the order was passed.
But
it was passed in your presence.
No.
But you came to know, is there any averment?
I came to know. It's not that I'm feigning ignorance of that.
Then
The
there's
problem is
nothing in
my
between.
clients were under the impression that since they are not disturbing their possession, so really this doesn't bother us. So they didn't prefer an appeal. The problem started when they received the contempt notice, when we were trying to put our signboard in our shop. This is when they saw they saw the order, and then they saw the entire fallacies and how the entire thing has been embroiled.
You see, we are under the impression that status quo means whoever is in possession.
Whoever is in possession, I'm not disturbing his, he is not disturbing mine. So we were okay with it. We were not.
Then this appeal becomes something else. It becomes a defense to the order 3902A. Whether we should give a premium to that. It's like filing an appeal against the parent order after filing of the contempt application. Precisely that, in fact.
But it is that.
It is that.
It is that. I cannot shy away from that.
Then it's not a bona fide section 5 then. One of the grounds of rejection is malafide.
Section 5 pleadings once, because I was initially not really aggrieved, because I thought he is there, I am there, no problem. But now when in my possession something is when I'm doing something, they are now trying to oppose on the strength of the status quo order. And the status quo without, there is no ascertainment of status that who is in which possession.
Yes, Mr. Ghosh, where is the scope of filing? What would you disclose in an opposition?
Well, because the grounds are absolutely not read for the section 5. There's no explanation. And Lordship, with regards to status quo,
that you can argue verbally also.
Well,
they will record that.
Lordship kindly see section 5, paragraph 11. He's saying he's not disturbing anything. It's his own averment that he's putting padlocks.
That's a different player, not his shop.
No. Mr. Gupta's argument, if you understood him correctly, yes, the best argument he has is that a status quo order was ultimately passed, not enumerated in the order that who is in possession.
Right.
So as we constitute status quo orders, usually whoever is in possession. So they became aware, they became aggrieved. Right. The aggrieved part comes in only when you take out this contempt application. Yes. So that is a justified ground for section 5 at least.
Not justified ground for section 5.
Why not?
Well, because condemnation of delay, if your Lordship kindly considers this, delay has to be explained on the basis of the understanding of the order on the day when the order was passed.
Yes, there is sufficient, scope of doubt as to this order being misconstrued as status quo. Parties are directed to status quo without saying that you are in possession of the entire property.
Lordship,
all it was passed on your basis of your averment.
Yes, and Lordship will kindly see paragraph 10 of the plaint, which is part of the stay petition.
No, plaint says that you are in possession. Your application was there, but the order does not record anywhere. But yes, order records since the defendant respondent is trying to obstruct the business of the plaintiff.
And he also admits that he is obstructing.
Trying to obstruct him by value. And at the ad interim stage, you took out the 39(2)(a).
No, my lord, this is 39(2)(a) subsequently. My lordship, this is, I'll just indicate 19th August. Whereas, my lord.
And in the impugn order, it is said that he is bound to file a miscase.
Yes, my lord, lordship will kindly see 206 for hearing of the injunction petition, W if any in the meantime.
Mr. Gupta, there was no scope of any doubt in your mind. This is just see the impugned order.
Yes, sir.
Advocate for the plaintiff petitioner has stated that a proposal is immediate leave it. In spite of having restraint order, defendant is trying to dispose. Conduct of defendant is not satisfactory.
Yes. So your lordship would see the entire
plaintiff is doing the business peacefully while the.
Yes, so your lordship would see the entire premise of the impugned order is I am disturbing his possession.
That has to be read in context of his application.
Yes,
the application says that he is in occupation of the property. There is no whisper anywhere because there was no written objection from you. No whisper anywhere that.
Lordship sees the entire premise, and your lordship would see the urgency.
Status quo has to be constituted in the context of the application.
Urgency pleading also in the 39(1) and 2) application that they are saying I am disturbing their possession. So since I was not, so we were not really aggrieved.
You cannot say, you cannot be an ostrich. I was not, I think that I am not disturbing, so I think that there will be no. Obviously, the next day, if you try to disturb their possession in respect of the entire suit property, that is not a sufficient ground in the section.
He is saying he is carrying on business. He has given the name of the business. That business is from one shop group.
Your sole
It's from a
sole premise for the delay, for explanation of the delay, is that what you said, that you were under an impression that this would not affect you. You were not aggrieved by it.
I was
That
under the
position
impression that the
cannot
status quo
change.
order is passed. So
See,
he is there in his position. I am there in my. I'm not disturbing him.
there is no scope of such misconstruction because the interim order, there was an ad interim order prevailing all along on the basis of their injunction application. Fine, the impugned order has been passed on the basis of their injunction application only, without there being any objection. So it has to be status quo as regards position, nature, character has to be read in the context of the suit property. There was no scope for your misconstruing it. And if there was your any scope for misconstruing, it should have been there from the first day. I mean, that the position did not change by their filing to order 13.2a.
No, I am not saying that the
Status quo was passed in respect of the entire property.
So I am also in possession of the entire property, in part of the property. He is there in
That was
possession.
not the finding of the court anywhere.
That is not the finding of the court.
Court passed order only on the premise of their averment made in the injunction application on that premise. Therefore, this order has to be read in the context of their application. Court passes, both of you are directed to maintain status quo as regards possession, nature, and character of the suit premises. Suit premises was the entire property. So both of you would maintain means obviously means that they would not also change the nature character of the suit
So
property.
my documents had not got in. So I had not.
Section 5, there is no ground.
If your lordship kindly permits me once, but if your lordship kindly takes my section 5 application once.
Yes, yes.
But kindly cease from.
We have another bench, Mr. I have another bench with Justice Bishas, Procedural Bishas. So we'll continue after 2, this matter. Even if you have any other matter, we'll continue after 2. এটা থাক, মানে এটা দিয়ে শুরু করবো দুটোর সময়। Right.
Well, I'm for the contempt.
You have come personally, yes.
I have received, my lord.
Yes.
There have some question of
Hello,
my lord, confusion regarding, my lord, on the part of state authority, my lord. That must be clear, my lord. You should kindly come to my page 16, my lord. That is their amendment, my lord. I state that Deputy Secretary Inspector General by
You are for the alleged contempt, na?
Yes.
No, I am for the
contempt.
Oh, you are for the petition.
I am the petitioner.
Yes. Where is that? Page?
Page 8, para 16, my lord.
The contempt of the
Deputy
contempt
Secretary-
application.
Yes, my lord.
This is
No,
the,
my lord. The affidavit I have filed, my lord. The report.
Oh,
purpose of non-compliance.
para 16,
Page
yes.
8, para 16, my lord.
Right.
Deputy Secretary to the Government of West Bengal Home Hill Department Police established branches which is still pending for approval. Next paragraph, that vide memo number 25th of February 2025, the Special Commissioner to the Government of West Bengal raised certain difficulties in complying the Honorable Court's order dated 30th of July 2024, suggested to file review petition towards modification of the Solomon Order 13 to the extent that the family pension benefit shall be paid solely present petitioner. The same cannot be equally shared between the present petitioner and the children of the second wife. The question is that, my lord, I am the first wife, my lord. First wife is entitled to get all the pension is concerned, my lord. Other benefit may be distributed to the second wife and other their successor, my lord. That may be, my lord, clarified your lordship order. That is the confusion on the part of state authority, my lord, that I reflected that para 17 and 18, my lord. The lordship kindly come to, my lord, your lordship order, my lord. The main petition. The contempt petition, my lord, that is page 19, my lord.
Authority's stand is that it has to be distributed to the second wife's children also.
No,
No,
The other
that
way
is
around.
omitted, my lord. That is not clarified by your lordship order. That is the problem.
Oh.
Is, my lord.
My lord has passed an order directing the authorities to pay equally between the petitioner and the children of the second wife. Now, problem is that, my lord, the children of the second wife are above 25 years, my lord.
No,
And we are.
Did you file a review application?
No, my lord.
Did you challenge the order?
It was suggested by the authority that you file a review.
But that order remains then.
So
This
the-
order remains. You have to comply
Yes,
with
my
this.
lord. Now, the problem is that, my lord, we are stuck with this. If my lord comes to page 32 of my affidavit, page 32, my lord. No, it will be, my lord, page
27.
memo touch.
Page 27.
Yes, my lord. Page 25, my lord.
Yes.
The authorities are struck by this order, the government order, which says that if the children are above the age of 25 years, family pension cannot be granted unless and until there are some special grounds which are enumerated at page 27, my lord.
But why were these not placed at the time when you passed the order? This circular was not placed before us.
My lord, at that time, my lord, we were not known that they are they have attained the age of 25 years. Much prior to this application, my lord. After inquiring, my lord, when we are going to give the family pension to the children, we came to know that they have already attained. Now they are 39, one is 40, one is 43.
There are some exceptions also, my lord. You should kindly come to my lord, next one memorandum, my lord.
Which page?
Page 27.
That's the 27.
Yes. They do not fall under these exceptions. So if the earlier order is modified to
No,
a
suffering
extent-
from any disorder or disability or physically crippled
Yes,
or
ma'am.
disabled. They are not disabled.
No, ma'am.
No question of my lord, pension, family pension as far as.
If the
Second-
earlier order is modified to the extent that only the first wife is entitled, as because, my lord,
No, the second wife is still there.
second wife is still there, my lord. At the time of retirement, my lord.
You will get it as per our order.
Yes, my lord. At the time of retirement, from the time of death, my lord, the second wife and the children of the second wife have enjoyed all the retirement benefit. They have enjoyed all the retirement benefit because they were staying with the deceased.
No, our order was very clear as far as the petitioner is concerned. We disposed it off without interfering with the impugned order, but by directing petitioner to furnish documents. They were to furnish documents
Yes, ma'am.
before respondent. Upon furnishing of such documents, our direction was limited to this. The respondent authorities shall ensure that the share of the petitioner in the pensionary benefits on the demise of her husband be disbursed in her favor at the earliest. It is reiterated that nothing in this order shall prevent the disbursing authorities also to disburse the share of the children of the late employee from his second marriage in their favor as well. So we did not direct you to pay to the children of the employees. We said that we directed you to pay only to her share. If according to you, her share is 100%, pay that to her. I mean, we said that this does not prevent you from disbursing shares of children to the late
Nothing has
employee.
been paid, my lord. As
Yes,
far as first
if-
wife is concerned.
We did not direct you to pay to the second wife or her children. No. The order is very clear.
Yes, ma'am.
We only made it clear because the second wife and her children were not there, not present. We directed that you have to immediately disburse her share of the pensionary benefits, and that nothing in this order shall prevent you from disbursing shares of children of late employee, if there is any. If the share of the second wife and other children are nil, then don't give it to them, but you have to pay her share. That was the direction. If her share is 100%, pay it to her.
My lord, if my lord comes to the order, page 4.
Page 4.
Paragraph 11, my lord.
Right.
This was coming to the hurdles of the authority.
Acha. Oh, shared between the present petition.
That may be clarified.
We can clarify that this order, if they are otherwise entered, এই জায়গাটা এর মধ্যে এটুকুন ঢুকে দিলে হয়, কারণ আমরা তো এন্টাইটলমেন্ট কনসিডারই করি না। আমরা এটা কি কনস্ট্রাক্ট করছি, আমরা অর্ডার তো মডিফাই কন্টেম্পট করতে পারবো না। আমরা
ঠিকই আছে।
হ্যাঁ, অনেক ঠিক আছে। We are interpreting this order. We are saying that if they are otherwise entitled, the meaning of this was so that you can disburse it.
And direction be given upon the deputy secretary. Last time I submitted that it is pending before the
This is a
deputy
long
secretary,
pending
my lord.
case, my lord. So, my lord,
So If
Deputy
the
Secretary
direction
is-
is directly given to the deputy secretary, it can be expedited, my lord. Everything is ready, my lord. Only the approval is needed.
Deputy Secretary is not a party here. How can you direct him?
My lord, that's why my lord has asked me to file this affidavit so that the
Oh.
direction will be
After filing affidavit, that
my lord comes to order dated 26th of February
Deputy
2025.
Secretary will do that. The affidavit filed to be kept on record, which discloses that although other steps have been taken for disbursal of the pension in favor of the petitioner, comma, an approval is awaited from the Deputy Secretary to the Government of West Bengal, comma, Home and Hill Affairs Department, comma, Police Establishment Branch, comma, Nabanno, comma, Howrah, full stop. Next para. Another sticking point, which is pointed out before this court by learned counsel for the alleged contemner, is that in paragraph number 11 of the order under contempt dated July 30, 2024, passed in WPST 4 of 2024, comma, we had expressed the opinion that there cannot be any impediment in disbursing the share of the children of the deceased employee, comma, even if from an illegitimate marriage, comma, in their favor, and accordingly the pensionary benefits have to be shared between the present petitioner within bracket first wife bracket closed and the children of the deceased employee from the second marriage. Full stop. As such, comma, it is submitted before us that the alleged contemner was in a dilemma as to whether to pay shares of the pension to the children of the deceased employee from the second marriage, comma, in view of certain government circulars. Full stop. In particular, comma, a memorandum dated June 18, 1991, bearing number 1097 hyphen capital F within bracket capital P small en pen within bracket is referred to, which provides that the governor, comma, after careful consideration has been pleased to decide that in both cases, that is, where a minor son is entitled to receive family pension up to the age of 18 and a minor daughter up to the age of 21 or till her marriage, comma, whichever is earlier, comma, the age limit will be raised to 25 years. Full stop. Next para. Learned counsel also places reliance on other memoranda of the government, comma, particularly the memorandum dated March 3, 2008, within bracket memo number 138-F within bracket pen bracket closed, comma, which provides certain exceptions to the upper age limit. Which of it is submitted that the but the second wife gets in any event. There is no bar to the second wife. This is regarding the
not getting any pension, as per law, malad. Only malad child, second wife child only.
Achha.
That is exceptional cases, malad.
The okay,
as per Hindu marriage act.
It is submitted that the exceptions incorporated in the memorandum dated March 3, 2008 are not applicable to the children of the second wife. But we had decided finally that the second wife will also get.
Second wife, as per law, malad.
As per law, you cannot argue. You have to challenge our order in appeal.
Second wife pension benefit already given to the second wife, malad. Only pension, malad, monthly pension, malad.
My lord, the second wife has received everything, my lord.
Yes, my lord. That is
Our direction, our observation was also that have to be shared between present petitioner and the children of the.
Yes, yes.
Well, but next para. However, comma, on a complete reading of our order dated July 30, 2024, comma, we find that in the ordering portion thereof, comma, we had merely directed that, comma, subject to the petitioner furnishing the documents as referred to in paragraph number 12 of our order, comma, the respondent authorities shall ensure that the share of the petitioner in the pensionary benefits on the demise of her late husband Suresh Chandra Roy be disbursed in her favor at the earliest. Full stop. Next para. As an additional observation, comma, we had recorded in the said order that it is reiterated that nothing in the said order shall prevent the disbursing authorities also to disburse the shares of the children of the late employee from his second marriage in their favor as well. Full stop. Next para. Thus, comma, it is clear that insofar as the ordering portion of the said order was concerned, comma, it merely mandated the respondents to disburse the share of the pensionary benefits in favor of the petitioner. Full stop. Insofar as the children from second marriage of the late employee are concerned, comma, we did not pass any such direction, but merely recorded that our order would not prevent the respondents from disbursing their shares, comma, if any. Full stop. Next para. Obviously, comma, since as per law, comma, the respondent's stand is that the petitioner would be entitled to 100% share of the pensionary benefits, and the share of the children of second marriage of the late employee would be nil, comma, the pensionary benefits have to be disbursed in favor of the petitioner as a whole. Full stop. There cannot be any doubt in that regard, comma, on the face of our order under contempt. Full stop. Hence, comma, in such view of the matter, comma, we do not find any reason not to disburse the pension in favor of the petitioner, pensionary benefits in favor of the petitioner as a whole. Full stop. Next para. However, comma, since it has been pointed out in the affidavit filed today that the matter is pending the approval of the Deputy Secretary to the Government of West Bengal, comma, we direct the Deputy Secretary to the Government of West Bengal, comma, Home and Hill Affairs Department, comma, Police Establishment Branch, comma, Nabanno, comma, Howrah, comma, PIN code 711102 to immediately implement the order of this court dated July 30, 2024, passed in WPST 4 of 2024, and ensured that due approval is granted to release of the pensionary benefits in respect of the petitioner in terms of our said order at the earliest, comma, preferably within a fortnight from date. Full stop. Next para. The Deputy Secretary shall act on the server copy of this order, coupled with a communication by the learned advocate for the petitioner for the purpose of compliance, without insisting upon prior production of any certified copy. Full stop. Let the application be listed next on ওই কোন একটা সময় করে দিই, একটা শুক্রবার থেকে করে দিই তাহলে on April 25, 2025 at 1 p.m. for passing further orders. We are granting you more than that time. So please communicate immediately.
I would like to appear virtually because circuit will be
No, appear virtually.
I beg your pardon, my lord. Item number 16, 17, my lord, had taken up, my lord, had passed direction for mediation, my lord. There is one problem, my lord. Item number 17, my lord, there was a stay application to the counterclaim, to which an execution has already been filed, and the date is fixed on 25th April on, and it is written, if there is no order from the honorable court, their writ of possession will be issued, my lord.
You have granted some order.
You granted, my lord, injunction with respect to status quo, nature, possession of the property, my lord. There is
That will cover your execution also.
My lord, it will not, my lord.
No, we cannot recall our order like this.
My lord, kindly fix it to be mentioned tomorrow, my lord.
Well,
Sir,
to be mentioned-
the other side, my lord, he'll come.
To be mentioned tomorrow.
Tomorrow, my lord.
Tomorrow, very well. To be mentioned tomorrow.
To be
বছর হয়ে গেল স্যার, আমার হাইকোর্টে একটা কেস আছে।
হ্যাঁ।
এখন আমার 64 বছর বয়স, ভীষণভাবে আমি শারীরিক এবং
আপনি একটু মাইকটা কাছাকাছি নিন। হ্যাঁ।
শারীরিক এবং মানসিকভাবে ভীষণভাবে বিপর্যস্ত। দৌড়ে দৌড়ে আমার
আপনার কেস কি আমাদের লিস্টে রয়েছে? কত নম্বর?
আমার কেস নাম্বার FA 58 2019 13th January তে মেনশন
আপনি কি চাইছেন বলুন?
একটা হিয়ারিং ডেট যদি আমাকে দেন।
আমাদের প্রবলেম হচ্ছে আমরা অন্য কাউকে, যেহেতু অন্যরা অ্যাডভোকেটের থ্রু দিয়ে অ্যাপিয়ার করছে, তারা তো ডিসঅ্যাডভান্টেজে থাকতে পারে না।
না
আমি ইউনিভার্সালি আমরা আপগ্রেডেশন দিচ্ছি না, কারণ এই সবকটা ম্যাটার ইম্পর্টেন্ট, আর আমরা চেষ্টা করছি যত তাড়াতাড়ি
আমার লিগ্যাল এডস এর কেস স্যার, ওখানে কোনো রকম কোনো কিছু আমি পাচ্ছি
আমরা
না।
বুঝতে পারছি, কিন্তু আমরা পার্টিকুলার কোনো প্রেফারেন্স কোনো পার্টিকুলার কেসকে দিচ্ছি না
আর
এই
3 দিন
মুহূর্তে।
আগে আমি আমার লয়ারকে ফোন করেছিলাম, ওখান থেকে আমাকে
না,
যা
আপনার
তথ্য
লয়ার হয়তো
দিয়েছে,
কি বলেছেন জানি না আমি, কিন্তু আমরা
উনি
আপগ্রেডেশন
বলেছেন
দিচ্ছি
যে
না।
আমি ছেড়ে দিচ্ছি, আপনি অন্য কাউকে দেখে নিন। এটা
উনি এই কারণে বলেছেন আমরা আপগ্রেডেশন দিচ্ছি না হয়তো,
আমি আমি তাহলে
কিন্তু
কি
আমরা
করবো?
আপগ্রেডেশন কোনো পার্টিকুলার ম্যাটারে দিচ্ছি না। আপনার চেয়েও অনেক অসুবিধাজনক অবস্থা অনেকে আছেন যাদের অ্যাপিল আমাদের
9
কাছে রয়েছে।
বছর হলো আমি এখানে করেছি।
9 বছরের বেশি
এখানে
অ্যাপিলও আমাদের কাছে আছে।
ঘুরছে স্যার শুধু।
আমরা বুঝতে পারছি, কিন্তু প্রত্যেকেই সেরকম সার্কামস্ট্যান্স, একজনকে আরেকজনের উপর প্রেসিডেন্স আমরা দিতে পারছি না। ওই জন্য বাকি যাদের অ্যাপিল রয়েছে তাদেরও কিন্তু সিমিলার সার্কামস্ট্যান্স অনেকের আছে। আপনাকে প্রেসিডেন্স দিলে তাদেরকেও পিছিয়ে যাচ্ছেন, আমরা সিরিয়ালি ওই জন্য নিচ্ছি।
কবে হতে পারে এটা?
বলতে পারছি না,
আমি
যবে
আমি
নিতে
কিভাবে
পারবো তবে।
আমি কিভাবে জানতে পারবো?
আপনাকে লিস্ট ফলো করতে হবে, আপনি অনলাইন স্ট্রিমিং হয় আমাদের কোর্টে দেখতে পারেন।
কজ লিস্টের মান্থলি
কজ লিস্টে মান্থলি না, ডেইলি কজ লিস্টও বেরোয় আমাদের। আপনি একটু জিজ্ঞেস করবেন, উকিল বাবুরা হেল্প করবেন। থ্যাংক ইউ। Yes, Mr. Gupta.
Well, if your lordship kindly takes a look at my section 5 once, kindly comes to my lord.
Yes.
Paragraph 21. At page 7.
Yes.
Well, this was the impression which the defendant was having, that it was the suit the plaintiff filed with regard to his right. And since there was no, he was carrying business of Hamlin shoes, the plaintiff. And since the plaintiff, defendant was not taking any step to evict the plaintiff, the status quo order is really not pinching him at all. So, my lord, thereafter, my lord, it has been mentioned, my lord, that at paragraph 20, my lord, that my lord, a notice was given saying that by putting up a signboard in the defendant's portion.
What do you say that?
My lord, kindly see paragraph 24 at page 8. The signage was only changed in respect of the defendant shop room. Now, my lord, in the plaint and the injunction application, there are suppressions galore.
In the order 39 rule 2A, their contention is only that you're changing the sign.
Yes, nothing else. Nothing else.
Fixing
Fixing a signboard.
Only that.
Yes.
Not that you're trying to enter into.
Your lordship would take it from me and record that I am not going to disturb his possession of his shop.
No, that is something.
That is not which we have ever intended to. But the problem is, my lord, the plaint and the injunction application both contains suppressions galore, where the plaintiff had entered into an agreement, and this is what is the subject matter of Can 3, where the plaintiff had entered into an agreement saying they will vacate the property. Plaintiff. Because there was a development agreement, and in the developer company, he, in exchange of him relinquishing possession, he has been allotted 10% shareholding. So he's got that consideration. He has got the allotment of 10% shareholding, and yet he was not leaving.
That is on the grounds of the appeal.
Well, that is why, my lord, because I couldn't place anything on record before the court below, my lord. So we had come up with that order 41 rule 27, where we have, my lord, sought to give the grounds as to, my lord, why I am in possession and why he does not have any right, but whatever, I am not disturbing his right.
Yes, Mr. Ghosh, what do you say to this explanation? Yes, Mr. Gupta, you want to add something? Sorry.
My lord, only thing, kindly see paragraph 25 also.
Yes.
But here I have annexed photographs that what all I am trying to do, paragraph 25. So, really, it is.
Have you annexed a copy of that order 39 rule 2A?
Yes,
Next to stay petition.
Next.
It is annexed to stay petition. It starts at
page 39.
It starts at page 26.
39.
Oh, I'm sorry.
39.
Yes, ma'am.
Now, paragraph 5 and 6 is really the ground at page 44, where there's an allegation of changing the padlock.
It's not just the signage.
So this is this 39.2A is before. This 39.2A, the date of filing is before the interim order. The final.
Is that the ad interim stage?
Yes. Now, after.
But the ad interim stage, the same status quo was passed.
Yes, but after that order, the advocate's letter, which really prompted us to come, is, if your lordship kindly sees that letter once, that, my lord, will find that page, my lord. 64 is really not legible. আচ্ছা ভালো কপি দাও না। Well, if your lordship kindly takes a look at the 10th December letter of their advocate from Can 3, that is legible.
No, this is also legible, yes.
Legible?
Sure.
আমার কপি legible. Can 3 তে page 42 দেখ। Can 3 তে page 42. Kindly see, it turns to the second page.
Signage.
Signage.
This preceded the 39(2)(a). Must have.
This preceded the 39(2)(a). No, not that 39(2)(a). This was a letter issued after the final order.
There's only one 39(2)(a).
Yes. So the 39(2)(a) is prior in point of time, where allegations were there with regard to padlock and CCTV camera.
So after getting the 39(2)(a) copy, you moved this appeal.
No, after getting 39(2)(a), even in the day fixed before the learned court below, we wanted to file a written objection in 39(2)(a) also, as well as to 39(1)(2).
Mr. Gupta, if you came to know from 39(2)(a) that they are interpreting the status quo in such a manner, then that would have prompted you to come up in appeal immediately against the ad interim, because after that only the final order was passed.
After
So how
that,
can that prior 39(2)(a) be a ground for your misapprehension continuing?
We were wanting to contest both the proceedings.
39(2)(a) you got obviously before the passing of the present impugned order.
39(2)(a) is still pending.
Whatever,
Yes,
you got the application, copy of the application prior to this order.
Absolutely.
So how can that be a post facto ground for your misapprehension after getting the 39(2)(a)? You must have understood that.
Well,
Then how can that 39(2)(a) be a ground for your delay?
Well, my contention is that from this lawyer's letter, where
Yes.
my possession, because up till then,
Lawyer's letter was also before the 39(2)(a), before the impugned order.
No, well, lawyer's letter is post.
Post.
This is post. This is December.
But you had the 39(2)(a) before that.
Well, may I just by
39(2)(a) says that you cannot put a padlock and all this.
May I indicate? 39(2)(a) was with regard to two complaints: padlock and CCTV. Those were outside my shop room. But
Common,
this is
a common
area. Very well. Now, my lord, this letter where I am doing something in respect of my shop room when it is
give rise to a new cause of action.
No, because
you already had knowledge of their construction of that order, the identity order,
which they were construing in respect of other portions. So I was really not bothered with that, because as long as I am doing my business, I don't have a problem. Here is when the real problem started, and when the clients came, my lord, that when this letter, by this letter, they sought to contend that you cannot do anything in respect of your portion also. Because that is the tenor. Kindly see the second page where the signage was being changed, which was an act of contempt is being said. So then the clients thought that the status quo, they would be doing their business, I would be doing my business. But no one is changing anyone else's position.
All right.
But this is a fallacy in the understanding I can understand. But this is what has happened. But they were really not wanting to disturb them, so they were really not wanting to come up from that. Now, for settlement,
let us hear, Mr. Ghosh. Yes.
Lord, with regards to the Section 5 application, what Mr.
Where is the scope of filing any opposition? What?
To the extent that his understanding is flawed, that is the basis. That is absolutely negated from, my lord, the series of orders which is evident, as well as, my lord, the fact that, my lord, he has actually disturbed.
The series of orders are with you.
Because it is part of the memorandum of appeal.
And then there is no necessity of filing
And,
an
my lord,
opposition.
paragraph 11.
So you are relying on their averments and their.
Yes, because they are changing the nature.
We are not directing to file an affidavit now. We are deciding right now. This.
Very good. But, my lord, Order 40 on Rule 27, Lordship.
No, only Section 5.
Only Section
First
5.
Section
Yes,
5.
Lord.
Then we have to admit the appeal, then Order 40.
Yes, my lord. So, my lord, they contain that the interpretation and understanding of the suit premises as indicated in the plaint, there the petitioner had misconstrued, and it was construed only as my shop room, which, my lord, is the only ground according to them in the Section 5. Now, my lord, Section 5, my lord, their understanding of the factual position from their own averments would indicate that they had actual knowledge of what the suit premises is. Now, in my plaint, if they say that it is the shop premises, that would also be negated from my plaint, because paragraph 10 of my plaint is very clear, where it says, Lord, if your lordship is pleased to take it, it's from the stay petition at page 17. The defendant is trying to forcefully change the nature and character of the suit premises without having any legal right to do so. So it couldn't have been that I am pertaining to my premises and challenge his legal right. It has to be with regards to the entire ground floor.
Where is that? Which paragraph?
Paragraph 10 at page 17.
Trying to forcefully acquire. Yes.
So his understanding, based on which he has filed the section 5, that again is, my lord, is perhaps not the correct understanding which has been indicated to your lordship.
But he says that even in your 39(2)A application, you have not complained, you have not tried to prevent them from using their shop room. You have only alleged that they are putting CCTVs and in the common entrance they are putting a.
Yes, my lord.
So thereby implying that their user of their own shop room, you are not bothered with that.
No.
At least that's not a ground for contempt.
No, because that ground.
Common entrance is a ground for contempt.
Yes.
So common entrance. Therefore, you continue with giving them permission to use their portion of the shop room even after the injunction or ad interim order.
So the ad interim order is only ad interim as confirmed.
And even after the impugned order, present final order, then also you give a letter only saying that you are changing the signage, which is a contempt.
Yes, my lord, which is only restricted.
You never
to the
complained. You never complained about their user of their shop room.
No, we have never complained about their user,
So
because
that may create an apprehension in their mind that yes, although the schedule was that.
Schedule is that
Status quo was interpreted as it is going on.
But my lord, my
possession as it is.
Yes. Possession as it is, it will continue.
So they are also in possession, so that will continue. They could have an apprehension. There is a possibility of that.
Possibility of
their apprehension.
I will remove them.
No, possibility of their apprehension that this status quo does not affect their portion of the shop room, because you did nothing to complain that they're using their portion as a contempt.
No, my lord.
So status quo may mean both things. Status quo may be because it was not specified that yes, status quo regarding this. I mean, nothing was specified as to what is the status.
Well, in my plaint, my lord, perhaps
plaint it is there, injunction it is there, but ultimately the order of status quo, it is the order of status quo which is challenged. Now they might have apprehended that you constitute in a different way, and that has been, I mean, rather corroborated by your action or inaction.
Well, I have not disturbed his possession.
So we are on section 5 only.
Yes, well, on section 5 only. I have not disturbed.
They could have this misapprehension. Then you are not disturbing their possession means that they were not threatened. But the moment you said you cannot put up a signage, they constitute, yes, then signage, putting up signage in my shop room also is a part of that status quo. You're constituting.
But the fact that they're aggrieved by the status quo, and the fact that, my lord, my letter of December 24, which I've written to them indicating that you cannot put up a signage, the timelines, if your lordship sees, they being aware of the suit premises and it is not restricted to just their shop room, that explanation does not cover. Their explanation is this, that I as in their clients, construed the suit premises to be only my shop room, as in the plaintiff's shop.
They constitute the status quo to be
apply
in respect of whoever is in possession of whichever portion.
No, my lord, that perhaps is not the case.
That has to be the case. They cannot say that they constitute the plain schedule to be different from what it is.
That is what they have stated.
No. What is that? Plain schedule they have not said in.
Lordship sees what they have stated in paragraph.
Partly both. Plain schedule as well.
Plain schedule was before you.
As was always there. Their case is that.
They were under.
They have misconstrued the plain schedule.
Both had.
Which is the relevant paragraph?
My lord, lordship sees paragraph 38 at page 10 of the section 5. It has now transpired after the delay of such and such days. The delay was unintentional as much as the appellant was on a bona fide impression order impugned would operate qua the shop.
Which paragraph?
Paragraph 38, my lord.
38 is at page 11, yes.
Yes, my lord. That qua the respondent's shop room.
Oh, sorry, we are looking at. I was looking at the other.
Section 5. It
will be can 1.
38, yes.
Yes, my lord.
Now transpired that case.
Was under bona fide impression that the order impugned would operate qua the respondent's shop room, in as much as the entire cause espoused in the plaint pertain to a respondent's shop room, which is again an incorrect statement.
They don't refer to the schedule as.
No, but then the next paragraph, however, the fallacy is such, understanding of plaint was pointed out by the senior. And, my lord, in view of the matter, delay.
Sir Gupta.
Yes, Mr. Gupta. He pointed out that it's not your shop room. It is the entire ground floor. So don't do anything. That is when he said, go and file an appeal.
That is when I said, go and you to file an appeal. You can't just be there.
So the fallacy is with regards construing the plain schedule, not his understanding of the order. If I would have understood,
They say that the impugned order would operate quay the respondent's shop room.
That
don't say that that is the suit premises. They say that it would quay because you have permitted them to stay use their shop room. all
that is their understanding, but that the order doesn't say
There was
so.
some basis for that understanding because your neither your contempt application nor your letter say that they are using the shop room in violation of the order.
No,
you have permitted them to use the shop room order.
Because my lord, my it's not for eviction.
So therefore, status quo as regards possession might mean both. Whatever,
So they are
whoever
in possession, but if they start changing the nature or character,
whenever you are stopping them from changing their own signage, then they come to know that come to understand that
that is their
the light flashes, the signboard, the signage flashes.
Signage flashes.
Go and file an appeal, or go to Mr. Gupta,
Yeah,
and then Mr. Gupta says that.
But that delay, that is not an explanation for the delay. I cannot.
Learned counsel for the appellant, in support of the application for condonation of delay, submits that the appellant was all along under the impression that the status quo order, which is sought to be impugned in the present appeal, was passed qua the shop room of the respondent. First up, it is submitted that from the ground floor of the suit premises, both the appellant and the respondent are carrying on their respective businesses from different shop rooms. First up, next para. Such impression, it is argued, was further strengthened by a notice dated December 10, 2024, issued by the learned advocate for the respondent after the passing of the impugned order, wherein it was alleged that by putting up and or installing a dealer board and or storefront signage, SIGNAGE, in the name of Mojo Fashions, an act of contempt was being about to be committed by the appellant. Push up, as such, upon understanding the construction sought to be given by the respondent to the impugned order from such letter, the appellant was advised to prefer this appeal, since the letter prompted the appellant to be aggrieved by the said order for the first time. Whose up next para, learned counsel appearing for the respondent controverts such and contentions and submits that the plain schedule and the schedule given to the injunction application in the trial court made it abundantly clear that the suit premises, which was the subject matter of the status quo, comprised of the entire ground floor, including both the alleged shop rooms. First up, as such, there was no iota, there could not have been any iota of doubt in the mind of the appellant as regards the property in respect of which such status quo order was passed. First up, thus, nothing happened after the passing of the order of status quo to alter the perception of the appellant on such count. As such, it is argued that no ground or plausible reason for the delay in preferring the appeal has been made out. Next para. We find from the schedule to the plaint and the injunction application that undoubtedly the respondent is justified in contending that it was open to the appellant to understand that the subject matter of the suit property, in respect of which the status quo was granted, both at the ad interim and the final and the temporary injunction stage, comprised of the entire ground floor, including the shop room of the plaintiff, including the alleged shop room of the appellant. Next para. However, it is the perception of the parties which matters here. It might have been reasonably perceived by the appellant, from the conduct of the respondent in construing the ad interim and thereafter the temporary order of status quo, that the status quo operated in respect of the respective position of the parties regarding their individual shop rooms. Next para. In fact, from the impugned order, comma, we find that although the case of the plaintiff has been discussed within brackets, since there was no written objection filed by the defendant stroke appellant, bracket closed, comma, the ordering portion merely directs the parties to maintain status quo as regards possession, comma, nature and character of the suit premises till disposal of the suit, comma, without categorically spelling out as to which portion of the premises was in occupation of which of the parties. Full stop, next para. In fact, comma, a misapprehension in that regard might also have arisen since both parties were directed to maintain status quo not only regarding the nature and character of the suit premises but also the possession, comma, since if the defendant was construed by the learned trial judge not to be in possession, comma, there would not be any occasion to bind the plaintiff as well by an order of status quo in respect of possession of the suit property. Full stop, next para. The said misapprehension might have been strengthened by the application filed under Order 39 Rule 2 capital A of the Code of Civil Procedure by the respondent for alleged violation of the ad interim order of status quo, comma, which was to the same tune as the final order. Full stop, next para. In the said application, comma, the allegation of violation was restricted to the appellant allegedly putting up CCTV cameras within the premises and putting up and affixing a padlock on the within double inverted common entrance, double inverted close, of the suit property. Full stop, next para. Thus, comma, even in the said application, comma, there was no specific allegation that by using the shop room purportedly in possession of the defendant appellant, comma, any contempt of the status quo ad interim order of status quo was being committed. Full stop, also, comma, in the letter dated December 10, 2024, comma, it was alleged merely that by putting up a signage on in front of the shop room apparently in occupation of the appellant, comma, a contumacious act was being committed by the appellant. Full stop, even in the said letter, comma, no specific allegation was made that the appellant was in contempt of the status quo order by using his own shop room. Full stop, next para. Hence, comma, from the conduct of the respondent, comma, there might have been an apprehension in the mind of the appellant that the appellant was not aggrieved by the status quo order, comma, since the parties were directed only to maintain status quo in respect of their respective possessions in the suit property. Full stop, next para. Hence, comma, we find that a plausible reason for the delay in preferring the appeal has been made out in the application. Full stop. In the absence of any malafides as such which can be attributed to the appellant, comma, it is trite law that a lenient view is taken in deciding applications for condonation of delay, where sufficient reasons have been shown. Full stop. In such view of the matter, Can 1 of 2025 is allowed, comma, thereby condoning the delay in preferring FMAT 1 of 2025, full stop. There will be no arrest to cost, stop. However, comma, we make it clear that since no affidavits have been directed to be filed, comma, it is deemed that none of the allegations made in Can 1 of 2025 have been admitted by the respondent, full stop. The appeal is now taken up for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Yes. It is appearing under the Order 41 heading.
Yes.
Yes.
Well,
What is your ground?
I need to press my Order 41 Rule 27.
Order 41 Rule 27, you have a bad case, Mr. Gupta, because since you are precluded from filing a written objection, you cannot, in the garb of this Order 41 Rule 27, before the appellate court for the first time get an opportunity which you are denied in the trial court, unless this order is set aside otherwise.
But could I
If we
then
permit you to do that, that would tantamount to permitting you, more than permitting you to file a written objection at the admissions.
I understand. I understand. Well, may I humbly suggest one thing, subject to what your lordship. Well, this
They
order.
got a walkover. We have no doubt on that, in the sense that there was no written objection.
Yes.
But you got two
But
opportunities.
I got opportunities. I
That is the
understand.
difficulty.
Yes, but there are suppressions galore and there are agreements which they have executed where they have said they would go out. But may I, in this
If there
circumstance,
was a suppression galore, Mr. Gupta, you are entitled to file an order 39 rule 4 even at this stage, even if it was a contested order, on the grounds of suppression and undue hardship.
I was relying on those that club judgment, where if suppression is of such a nature which would really affect the substratum of the order, then possibly before the appeal court also, it can be looked into. But I understand, I had missed the bus twice. May I
There was an
humbly-
objection on record, Mr. Gupta. We would not
may I-
hesitate to do that.
may
We
I-
could take in further evidence.
May I humbly submit one thing? Keeping the order as it is, would it be your lordship's pleasure to remand and give us 3 days time to file a written objection and direct the matter to be heard upon considering our objection?
What is the wrong in the order? You have to say something that.
But the wrong in the order is it's only with regard to the plaintiff. They, on the basis of their
You
pleadings.
did not file any written objection despite getting.
Yes, I did not. So I want
the
to bring
court had
those
to
on
proceed on that premise only.
I had to bring those on record because there are agreements to say which would show that they have no right, and they have said they would relinquish possession because this entire building was to be developed, and in the developing company they were allotted in
But if they
lieu of
say that they want to relinquish the property, that means that they have a possession and right in the property.
Yes, and
can relinquish only what one has.
And I'm not disturbing and recording that your lordship may remand that I undertake not to disturb their possession without due process of law. Recording that undertaking, if it so commences to your lordship, subject to hearing my learned friend, of course. That moment, if your lordship kindly grants us an opportunity to file a written objection, kindly gives us 3 days, we can file it by Monday's holiday, by Tuesday.
Yes, Mr. Ghosh, what do you say to that? There is a written objection on record. We are also a bit apprehensive.
They had sufficient opportunity. That's one. The other part is
Will
this.
compensate by costs. Will maintain the status quo order till disposal of the injunction application.
And also records are undertaking. I'm
not just that.
You're undertaking this order will be.
Yes, and
not
on
just
the
that,
instruction
the
that I will
order
not.
is still disposal of the suit.
Pardon?
The order is still disposal of the suit.
Yes.
I'll have to come down to the disposal of the
injunction
application.
stage. Yes.
They can come. They could have filed an order 39 rule 4. Nothing prevented them. Their issues with regards
Order 39 rule 4 is
and they've filed an application for modification of the order. That is pending.
Modification of this order?
Yes.
To what effect?
Look, this is to the effect.
Contempt.
Yes.
Contempt.
This is in
The miss case. This is in the miss case.
The miss case.
Miss case?
Miss case with
In the
regards to,
context.
my lord, the order of 19th of August 24, which is, my lord, the order passed in the miss
This is the
case
impute
where,
order,
my lord,
yes.
the status quo till disposal of the suit.
What modification have they sought?
I'll indicate.
Lordship will kindly see this. Modification is that modified and status of the petitioner be restored and the contemner be allowed to defend this instant proceedings. This is, my lord, in the order of 19th of August, where they did not fight.
Modification is neither here nor there.
Well, I'll indicate. 2 orders were passed. One, where the injunction was disposed of finally.
Yes.
The
Mr.
other,
Gupta, we don't find any reason to set aside the order and give you
this
an
is not a modification. May I only dispel this doubt?
No, even if the modification is not there, we are not satisfied on merit. Our judicial conscience does not permit you to give you another opportunity. You are given 2 opportunities. There is no fault on the part of the learned trial judge. A wrong signal will go if we set aside this order and give you an opportunity. There will be no end to litigation. You fight out in the suit. This will be tentative for the purpose of the
But
suit.
if this goes on, this
This
order
will go on.
if this order goes on, then my lord, I'm stuck with my business.
You are stuck with your business.
Yes. So that is why. my
Be
lord.
stuck with your business. You want to do that. You want to be stuck with your
They
business.
can't be going beyond their business.
A, they do not have a right, and B, I am stuck.
No, it's
And
the
because
contentious.
till date, unless they get a cue from your arguments, their contempt and their letter also confined to their shop room only. But they say you cannot put up a signage that will be changing nature and character.
Yes.
probably.
Yes. But
So they are not disturbing your position regarding the suit property as of today. So the status quo order as regards position, nature, and character does not harm you, affect you.
that is why we initially thought. Exactly why we initially thought. But the problem is elsewhere.
Nowhere.
The
We won't set aside. We won't admit the appeal because
Malad,
there is
could
no
I-
case made out by you for admission of the
Malad,
appeal.
could I-
The court was justified.
Could I indicate one modification in this?
What modification?
That this will not prevent either parties from carrying on their respective business.
No. What a beautiful modification.
I will not disturb them. So there,
his
so the
title
status
is
quo
in
with regard to
doubt.
my position.
I-
if your
I'm
lordship kindly
challenging
sees-
his
We won't
title.
clarify that.
But if your lordship kindly sees the
That
last
will be
note-
argued in the contempt proceeding.
But if
If they broaden the contempt
But
proceeding.
your lordship, I need to use an objection to bring on record these documents.
You have lost that opportunity.
But then kindly in the appeal, your lordship would
We'll say these findings are tentative for the
But
purpose
your
of the
lordship
issue.
would
No
kindly-
findings there as such against you.
there's the
Because your objection was not there.
objection is- I
Could
understand.
not have been any.
I am not blaming the
Could
learned.
not have any adjudication on merits.
No, I am not saying that. But the problem is, my lord, we were ready with the
All
objection.
questions will be left open to be argued in the.
That's in the
suit.
suit. My lord, the suit would take years to, my lord, get disposed of.
Depending on you.
No,
Both of you.
even if we, we are not there before the learned.
Status quo as regards position.
Yes.
So go on interpreting it in your own way.
Your lordship would kindly then.
They have not done anything to
Your
disturb your
lordship would
position.
kindly order 41 rule 27 because I need to, my lord,
We
bring
won't
on
admit the appeal. Order for Rule 27.
No, well, the
Well,
injunction. This
produce this
order-
bunch of documents as evidence in the suit. Because the suit is for that. The same relief is. Suit
that
is for permanent injunction, basically.
That's not a.
Do that. Do
But,
that.
but kindly gives
We
us
won't go
one-
into the merits of the order for
but
Rule
kindly
27.
then leaves the door open for a 39-4. Because otherwise, my lord, we can, because it's on the ground of suppression. But I could have, my lord, shown. Well, I could have shown on the ground of suppression. If your lordship kindly takes a look at 39.4.1.
Suppression is there. No, suppression probably for expertise orders only.
Yes.
For contested orders, it's only hardship. I have forgotten. I'll just check.
Yes. I'll indicate.
39.4. The last proviso, second proviso. Shall set aside except where change in circumstance or undue hardship.
Undue hardship.
You have these two.
Undue hardship. So
But we will leave this scope open.
kindly
This will
leave
not
this
prevent
scope.
you from filing
Yes.
any order 39 rule 4 on the second proviso.
Yes.
Let them file.
Order for বলেছি বোধ আগে যে order for 29 জন্য hard learned counsel for the appellant full stop. We find no deficiency and or illegality in the impugned order. Full stop. The plinth of the arguments of the appellant are centered around their not being around the appellant not having an opportunity to place its case before the trial court by filing of a written objection to the injunction application. Full stop. However, we find from the impugned order that the matter was already fixed for filing of written objection, and on repeated calls, the defendant stroke appellant was not present, nor anybody moved, anybody appeared on behalf of the appellant. Full stop. Next para. We also come to know from the submissions of learned counsel for both parties that a previous opportunity had also been given to the appellant to file a written objection. Full stop. Having missed such opportunity twice, a new window cannot be opened before the appellate court, permitting the appellant to file a written objection to the injunction application. Full stop. There has to be an end to litigation at some stage, and in the absence of any patent or illegality or other legal or factual error in the impugned order on the basis of the pleadings before the learned trial judge, we are not inclined to interfere with the impugned order. Full stop. Accordingly, FMAT 1 of 2025 is dismissed under order for Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, Can 2 of 2025 and Can 3 of 2025 are also dismissed. Full stop. Next para. However, it is made clear that nothing in this order or the order impugned herein shall prevent the petitioner, if otherwise prevent the appellant, if otherwise entitled, from taking out an application under Order 39 Rule 4 of the Code of Civil Procedure, subject to satisfaction of the yardsticks stipulated in the second proviso thereto. Full stop. If such an application is filed, the learned trial judge shall hear the same, shall give an opportunity to both parties to address the same and file their pleadings in respect thereof and decide the same independently of the present dismissal. Full stop. It is further clarified that none of the observations made herein and or in the impugned order shall be treated to be conclusive for the purpose of the final hearing of the suit. No arrest to cost.
Your Lordship said final hearing of the suit, the application of this.
No, you can file another injunction tomorrow. Then. This will be treated as conclusive for 13(4). These are conclusive for 13(4). If you satisfy the yardsticks of 13(4), then this will go.
Great. Great.
Yes. আচ্ছা
25, my lord.
This is section 5?
Yes, my lord. In pursuant to lord's
First, let us correct an order, correct an error in our previous order. In the order dated March 11, 2025, comma, the caption erroneously recorded FA 41 of 2025 instead of FMAT 41 of 2025. Let such order be deemed to stand corrected accordingly. Yes. Section 5.
I am for the defendant appellant.
You have given a copy of the section 5, Mr.
Yes,
Mathur is appealing.
In pursuant to lordship direction, my lord, I have such.
What is the delay?
This appeal is, my lord, against the ex parte order passed in an application under Order 39, Rule 1 and 2.
Injunction granted.
For partition.
Injunction granted.
Yes, my lord, till the disposal of the suit. I am inviting your lordship kindly come to the impugned order.
No, first you have to cross the section 5 hurdle.
Section 5, my lord.
What is the delay? 143.
What
is the reason?
Reason, my lord, the advocate on record, my lord, was ill. She was admitted in the hospital, my lord. I have stated everything in my.
Yes, Mr. Mathur, what do you say? In view of sufficient reasons having been heard learned counsel for these parties in respect of the condonation application, full stop, upon being satisfied as to the sufficiency of the reasons for the delay in preferring the appeal, comma, can 1 of 2025 is allowed, thereby condoning the delay in preferring FMAT 41 of 2025. Full stop, there will be no arrest to cost. The appeal is now taken up for hearing under Order 41, Rule 11 of the Code of Civil Procedure. Yes.
Not suit for partition. Defendant appeared and filed written objection.
Mr. Mathur, take your seat because.
This one number 1 to 5.
1 to. The plaintiffs. The rest we can dispense with also.
The suit for partition, my lord, the defendant appeared and filed written objection. My lord, on 10th of June 2024, my lord, the date was fixed for. Initially, my lord, the order of ad interim injunction was granted, my lord.
You only filed written objection?
Yes.
There are other defendants also. You only filed written objection?
Yes, my lord, I am only.
So then?
My lord, initially, ad interim order of injunction was granted. After that, my lord, the defendant appeared and filed the written objection, filed his written objection. And on 10th of June 2024, the date was fixed for hearing of an application under Order 39, Rule 1 and 2. On that day, my lord, the defendant appellant filed one application for adjournment. But, my lord, at the time of call, no one appeared and moved this application.
How are you aggrieved with the status quo order?
Status quo, my lord, my humble submission is that
it is a partition suit.
Partition suit. The plaintiff is not the owner of the property, my lord. Their predecessor already sold out the property. Without giving any opportunity of hearing the, my lord.
Mr. Mahato, this order is not proper. Just making it absolute, the final hearing of the injunction is different from ad interim. We'll set aside this order. Because there was already a subsisting status quo order, we'll clarify that will remain till the disposal of the injunction. But a hearing has to be given to both sides.
The submission part has been submitted before your lordship that they filed an application on order.
Written objection. They filed a written objection, they say.
No, written objection to the injunction application that is there.
Yes, only that.
Why they did not take any step?
No, my lord.
That is, there is
no. Regarding not taking step, we can understand that the trial court may be correct. But the trial court says, because at the final hearing stage of the injunction, Mr. Mahato, you have to decide on merits, the injunction application. At least looking at the written objection.
If the interim order will continue till the disposal.
Before coming into the courtroom, you know, Mr. Mahato, what order will pass. So let us pass that order.
My lord, my submission, what my lord has submitted.
Yes, status quo will continue till disposal of the injunction, but will direct. Obviously, that has to go.
My lord, may I file the affidavit of service?
File it. It's larger than Mr. Mahato, the envelope. You can hit him with it also. Mr. Mahato, we are recording your consent in taking up, disposing of the appeal along with the, at this stage. That consent only. Achha, in view of a strong prima facie case for hearing of the appeal on merits having been made out, comma, the appeal is admitted and will be heard on the grounds as taken on the memorandum of appeal. Pushed up. আচ্ছা একদম প্রথমে দিয়ে দাও affidavit of service file to be kept on একদম next para. Since the scope of since the ambit of the appeal is extremely limited, comma, we give a proposal to both sides to take up the appeal along with the application for final disposal by dispensation of paper books as well as trial court records. Push up. Learned counsel appearing for the plaintiffs respondent numbers 1 to 5, comma, who are the primary contesting respondents, comma, in his usual fairness, comma, agrees to such proposal of the appeal being decided finally. Push up next para. Service of notice on the pro forma respondent on the defendant on the respondent numbers 6 to 17 and the pro forma respondent number 19, comma, against whom no relief has been sought in the appeal, comma, is dispensed with. So next para. By the impugned order, comma, the learned trial judge disposed of finally an injunction application, comma, however, comma, without adverting to the merits of the injunction application and the written objection at all, comma, merely on the premise that since there was already a prevalent ad interim order of status quo as regards possession and nature and character of the suit property, comma, the learned trial judge found it just to extend the said order in the form of status quo till disposal of the suit. Full stop next para. It is common knowledge that there is a distinction between a mere extension of an ad interim order granted at the initial stage and the final hearing of an injunction order. Full stop. There are several stages to the hearing of an injunction application, full stop, whereas an ad interim order is passed on certain yardsticks, comma, the same is the observations made while passing the same are not binding at the final hearing of the injunction application. Full stop. While deciding the temporary injunction application finally, comma, it is the incumbent duty of the civil court to advert to the allegations made in the injunction application and the written objection, comma, if any, and decide on a full-fledged hearing the injunction application on its own merits. Full stop. However, comma, the procedure adopted by the learned trial judge was cryptic. Full stop. The learned trial judge merely treated the final hearing of the injunction application as an application for extension of the ad interim order passed earlier. Full stop next para. Thus, comma, we are of the opinion that the impugned order is bad on the above score as well as devoid of reasons as such. Full stop. Accordingly, FMAT 41 of 2025 is allowed on contest, comma, thereby setting allowed on contest against the respondent numbers 1 to 5, comma, thereby setting aside the impugned order bearing order number 11 dated June 10, 2024, passed by the learned civil judge, senior division, 3rd court at Poschim Medinipur in title suit number 583 of 2022 and remanding the matter to the learned trial judge for a fresh adjudication of the temporary injunction application on merits in the light of the above observations, comma, upon giving an opportunity of hearing to both sides. Full stop next para. It is, comma, however, comma, made clear that the ad interim order of status quo as regards possession as and nature and character of the suit property, comma, which was subsisting at the juncture of passing of the impugned order, is hereby revived and shall continue till the disposal of the temporary injunction application by the learned trial judge. Full stop. Next para. It is expected that the learned trial judge shall decide the injunction application on merits as expeditiously as possible, comma, preferably within 6 weeks from the date of communication of this order to the learned trial judge.
Grateful. Your Lordship.
Can 2 of 2025 is disposed of accordingly as well, no orders to cost.
Grateful, Your Lordship.
এটা তন্ময় জাজমেন্টের ফরম্যাট অ্যাপিলটা ডিসাইড
Item number 26, Lordship, is my appeal.
Yes.
The judgment and decree passed by the learned additional district judge.
What is the defect? There is a defect pointed out here.
Lordship, I believe that the name of the
Several defects. Pro forma defendant respondent 4 is not a party in the appellate court.
Lordship, if your Lordship may kindly see the memorandum of appeal and my CAN 1, that is stay application. Respondent number 4, that is Chandi Das, I believe, has been made a party. He is a party. Lordship may kindly see.
No, the defect is that the Chandidas is not a party in the first appellate court.
First appellate court, Lordship, he was a pro forma defendant. Lordship, I will place.
We'll just check up the.
If your Lordship may kindly have regard to the decree.
Appellate court's degree, yes.
Yes, Lordship. At page number 57, your Lordship will see he is pro forma respondent, Shri Chondidas. Pro forma.
Yes, you're right. So that defect goes. Next is preamble is bereft of the name of the presiding judge.
Yes, Lordship. I have written it in the memorandum of appeal, but Lordship, there is a little bit of mistake. You
have written.
I have written, but Lordship, the spelling is incorrect. It should be Binay Kumar Nonia. I have written it Niyogi.
That is a different. I mean, you've given the name. We'll give you liberty right now to correct that surname error. The next is name of presiding officer.
Of the
Actually, needs to be rectified. Oh, trial court's presiding officer. Yes. What about that? That name you can furnish now. Appeal court, trial court's name is not there. So, do you know the name? Can you furnish it? Do it today.
Yes, Lordship, it is present. It is present at page number 20.
Board of course, yes.
Lordship,
So do it right now. We'll give you liberty. Even if you dismiss the appeal, please rectify carry out the corrections. We'll give you that liberty first, then proceed. Insofar as the first defect pointed out by the additional stamp reporter, we find from the decree of the first appellate court that the name of respondent number 4, Chondidas is a party here in your appeal also. Yes.
Yes.
Respondent number 4, Chondidas is concerned, he was mentioned as a pro forma respondent, and as such, there is no need to rectify, send down the records for correction of the appellate court's decree, first appellate court's decree. Push up. Regarding the second and third defects, leave is granted to the learned advocate on record for the appellants to carry out the necessary rectification in the name of the learned first appellate judge as appearing in the memorandum, as appearing in the preamble of the memorandum of appeal, as well as incorporate the name of the learned trial judge in the said preamble during the course of the day. So the appeal is now taken up for hearing under Order 41 Rule 11 of the Code of Civil. Yes.
My appeal is against the order dated, judgment and decree dated 23rd of December 2024. Lordship, before coming to the impugned judgment and decree, Lordship, I will place that I had allowed the defendants.
Is a judgment of affirmance or reversal?
Lordship, it has been reversed. The trial court had given.
You got a decree in the trial court?
In the trial court.
What is the suit for?
Lordship, it is suit for eviction and recovery of khas possession.
Eviction on the ground of?
Eviction, Lordship, I had allowed the defendants to
trespasser.
Licensee,
then.
And license, Lordship, in 1996, I revoked them. They were allowed as permissive possessor to reside in my suit property. In 1996, I requested them to evict the suit property. Lordship, they did not agree, for which I filed a plaint in 2012. Lordship, they
1996 you revoked and
1996 they were allowed to stay in the
continue.
and
Why did the appeal court reverse?
Lordship, appeal court has said that I have not been able to prove my title over the suit property, which is not the defendant's case. And
What is the case of the defense case?
the defense case is that their plot of land is separate from my plot of land, and therefore and they have acquired the same by virtue of a vesting proceeding which has been conducted under the West Bengal Agricultural 1975 Act.
That is a different plot.
Yes.
What is the difference on the suit plot?
Lordship, my case is that they are residing within my suit plot, and they have not been able to produce any documents to show that a vesting proceeding has been conducted. And the learned trial court, learned appellate court,
They say that the suit plot has been vested.
yes,
So they failed to prove that.
yes. Appellate court has held that without adding state as a party, it cannot be ascertained whether it has been actually vested or not vested. The trial court has held that since they are claiming that the plot of land they have acquired by way of vesting proceeding, therefore state is required to be added as a party in order to ascertain what is the actual position of the
Appeal court said that.
Yes, Lordship. Appeal court said, I will
So therefore, non-joinder of the state as a necessary party was a ground.
as a ground, Lordship.
And what else?
Else, Lordship, I have failed to prove my title over the suit property, which is not the respondent's case.
Now,
which
what
is
did
not-
you prove regarding the suit? You have to show something that you have got title.
Lordship, I had
Better
produ-
title at least.
Lordship, I had not produced any deed, but I had produced my ROR. I had
ROR shows that you are in possession.
Yes, that is in that it is there. But the learned appellate court has held that ROR is not a proof of title, and therefore I have not been able to.
Well, where has the trial court, appeal court held that? No, non-joinder point.
Non-joinder, Lordship, the page, Lordship 54.
No, come to the refer to the internal pages
Internal
of the
page
appeal court.
number 11 of 12, Lordship. Of the my can one. Lordship, may I place the relevant paragraph?
Just the non-joinder portion.
Lordship,
Rest you have on. All judgments and all.
Yes, Lordship, paragraph number 22, page number 8. Paragraph number 22, they said, it is practically impossible to say that the said plot is part of the suit plot on or the defendants.
Where is that? It is practically impossible. Yes, middle of that. Yes.
To say that the said plot is part of the suit plot or the defendants have possessed into plaintiff's land. In reply, learned advocate for the plaintiffs replied that the suit plot has never been vested to the government and also not bifurcated till date, and the LRROR, that is Exhibit A, relied by the defendants is not made in connection with the suit plot. He further submitted that in case the government vested any land in favor and subsequently granted patta to anyone, then there must be some procedure or proceeding to that effect, and patta holder must have a patta within it.
No, non-joinder.
Lordship, here itself it has been
Middle of para 24 probably. The trial court has observed that the suit is not bad for defect of party.
defect of parties as other kosher has not been.
That is different. Or did not limit the defect of party did not limit to kosher. Yes. Ashwin, order. The present second appeal will be heard on the following substantial questions of law. Roman 1, whether the learned first appellate judge substantially erred in law in reversing the judgment and decree of the trial court on the premise that the suit is non-joined, suit is bad for non-joinder of the state stroke government as a necessary party, comma, in view of the suit primarily being for eviction of the defendant, and the mere fact that a defense was taken that the suit property is vested does not make the state a necessary party. Roman 2, whether the learned appellate judge, first appellate judge, substantially erred in law in reversing the judgment of the court of first instance on the premise that the plaintiff appellant has failed to prove his title. The plaintiff's appellants have failed to prove their title, comma, by overlooking that a presumption of correctness should have been attached to the records of rights, comma, the extracts of which, as produced by the plaintiffs, show that the suit property is recorded in the name of the plaintiffs, and in a suit for eviction of a licensee stroke trespasser, comma, it would suffice that the plaintiffs prove their better title over the defendant. Third হচ্ছে, whether the learned appellate judge erred in law in making out a third case inasmuch as the defendant, how many defendants?
Three.
Inasmuch as the defendants themselves did not disputed your title. They disputed your
No,
title.
they have never disputed.
Vesting? Who brought up the question?
Lordship, their case is that their suit plot of land is different from my plot, but they have not challenged my.
No, they have said that your property is vested.
No, my property is not vested. Their property is, Lordship, that property, my property is.
Background to দরকার স্যার যে দুটো আছে আছে well we admit on this two your application for what stay eviction no eviction what is the scope of stay?
Lordship, if
we'll just direct the paperbooks to be prepared and all. What is the scope of stay?
There is a Lordship, there is a possibility that they might change the ROR in their favor because my title
that is beyond.
Lordship, my title has been brought into question by the learned first appellate court over the suit property.
What was your suit for? Eviction only?
Eviction and recovery of khas possession.
You did not seek any declaration of your title?
No, I have never sought for declaration.
No scope of stay. We stay the operation of the decree. The judgment is there is no scope.
Lordship, decree has been passed.
Decree has been refused. Ultimately, appellate court has refused to grant a decree for eviction.
Yes, appellate court has never.
No scope of stay. We'll record your apprehension and say why you are not granted. Learned counsel for the appellant, in support of the application for stay, submits that the appellants apprehend that on the premise of the findings of the learned first appellate court, the title of the plaintiffs may be disputed before other forums. However, since the matter is sub judice, we do not find any reasonable basis of such apprehension. Moreover, by the impugned judgment and decree of the appellate court, the eviction suit of the plaintiff has been dismissed. It may be noted that the suit was it may be noted that no relief of declaration of the title of the plaintiffs were sought in the suit, and as such, the observations of the first appellate court do not have any bearing on such title in any event. Next para, since the impugned decree of the appellate court has had the effect of dismissing the eviction suit of the plaintiffs, there is no scope of grant of stay. Accordingly, can 1 of 2025 is disposed of, however, directing the appellants to put in the requisites for service of notice of appeal on the
defendants number 1 to.
What the pro forma?
Pro forma starts from page.
Why are they made pro forma? You have made all of them no 1 to 3 only. Why are the rest pro forma? They did not contest.
Yes, no, 5 to 11 lordship are they were with me in the trial court, but they are not at party in the instant.
And what about 4 Chandidas?
4 is lordship. He was pro forma in the appeal, pro forma respondent. As I have just shown from.
But he is one of the defendants.
Yes, he was the defendant in suit. There
So
are
you have to serve on whom? 1 to 4.
1 to 3 lordship. No, no.
In the suit, what was the status of Chandidas?
He was the defendant number 1.
Then you have to serve on him. He is affected directly. You sought an eviction against him also.
Lordship.
So 1 to 4, you did not seek eviction against 5 onwards.
No, lordship. They were with me. They were the
Co-plaintiffs.
Lordship.
Or co-plaintiffs. You should have described them as plaintiff stroke pro forma respondents. You did not do that. And the description of 4 is wrong. You say pro forma defendant respondent. Should be the other way around. Anyway, shall put in requisites and postal costs for service of notice of appeal on respond numbers 1 to 4, in view of the pro forma respondent numbers 5 to 11 being co-plaintiffs with the appellants in the trial court, comma, service of notice of appeal on the said pro forma respondents is dispensed with. Next para, the trial court record shall be brought by special messenger at the cost of the appellants to be deposited within a week from date. The appellants shall prepare and file the requisite number of informal paper books without comparing with the records within 4 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Leave to mention the appeal for inclusion in the list before the appropriate learned single judge having determination as and when the same is ready for hearing. Thank you. What is your name, please?
Ravindra Kumar Pathak.
Well or good? Yes. He's your junior. Good training, Mr. Dhol. Yes. Yes. You're appearing before this court after a long time.
Yes, my lord.
But that does not mean you have a good case. What is the matter about?
My lord,
Why defective? First say that. Defective.
Maybe, my lord, the date has been wrongly mentioned, my lord.
2 defects.
2025, November.
Decree has not been filed. What about this? Why decree? What is the challenge against? Why FMAT?
My lord, because the suit was being disposed of in the preliminary stage, my lord. Because we filed up a suit for.
But then how can it be a misappeal? It has to be a regular
Yes,
first
my
appeal.
lord, regular.
You don't need any order for turn hearing. You are
Yes,
describing.
but
We'll direct you to effect the necessary correction in the memorandum and to declassify the appeal. The caption is right from original degree, but you have said FMAT that unnecessarily.
Original judgment has to be written.
You have to file the decree of the court below.
Yes.
That will direct you right now. And what is the other defect? Yes, that is also one of the defects, FMAT or FAT. Very well. The suit, the appeal has been erroneously described as FMAT number blank of 2025 in the memorandum of appeal. Leave is granted to the learned advocate on record for the appellants to carry out the necessary rectification in the memorandum by deleting the said statement. Just delete that FMAT. The rest is all right. Next para. Since the appeal arises out of a decree, comma, the same is required to be reclassified as a regular first appeal. Accordingly, the file be sent down to the department for reclassifying the appeal as a regular first appeal and to allot an FMAT number accordingly. Leave is granted to the appellant to mention the application for inclusion in the list as and when such reclassification is completed. Arekta line add kore din. Leave is also granted to the learned advocate on record for the appellant to will grant you that leave when the new number is given, because you have stated here FMAT number 69. Yeah. That can only be done when it is after the reclassification. It will go down, reclassified. Whenever it is reclassified, just mention We'll take the injunction application directly. Thank you.
Number 28.
আস্তে আস্তে করছি পীযূষ আস্তে আস্তে আমি আস্তে আস্তে করছি but I'm for the appeal.
Yes. Where's Mr. Ali laughing?
They are whispering ye Piyush da atke gache, that is Mr. Chaudhary.
He's at page number 24. So you're praying
So
for
on the last
as per
occasion,
instructions.
Mr. Mukherjee got stuck.
No, I assured them that I am doing it slowly. He will be on.
If he does not come, then it will be.
No, up to 3:30. I think not.
Achha. You will continue up to 3:30?
In all probability.
We release the matter on person. Must have known some of the parties. Either of us
As
must
per
know some of the
instruction, he
parties.
said like to pray for not today.
Since he has said Mr. Mukherjee, then it's binding. Binding on him.
Never, of course,
It's binding on him, therefore it's binding on us. So what is the appeal about? Just for
I'm
curiosity's sake.
challenging I am a trustee. According to Lord, the plaintiff's case, Lord.
No, this is an injunction appeal.
Lord, this is an injunction appeal, final order.
Mr. Ali is with you or without you?
Lord, he is opposing. I'm opposing. Now, Lord, Mr. Ali's client, Lord, took out, Lord, a suit for a declaration that by virtue of our non-attendance, Lord, in the 3 consecutive meetings, by virtue of the clause in the trust deed, which is a public charitable trust according to their own classification, Lord, I have been ousted as a trustee. So I have
They have been ousted. Or you have been ousted.
It is their instrumental. Now, Lord, initially the trust was formed in the 2012, where I was one of the settler. I was a trustee, settler, and there were, Lord, 6 other persons. In 2014, Lord, my learned friend's client were, Lord, added as a trustee because, Lord, 3 of the original trustees, they had retired. Now, Lord, this additional trustees who were inducted, they are, Lord, the plaintiffs in the suit, and which they claim that, Lord, the settler trustee and the other trustees who were originally there, they are no longer trustees. This is not the ambit of the suit.
So you dug the ditch for bringing the alligator in. Rough translation.
Yeah, that is, Lord, now
rough
they say
translation.
that I am out of not the entire. The trust, Lord, operates an educational institution. Now, Lord, the injunction that has been granted by the learned judge was that, Lord, I am not to intermeddle with, Lord, the affairs of the trust and not to operate the bank account. Lord, our defense, Lord, to their injunction.
It was a temporary injunction.
But there is a injunction granted, Lord, till disposal of the suit. So I am out of, Lord, the management, and I am out of, Lord, the financial mismanagement, even as they allege. Lord, that is as they allege.
That is the right.
Now, Lord, the points that we took in the trial court was, Lord, that, Lord, section 92 is, Lord, applicable. They cannot avail of section 34 of the Trust Act. And, Lord, since the trust properties are situated, Lord, outside the jurisdiction, the court doesn't have the jurisdiction.
92 is public.
Public charitable.
So this is governed by 92 according to you?
I have a different argument on that. It might be under the Charitable Endowments Act 1920. Because that is also where, Lord, the definition of court is there. But
yes.
That will be my eventual argument, because the learned judge will not return the finding that, well, section 92 doesn't apply. 34 does apply. And, Lord, because the trust deed contains, Lord, a clause which says that the trustees can change the office as well as the properties of the trust. Therefore, the territorial jurisdiction, Lord, the court does have. Trust deed said that that office of the trust will be, Lord, at Birbhum.
Birbhum, right?
Birbhum.
Yes. It's still there at Birbhum.
It's still there. All, Lord, the properties, the educational institution, all are there at Birbhum, outside the jurisdiction. It is all that out of, Lord, the parties, one of the defendant, they show their address to be in Calcutta and they file the suit here.
No, this is Murshidabad. District Murshidabad.
This will be Murshidabad.
Since Mr. Odhikari is there, it must be Murshidabad.
Yes, Lord, Murshidabad. Yes.
Yes.
The property is
Lord,
Properties in Birbhum.
Properties in Birbhum.
The trust and one of the offices is in Calcutta.
But that is not only their point, that they say that one of the defendant, Lord, stays in Calcutta. Therefore, Lord, the court has jurisdiction. Now, Lord, the court, if your Lordship kindly comes to, Lord, the finding at page, Lord, 10. Then it is, you're praying for an adjournment.
Till prayers for adjournment.
Final hearing.
We'll record an order and adjourn it for the day.
15 minutes.
When the matter is called on for hearing and arguments commenced, an adjournment is sought on behalf of the respondents. Full stop. Accordingly, let the matter stand adjourned for the day.
Great.
নাম ফামগুলো সবার একটু We'll give all the names, barring Mr. Chaturvedi.
Number 29.
My lord,
and charitably মধ্যে আনতে
we have came up, my lord, in regard to the rejection of our order 39 rule 1.
This is also defective. What is the defect? Let us see.
Defective, my lord.
Instant memo of appeal bereft of name of the learned trial judge.
Oh my.
You have to give the name of the learned trial judge. That's a defect otherwise. The name is not there in the order. Can you ascertain the name today or unless that is done? Without that, you cannot take up the appeal. If you knew the name, we could.
Indol Rai, my lord.
You are sure? Yes, a single name is there. So we'll grant you immediately liberty to carry out that. We'll do that and then take up the matter under order of attorney right now. There is a defect in the appeal inasmuch as in the preamble of the memorandum, the name of the learned trial judge has not been given. Leave is granted to the learned advocate on record for the appellant to carry out Oh, it has already been done. Sorry. Defect is removed.
Oh, it has been.
Sorry. We take up the matter. Yes.
My lord, we filed up the title suit in regard to the declaration, my lord, partition, and as well as, my lord, by injunction before the senior division, Medipur court, my lord.
You?
Yes, my lord.
Declaration, partition, and injunction. So partition suit, basically.
Yes.
Take the microphone a bit closer to you. Yes.
And then we filed up one order 39 rule 1 and 2, my lord.
Yes.
The fact was there, my lord. The fact of the case is that my predecessor named Hasna Begum, my lord. She inherited the property in 1965. But in that 1965, she was the owner altogether. Means long back she has inherited.
Right.
So in that case, my lord, the ROR records were also in her name also. In 2023, of a sudden, the ROR records were being changed, my lord. It came out directly to some Sukumar Poria, my lord. And it has been, when we find out that why the Sukumar Poria name has come up, we found out that he has purchased the property from one Gopal Samantu, my lord. And he is the son of Subhendu Samantu, my lord. In that, what it has been showed out, that Gopal Samantu has inherited the property from Subhendu Samantu. And in 1965, one deed was being executed by my predecessor.
1965 itself.
Yes, they said out. They said out that in 1965, one deed was executed in the name of Subhendu Samantu. And there in the deed, if we gone into that, we saw out a thumb impression.
But that deed was executed according to them by the same your predecessor.
But we did not. That was not been executed.
No, as per their case,
their
it was
case. Yes,
told by, what was the name of the lady?
Hasna Begum, my lord.
So according to them, Hasna Begum herself sold.
Yes, my lord.
Very well. So thumb impression, yes.
But that was a thumb impression in the sale deed, my lord.
Yes.
But Hasna Begum was an educated woman. Even in cases that was later been done in 72 in other cases, she has put up the signature. Never she had used out her thumb impression.
Signature, she used her signature where? In pleadings?
Cases, executing cases also. But she never used out a thumb, my lord. She was an educated lady, my lord. Now, Subhendu Samanto from 1965, if he has shown out the purchase, till 2023, never he has obstructed the possession of Hasna Begum and the that is title interest which have come up after her.
You are the heir of Hasna Begum?
Yes, my lord.
When did she die?
When she died? Hasna Begum?
Because Hasna Begum did not file this suit.
No, my lord.
You must have inherited after her demise.
Yes, so she was the predecessor of us.
Obviously, yes. But if there is a sale deed and you are seeking, you have to seek a cancellation of the sale deed.
There is a cancellation also, my lord. In
That prayer has also
cancellation
been.
there.
Oh, you have also prayed for
Yes,
cancellation of that.
cancellation.
Why was injunction refused?
Well, the reason was there in regard to that deed which was executed. This Gopal Samanto has executed a deed in favor of this Sukumar Poral, my lord. That is the reason it was taken, but it does not take out the deed which was being challenged, my lord. On that basis of the challenge deed, he find out a prima facie. The learned judge.
There is a presumption of correctness attached to a registered deed of purchase. He's right on that. Unless you prove by evidence that was.
My lord, the ROR record can be seen, my lord, in page number 150.
ROR record. What ROR? LR?
It was LR as well as RS all were in our favor till 2023.
So if the purchase
in 2024, it was straightaway came up in the name of Sukumar Poral. But what they had sold out, Sukumar.
When did Subhendu sell to Sukumar?
According to them, Subhendu never sold out.
No, how did Sukumar?
Gopal has sold out. Gopal
was Gopal. What does
Subhendu has sold out, but he is a Subhendu.
Subhendu acquired in 1965. How does it come to the defendant according to them? Where does Gopal drop in from?
Malad, it can be can it be kept out tomorrow, Malad? Until today, just now I
Gopal has changed the picture.
Let me come out with a brief, Malad. Tomorrow I'll come out with this matter, Malad.
On the prayer of the appellant, the matter is adjourned for the day. You resolve between Subhendu, Gopal and this defendant. Yes, Mr. Chaudhary.
I was placing the award of the arbitrator pursuant to my lord. That is, my lord, volume 4.
Volume 4.
At page 808. While placing the award, I had shown your lordship, my lord, the submissions which were made. The award starts at, my lord, page 786. And my lord, I had placed the submissions, my lord, to show, my lord, what was contended. And even before the second arbitrator, my lord, the same void argument was repeated.
Yes.
And then, my lord, where we parted yesterday, that we were at page 808. I have shown, my lord, the earlier division bench order was quoted.
Section 9.
Quoted by the arbitrator. And then at page 808, my lord, this is the summary made by the arbitrator based on the observations of the division bench. Upon paragraph 39. Upon reading the aforementioned observation of the Honorable Division Bench, the following factors stare loud and clear. They are that Star Trek is not entitled to remain in the said premises or utilize it or earn occupation charges and or rent by subletting the said premises, and that too after termination of the license agreement. That Star Trek does not and cannot have an independent right in respect of the premises in question. That Kolkata Port Trust, by a subsequent development on 23rd June 2015, has executed a fresh deed of lease in favor of Efcalon or claimant, leasing out the premises to them for a fresh period of 30 years with effect from 4th August 2003. Under these circumstances, Star Trek has no authority to say that Efcalon had no right to license out the said premises. If this were the case, then there would have been a dispute between Kolkata Port Trust and Efcalon. But instead, the former Kolkata Port Trust has extended the lease for a fresh period of 30 years with effect from 4th August 2003, which means that the lease with Efcalon is subsisting at least up to 2033. So, my lord, this is the summary of facts based on, my lord, the observations of the division bench. Now, my lord, one thing lordship will note, I have shown your lordship, The contention raised before the second tribunal was twofold. Number one is the reiteration of that void.
Null and void.
And my lord, number two, which is very important because that takes away the entire sting out of the argument advanced here also, that I came via the document, I was put in possession, but because you, for your misrepresentation and your the agreement being void, I am continuing in possession, but I am now claiming I have become a direct tenant under KOP. Now, this theory, my lord, cannot stand because, my lord, good, bad, indifferent, the port has given the lease subsequently in my favor. And it is there till 2033. And, my lord, now barely 8 years remain. They have, my lord, consumed, my lord, by being in wrongful possession from 2010. In fact, my lord, this is, of course, not here, but subsequent. When they come to know of the lease, they have filed a suit also, my lord, challenging the lease by Kolkata Port Trust, saying that it's collusive, this, that, and all.
Kolkata Port Trust lease to FKLON that they have challenged.
Yes. Here they are saying that they are tenants under Port Trust. Over there they are saying, my lord, they have challenged it that, my lord, Port Trust has colluded with me. But it is, since they are in possession, my lord, any defense, my lord, is justifiable so far as they are concerned. But, my lord, kindly comes to para 43. It would be relevant to mention here at this stage that the respondent may have been a lessee or a licensee or a tenant under the agreement dated 26 December. It derived benefits out of the said agreement so long as it was necessary to be done. Kolkata High Court judgment. But the moment it started inducting occupants for monetary gains, it not only went against the spirit of the agreement, but also took a strange action by raking up a preliminary issue before this proceeding, claiming that although it had always acted upon the said agreement, it was not estopped from challenging it subsequently or challenging its validity. It also went on to challenge the agreement, saying that it was not registered and stamped. It cannot be enforced as a piece of evidence. In my opinion, the respondent is legally not permissible to take contradictory stands, having elected firstly to accept the agreement and be bound by it, and then attempt to take a completely different stand by submitting that the said agreement is not enforceable. This is well-known concept of law based on the principles of election. My lord, what fell from your lordship yesterday? I said that it is already noted because we had cited, namely that no party can accept and reject the same instrument. In fact, what the respondent is attempting is that it is seeking to approbate and reprobate in support of the aforesaid proposition. A judgment of the Honorable Supreme Court in the case of Karam Kapahi may be looked into. In the said judgment, the apex court has explained and not taken note of the principles of election as expressed in Treaties Equity, a course of lectures by F.W. Maitland, University of Cambridge, 1947, saying that the doctrine of election may be stated thus: that he who accepts a benefit under the deed or will or other instrument must adopt the whole contents of that instrument, must conform to all its provisions and renounce all rights that are inconsistent with it. This principle was again explained by the apex court in the case of Nagubai Ammal versus B. Shamarao, reported in 56 Supreme Court 593, wherein their lordships have observed that the doctrine of election is not, however, confined to instruments. A person cannot say at one time that a transaction is valid and thereby obtain some advantage to which he could only be entitled on the footing that it is valid, and then turn around and say it is void for the purpose of securing some other advantage. This is to approbate and reprobate the transaction. From the judgment of the Honorable Supreme Court in the case of Karam Kapai, as referred above, their lordships, while referring to Nagubai Ammal's case, have also briefly noticed Halsbury's Law of England, volume 13, in which principle of approbate and reprobate has been described as a species of estoppel, which seems to be intermediate between estoppel by record and estoppel in pies. This, therefore, is a universally accepted legal principle which creates an embargo upon a person or an entity not to turn around and agitate any matter after availing an advantage from the same transaction. Another principle of law squarely applicable in the facts and circumstances of this case is the principle based on the doctrine of allegens contraria non est ordinus. He is not to be heard who alleges things contradictory to each other. What we colloquially say mutually destructive.
Yes.
This elementary rule of logic, which is frequently applied in courts of justice, was explained clearly by Lord Kenyon, that a man shall not be permitted to blow hot and cold with reference to the same transaction or insist at different times on the truth of each of the conflicting allegations according to the promptings of his private interest. Well, this is the language from the Broom's legal maxim. In my view, in view of the aforesaid reasoning, the other submission of Mr. Mukherjee to the effect that all observations of the learned arbitrator passed earlier were not interfered with are submissions which have been made in futility, and similarly, the arguments to the effect that this arbitration proceeding can only enter upon and decide the question as to who would be entitled to take occupational charges and cannot enter into any other sphere are, if I may say so, totally misconceived and devoid of merit. Mr. Mukherjee has referred to a judgment of Honorable Supreme Court passed in the case of Satish Kumar versus Surinder Kumar, AIR 1970, Supreme Court, in support of his contention that after pronouncement of an award, no action can be started on the original claim which had been the subject matter of the reference. He refers to paragraph 8 of the said judgment and submits that since this arbitration proceeding is limited only to the extent of finding out as to who is entitled to occupation charges as submitted by him earlier, it cannot go into the original claim which had been the subject matter of the original reference under which the first award had been passed. For the same reasons given above, this judgment cannot be made applicable in the facts and circumstances of this case, and that too after the award has not only been set aside, but has been done so after recording strict observations against the respondent. Similarly, the submission that save and accept the dispute with regard to payability of occupation charges, all other matters were left untouched, cannot also be accepted, especially after the observation of Honorable Division Bench and also taking into consideration the subsequent event of extension of the lease in favor of Efcalon for a further period of 30 years. Mr. Mukherjee then relied on a judgment of 2010-1 ALR arbitration law reports in Messrs. R.S. Jivani versus Iron International Limited. Ircon International Limited. He referred to para 7 and internal page 32 thereof for his contention that judgment delivered by division bench has to be interpreted on severing the same by firstly taking into consideration the portions which are in favor of the respondent and portions which are against the claimant. Merely because the division bench has set aside the award would not mean that the other portions of the award made in favor of the respondent which uploads the factual finding should be ignored. The severed portion which they are trying to say is that, my lord, as if the void and voidable finding of the erstwhile arbitrator remains.
Yes.
And, my lord, the only issue is that whether I am entitled
Occupation
to who is entitled.
without occupation.
This is again a mutually destructive plea because, my lord, if that finding remains, then I cannot be entitled to. Neither can they be entitled to. So who is entitled? That is why, my lord, they build up their alternate case that they have become tenants under Kolkata Port Trust. Which case is soft pedaled before your lordships here because, my lord, they know that was only a way out. So, my lord, these have been dealt with. In fact, my lord, somewhat strong words have been used by the learned arbitrator, para 53. Such a submission can only be termed to be ludicrous. Neither an arbitrator nor any litigant or any parties to arbitration can be said to be vested with the authority of severing a judgment delivered by the Honorable High Court to suit their own interpretation. In the instant case, award was set aside with severe strictures upon the respondent. It cannot be allowed to continue in occupation on somebody else's property, and that too without payment any charge. The observation therefore sealed the fate of the respondent, and we cannot embark upon a process of fishing out portions of judgment and say it cannot be made applicable. Well, this controversy has been put to an end. I have shown your lordship the division bench order in the Section 9 appeal, in the 37 order arising out of Section 9, that once the award has been set aside, you cannot rely on portions of the award, because well, the same line of argument was advanced.
Mr. Chaudhary, one question is troubling us. I mean, yes, we understand your argument that even if regarding registration, Mr. Mitra has argued that registration cannot be waived, no estoppel against the law. And we find from the arbitrator award that even if it was non-registered, unregistered, then it's a monthly tenancy as per judgments of courts and the sections of the Transfer Property Act. Now, Mr. Mitra made an argument. We put a question to you. You gave an answer. I'm telling you why there's a doubt. The question was that, yes, if it's a tenancy under law and under judgments of Supreme Court, it's a statutory tenancy. Monthly tenancy becomes statutory, not contractual in terms of this lease. Now, therefore, the arbitration clause contemplates disputes arising out of this lease deed, and therefore, why should this be arbitrable at all if it arises from a different jural relationship, a statutory relationship? You gave an answer probably in the passing that yes, it's well settled now that an arbitral clause can be segregated from the arbitral agreement. It's not that exactly. Suppose it can be segregated. Even if non-registration vitiates that lease deed as a lease deed, the arbitration clause survives. But still then, what is now in dispute is not on the premise of that contractual lease, but on the premise of, we take it all along that this arbitral clause survives independently. But now the dispute relates to not to that contract, that lease deed, but to a separate statutory jural relationship, regarding which this arbitral clause does not apply, because this applies only to contractual dispute.
I join issue, my lord, slightly different.
Yes.
What fell from your lordship?
Yes.
My lord, once it is admitted that I come in possession qua this document, and this document has an arbitration clause, any dispute arising between us, either, my lord, regarding validity of the document or otherwise or any other way, my lord, it has to be, and the arbitration clause, that is why, my lord, it has been made independent and separate. Because let us assume their contention can be said to be correct, it is void. Who will decide this? The arbitral tribunal will decide. And that is what they exactly did or tried to do before the erstwhile arbitrator.
So the moment the arbitral tribunal holds that it's a statutory right, even if it's a statutory jural relationship, that also involves the interpretation of this agreement.
Yes.
To say that this does not create the right, or
because, my lord, statutory relationship is only for the purpose of severance and or for the purpose of, my lord, making a distinction in law as to whether it's a statutory protected tenancy or it's a tenancy under Transfer of Property Act. My lord, all leases,
yes,
all leases are contractual.
True, but then it's not this contract.
No, I am formulating.
There has to be an underlying contract.
All leases are contractual. What the statute does so far as 106 is concerned, or 105, my lord, lease, the definition and all that.
5-7 years.
Lord, it is making a distinction vis-a-vis the period of lease and vis-a-vis the termination process which is available to the parties. Number one, depending 106, lordship knows, my lord, if it is for manufacturing purpose and other purposes, my lord, there is a 6-month period of notice. Other purposes, it is 15 days notice. So, my lord, it is because, my lord, even a lease under 106 termination is presupposing, and that is statutorily ingrained, that there is a jural relationship between the parties, which is, my lord, the initiation is contractual. It is not that, my lord, a trespasser can come and sit and say that I have become a contractual lessee, I have become a statutory lessee under the Transfer of Property Act. What is happening here is that if it is an unregistered lease, there is a contract. There is an embargo in law in relying upon the terms of the document. But Millard, we now, it is well settled for the purpose of quantum of rent and all that collateral purpose, it can come. So Millard, there is that you can't rely on the, you cannot rely on the terms and conditions, but an arbitration clause has been severed from the main document to say it stands on an independent footing, because any dispute arising of that document, it has to go to the tribunal which the parties agreed. Otherwise, my lord, what is falling from your lordship or what is troubling your lordship, the situation will be that when it suits my favor, I go in the agreement and take the advantage and I be in possession. Then I turn around and say it is void.
No, it's not they are taking advantage. The tribunal itself is proceeding on the premise that
Correct.
even if it's
And
unregistered.
tribunal is proceeding on the basis that, my lord, that is the law, my lord. Yesterday I cited.
And Mr. Chaudhary probably have another additional point. I mean, you can develop on that. No, Section 7 of the Arbitration and Conciliation Act contemplates a contract, written contract, but it also uses the expression legal relationship.
Correct.
That is also there. So it's wider than merely what is emanating from that contract itself. Because the language of Section 7 is, don't have that.
Lordship will kindly have a look at, my lord, Justice Sen's order once, my lord, of 5th June. The arbitration proceeds on the consent. My lord, when at the second tranche, my lord, when this was done, it is done on the consent. That, my lord, I'll just read out, my lord.
Is it there in the paper books anywhere?
Yes, my lord. Page 249, volume 1.
Volume 2. 249, volume 1 does not contain 249.
It may be. My lord, I am
What is wrong? The page or the volume?
Volume 2 it.
Yes.
This application for appointment of an arbitrator arose.
We have it underlined in red by your predecessor in office, chair. There is no dispute that there is a valid arbitration agreement between the parties and the disputes are arbitrable. Yes.
Then, my lord, after there was a review preferred which was dismissed. That's the order of 5th June, which is at page 764. It a volume table.
That was on this ground that we did not agree.
No.
On a different ground.
On a different ground. Review, my lord, that it is a fresh reference. And we are not agreeing, my lord. They tried to change, my lord, their consent.
So what, that review was rejected?
Yes. It was rejected, my lord. Kindly see at page 764, the order starts. Let second paragraph. An argument is advanced on behalf of the petitioner that the learned counsel representing the petitioner without any authority has conceded to the appointment of an arbitrator, and the said order cannot bind the petitioner. Mr. Mitra Learned, senior counsel appearing for the petitioner submits.
Just give us the volume number.
Volume 4.
You just read it out because we are tired of volumes.
Argument is advanced on behalf of the petitioner that learned counsel petitioner without any authority has conceded to the appointment. The learned senior counsel appearing for the petitioner submits, in the absence of any specific direction passed by the Honorable Division Bench while setting aside the award of the arbitrator, and that the arbitrator shall hear the matter afresh, or that the matter is remanded for a fresh adjudication, no application under Section 11 of the Act is permissible, as the arbitration agreement has merged in the award. The learned senior counsel, in order to impress upon the court the proceeding has attained finality, there is no fresh dispute which can be adjudicated, and hence no appointment of an arbitrator could be made as relied upon a judgment of the single bench in Shakambadi. Then, my lord, I skip a few lines. It is submitted that the arbitration agreement has merged with the award, as all disputes have been decided and nothing more remains. This argument is based on the observation of Sudhir Kumar Shah. Then, my lord, all these are considered. Then, my lord, our arguments are considered. Let kindly come to page 769. The challenge to the validity of the arbitration agreement is based on the assumption that by reason of the award being set aside by the division bench, with no observation with regard to remanding the matter for a fresh adjudication, perishes the arbitration agreement, is misconceived and untenable in law. If that interpretation is accepted, then it would result in miscarriage of justice. Therefore, the division bench was alive to the problem and has accordingly exercised its jurisdiction in passing an interim order after dismissing the application for setting aside of the award in contemplation of the arbitration proceeding. The validity of the arbitration agreement is not in dispute. The finding of this court that the arbitration agreement is valid is not on a concession. The concession is only with regard to the exercise of jurisdiction by this court to nominate an arbitrator. It is difficult to accept that the argument was advanced by the learned counsel unconscious of the earlier orders passed in this proceeding. The earlier order denying appointment of an arbitrator by reason of pendency of the appeal also cannot come in assistance of the petitioner at this stage. And my lord, review was dismissed. My lord, it is... My lord, one thing lordship will also consider, there is another fallacy in this line of argument. When an arbitration proceeding comes to an end, moment an award is passed. Now, if the award is set aside, that arbitration proceeding, my lord, revives. My lord, why I am saying this? Because a line of argument or an argument, in fact, has been advanced that you can't take advantage of section 36 of the Stamp Act because it has to be in the same proceeding. The proceeding before the second arbitrator is not the same proceeding as the proceeding before the first arbitrator. And my lord, I have shown, my lord, what was the submission here, that I can take inconsistent stand because this is a different proceeding. My lord, that with respect can't be. Because, my lord, arbitration proceeding comes to an end on passing of an award. When the award is set aside, it is the same arbitration proceeding which revives. Otherwise, my lord, for the purpose of limitation, it will create, my lord, a bizarre situation. Section 21 notice is given. Arbitration initiated.
In that event, Mr. Chaudhary, was 29A in operation then when this?
No.
It was not
no.
there.
29A was not in operation.
So therefore, it could not be brought in.
Correct.
So 11 was in. But the moment you take out a section 11, it's as if it's a new.
But section 11 is taken out not because it is becoming new. Section 11 is taken out because the earlier arbitrator had expired.
Oh, right. In your case, he had expired. All right. Yes.
Mr. Raichodhuri, who was the earlier arbitrator, he expired. That is, and then the rules, the section 14, read with section, same procedure as original.
The rest come into play. Yes. Section 14, 15 are there.
14, 15 and those.
All the principles, even after 29A was introduced, the same principle.
So we failed to agree the same procedure because it was a named arbitrator.
It has to be taken up from there.
We failed to.
Was it taken up from that? No, it could not have been because the award was set aside.
The award was set aside. Fresh set of pleadings were required because, my lord, we couldn't get hold of the origin after his expiry from his house or from the records of the.
Nothing was required.
Yeah, other records could not be, my lord. Usually, my lord, if the records are available, my lord, no fresh pleadings were required. But, my lord, since no records were there, my lord, and the other method.
There were changes in the pleadings.
Yes, the parties changed. Before the erstwhile arbitrator, I mean, the status of the parties changed. From claimant, they became respondent. Right. We were the respondent with the counterclaim for eviction.
But then you cannot say it's a continuation of the same proceeding in that sense.
Well, it's a fresh reference of the same proceedings.
Yes, but the claimant becomes respondent and vice versa.
Yes, in any, even, my lord, under 23A, in a counterclaim, where I am a counterclaim, it is to be treated as my plaint. That is also, my lord, as per Civil Procedure Code.
No,
it is not that, my lord, I have claimed anything different.
But you remain a respondent all the same. I mean, the claimant, because unless there is a transposition.
Yes, because, my lord, since the records were not available.
There's a continuation of the same proceeding. It would require a transposition for the plaintiff to become a respondent advisor.
Since the records were not available and they were not willing to, my lord, reconstruct or rely on old records, we had to file our claim.
But in any event, the counterclaim remained the same as the claim in the original proceeding.
Correct.
So therefore, the premise
remained the same the defense also remains the same.
Same.
What was their claim become, my lord, they become wiser in the sense they no longer ask for a declaration or a counterclaim here. They take it up only by way of a defense and not by way of an offense. In the earlier proceeding, they had taken it up by way of an offense, in the sense, I want a declaration, which they were successfully managed
They
to
asserted.
get.
They
Yes.
were, now you are the respondent there previously. Now your counterclaim, now you make it a claim.
I make it a claim, I proceed. Well, it is like this, if I may say so, that if a plaintiff comes and withdraws the suit, then, my lord, the defendant becomes the position of the plaintiff, my lord, as so far as counterclaim is concerned, and the suit is not, my lord, dismissed,
Yes.
it carries on.
Yes.
Before the arbitrator, because of the peculiar situation that the erstwhile arbitrator expired, my lord, I asked for the self-same reliefs, but, my lord, I had to claim or assert.
There have been cases where we have transposed defendants
Correct,
to the
correct,
position of plaintiff if the plaintiff relinquishes.
Correct.
Say it's a partition suit, or not even a partition suit. If the defendant, some of the defendants have a case equal to the similar as the plaintiff, they can be transferred and they can continue the suit. So here it's better for you. I mean, you had that counterclaim all along.
Well, because, well, what is the fallacy in the argument of a fresh proceeding is, well, then section 21 will be rendered otious, because
Yes,
after
there has to be a new section 21.
after 14 years, then, well, everybody will say, and the claims will become barred by limitation. Because, well, giving a reference that you agree to a new arbitrator, so far
No,
as section 11 is
time bar may not come in because of section 14.
no,
Limitation.
not only section 14, Miller, it's the same section 21. When for the first time did we refer to the disputes arise?
There was no fresh section 21.
No, the letter is, well, the letter Lordship will find at page 177, volume 1. Yeah, একটা copy দে।
Yes, yes.
This is to inform you, my lord, we are writing to Star Trek. Pursuant to the order of 6 December 2014, award passed by the learned arbitrator dated 22nd April has been set aside by the learned 10th Additional District Judge Alipur. Under the circumstances, we hereby call upon you to select any one of the below named arbitrator for adjudication of dispute and differences that have arisen between us under the agreement of 26 December.
Yes, yes,
There
right.
the 3 names are given.
And
We call upon you to consent,
Yes.
failing which we shall be constant.
In the interregnum, the erstwhile arbitrator had died.
Yes, yes, that is why it will.
Very.
And, my lord, we have a judgment, my lord, again, my lord, we'll give it in the ready আছে দুটো সেট আছে দিয়ে দাও তাহলে।
No, we can. That is the judgment.
No,
We'll
no.
take it.
Well, Lordship had asked on the last day to prepare a compilation, so this is
Of what?
of the judgments.
Oh, yes. We had asked.
Well, in fact, এত মোটা কেন দিচ্ছ ভাই, আমি তো এত দেখাইনি।
Mr. Chaudhary has hit the nail on the head.
Well, I shall indicate on the last day I had cited the division bench judgment of Chief Justice Sanderson and Justice Ashutosh Mukherjee.
Yes, yes.
On the limited point.
So you will give the citations with your written notes of argument.
Very good.
Do that.
Well, I had relied on AIR 1917 Calcutta 498. Yesterday.
Yes. Anyway, it will be in your.
Yes.
Yeah, we remember that you relied on it and placed the judgment.
Today, my lord, I am only citing one judgment vis-a-vis this point, which is of the Bombay High Court. That, my lord, when an award is set aside, and, my lord, if it goes to a new arbitrator who starts it, it is not a fresh reference; it's the same arbitration which continues. I just read out, my lord.
That has to be because, Mr. Chaudhary, we cannot remand under section 34. We cannot remand.
Correct.
So unless that proposition is brought into play, I mean, it will be a chaos.
Firstly, 34 court, other than setting aside, my lord, cannot do anything.
Modify it, demand.
Now it's modify. It cannot send it back. Now, my lord, what happens is, since the Arbitration Act says that the arbitration proceedings gets terminated once the award is passed, but the award getting set aside, it is not terminated. That proceeding revives.
Exactly.
And my lord, that continues. Now, of course, we will have that, my lord, 29A problem which Lordship was thinking of, but this, my lord, and that is why Lordship will not find that the argument over there, my lord, they did not oppose that also. And now to say that after getting an award on the basis of the agreement, to say that it is void and therefore there is no arbitration agreement, that is where, my lord, approbate and reprobate principles were
We are not so much on the stamp act point because Mr. Mitra was also reluctant, to press it further. But registration is an issue, but registration we have already discussed immediately before.
But registration, my lord, that the recital of the license agreement itself says that because we did not have a lease, they agreed to take it on license. That if you have the lease, then we shall agree whether we want a sublease or not.
Right.
So now you can't turn around, and this is recorded in the document, by virtue of which you come into possession. You can now turn around and argue that it is a lease, registration, section 49, all these arguments.
You have bound them from all sides. If they say it's a lease agreement, unregistered lease agreement, then statutory relationship. If it's a license agreement, then it's not
But
required to be
in fact,
registered
my lord,
or stamped.
after the division bench judgment,
And if they say it's a null and void document, then also 64, 65 come in.
64, 65, my lord, this is the interpretation and it is holding field. Division bench of our court is saying, quoting the English law, that if you say it is void, for the court to hear you, you have to first give up possession and then come and say that before the court.
That was said long back when the standards were much higher.
Well, unfortunately,
Now nobody would go out and.
Well, this aspect, my lord, this aspect has not been highlighted in, my lord, modern day judgments. My lord, this is the principle of 64, 65, and, my lord, yesterday we
Nullity, Mr. Chaudhary, we are not very keen on accepting the nullity ground in any event because nullity is barred by section 116 of the Evidence Act. They cannot say because nullity is on that ground only that you did not have the
the division
the
bench
right
of
to transfer.
The division bench of the Calcutta High Court is saying under 116 only.
Yes.
That if you say it's a nullity or you are challenging, my lord,
So you have to relinquish the relationship.
Yesterday, that Kalidas submission that I was making, it is.
That is very stringent. That says you have to go out and do it.
Correct.
And even otherwise, if you take it otherwise also, you have to relinquish the juror relationship then.
Correct.
Before you challenge the title, what the court meant was in today's world, we'll be probably saying that you relinquish the juror relationship between yourselves, which tantamounts to going out of position.
In fact, the language is, I'll just read that language again.
It is just short of get out.
Yes, my lord, let me say, my lord,
just short of get
a
out.
better way of saying that.
Yes.
Now, in my judgment, the plaintiff was entitled to obtain a decree for possession of the land because the learned subordinate judge had found in favor of the plaintiff in respect of the tenancy and in view of that finding. In my judgment, the defendant was not entitled to set up his title against that of the plaintiff without, in the first instance, going out of possession and restoring possession which the plaintiff had delivered to him by means of the tenancy of 1910.
Yes.
This principle was laid down. Well, I have a one.
No, need not. Yes. You are sufficiently crisp.
This principle was laid down so long ago as 1832 by Chief Justice Tyndall in the case of Dodem Manton versus Austin in these words. The principle is that a tenant shall not contest his landlord's title. On the contrary, it is the duty to defend it. If he objects to such title, let him go out of possession. Let him go out of possession.
Yes.
So, my lord, in fact, my lord, this is.
You place this, yes.
Yes. But there is one more line, my lord. My junior thinks it is of better language. It is not a matter of mere question of form whether the person who has been a tenant should be the plaintiff or the defendant in a suit to establish the title of one or the other. It is a matter of substance. And in order to show that one may take as an example a case which is by no means unfrequent, where two parties are claiming title to certain land and both parties have considerable difficulty in producing strict proof to the title of land. In such a case as that, possession is of great importance because the party who is in possession of the land has great advantage in such a suit. For unless the party who is out of possession can satisfy the court and discharge the burden which lies upon him to prove he has got a good title to the land, the person who is in possession remains in possession of the land. That is why, my lord, I started by showing the initial pleading. They admit that I was in possession. And being in possession, I gave it to them because I couldn't get a formal lease executed in my favor as a license. So both counts, Lordship, look at it. My lord, it
Yes.
doesn't. And my lord, it is in this principle. Now, if Lordship comes back to the award, my lord, from para 54, these are our submissions. My lord, kindly
Yes, yes.
straight away come to. Yes. 54 is my submission. 55 is the finding. Internal page 5 of the agreement, running page 24, would show that in the absence of a formal renewal of lease and upon being approached by the licensee, the licensor had granted a license only for a period of 6 years. Commencing from 1st August, period of 6 years with effect from 1st August had lapsed, and in any event, there having been no further renewal, the claimant is certainly entitled to recovery of possession. So, my lord, this is the first finding vis-a-vis the license, that even the period has lapsed. On a similar consideration, even assuming that the case of the respondent is accepted to the effect that agreement is null and void, well, this is assuming but not admitting type. Similar, even assuming that the case of the respondent is accepted, that the agreement itself is null and void, even the same cannot be so treated, especially in view of the observation of the division bench. In any event, it is now clear upon a reading and understanding of the judgment of the division bench, if the claimant had no right to license out the property, then similarly, the respondent had no right to be in occupation thereof, and that too after expiration of the period contemplated in the agreement. Moreover, the observation of Honorable Division Bench would clearly go to show Lordships became conscious and took a judicial notice to the fact that the earlier arbitrator had committed a fundamental error in not directing respondent to restore status quo ante from the time it had been put in possession. Then, my lord, again, our submissions have been referred to. Para 59 is the finding in response to that. Para 5D at internal page 5 of the affidavit in opposition would show respondent itself has submitted that the claimant had no right, title and interest in the suit premises and their status was that of an interloper. If this submission is to be accepted, then once again what must be borne in mind that even then the respondent proceeded to take possession under the agreement dated 26 December and paid the agreed rent to the claimant in terms of the agreement till end of September 2010. This again takes me back to the well-known concept of law that a person cannot be allowed to blow hot and cold in the same breath in respect of the same transaction. Then, my lord,
if interloper, if 60 says interloper,
Correct,
then
correct.
64, 65.
Then, my lord, section 60 is the submission is accepted because of 64, 65.
Yes, yes.
Then, my lord, 61, para 61, I am inclined to agree to the
Also
submission of Mr. Chaudhary in terms of the provisions of section 116.
Right.
Of the Indian, I'm sorry, my lord, this should be the
Should
Indian
be
Evidence
evidence.
Act.
Yes, right.
A tenant or a licensee is restored from denying the claimant the right to immovable property, even if the agreement under which it is claiming is alleged to be voidable or what. And then, my lord, it is allowed. My lord, I shall give, my lord, the two judgments, that is the division bench of Calcutta.
We'll request you to file a short written note of argument. We cite your judgments with that.
My lord, the judgments which have been cited by them are all on the grounds of unstamped, unregistered. It is, and my lord, it proceeds on the basis that, my lord, section 36, whether it will apply or not apply.
Yes. But Mr. Haq, on the when you give a rejoinder, just please indicate clearly out of this, Mr. Mitra only relied on some,
Yes,
very few.
Yes.
So just please just in your written notes of argument, just indicate those judgments. We'll keep this compilation, we'll refer to those judgments only. There's no necessity of, yes, need not file these judgments all over again. If they're part of this,
If it's not there,
not there, then give it. Right.
Great.
So, my lord, the unstamped, my lord, argument is, my lord, firstly, my lord, it is the same proceeding and it was already exhibited before the arbitrator.
Yes.
Erstwhile arbitrator. Second, my lord, the judicial relationship, whatever, my lord, whether you call me a landlord, you don't call me a landlord. Once you admit that by virtue of this document, I have come into possession, my lord, you have to first hand over possession. So, my lord, whether it is stamped or unstamped, my lord, that argument because of section 36 will no longer be available.
Stamp is no longer available.
Yes, same proceedings. Well, assuming it can be same proceeding. Registration, no application because it is not a lease for the simple reason that recital is the answer. You knew that I did not have the lease, so you consciously took it as a license with the agreement that once I get a lease, parties will agree whether they will take it as a sublease or not. That is the understanding in the recital. So, my lord, neither principles of Registration Act which was argued are applicable, not the Stamp Act. Now, my lord, so far as, my lord, what is troubling your lordship, 106 being a statutory, suppose it is assumed to be a lease. 100, because, my lord, the arbitrator has gone on the finding it is a license, the period has lapsed, so period has gone. My lord, suppose it is, my lord, 106, my lord, my respectful submission is all cases of 106 are, my lord, a contractual tenancy takes the shape of a statutory one because the mode of termination becomes different.
Whether it's the same contract as reflected in this lease deed, that is the question.
My lord, it can't be any other. Because, my lord, that is why I said for them to, because they have admitted, I showed the pleading that I have come into possession by virtue of the agreement of December 2003.
If you accept your license argument, then everything goes.
But I am trying to argue that
this is over and above.
The best possible case which they may have.
Yes, yes.
Well, if they, well, then they would have to show that I have not come in possession qua this document. I have come in possession qua something else. Then I have become a tenant from month to month under the Transfer of Property Act. That is not their case.
And even then, it's an interpretation of this agreement is necessary, even to say that it is not this agreement by virtue of which you have come, by which you are a tenant, but it's a monthly tenancy. But it flows from that agreement, from interpretation of that.
Even to test their best possible case of void or voidable,
it has to be interpreted.
You have to see that you represented. What is their case? They represented to me they have a right which is recorded over here. Later on, I found out whatever is recorded in the agreement is not correct. Therefore, it's a misrepresentation, therefore void. So, even to test their case, you will have to look into the agreement.
Yes.
And that is what the erstwhile arbitrator did when they got an award in their favor. So, that is why, my lord, the arbitrator, the second arbitrator here has referred to, my lord, the doctrine of approbate and reprobate and doctrine of election. And you can't do that. Those are my submissions.
May I come back? Mr. Mitra will be there. We'll have to just tell him, Lord, tomorrow it's anyway fixed for Lord, the part heard matters to be taken up tomorrow. Lord, we'll just
hard in part for further hearing tomorrow.
Deeply obliged.
Tomorrow, just please convince Mr. Mitra to be short.
My lord, I shall.
We have failed to do so, but you have to do that.
My lord, I shall do so.
Because we'll deduct points if it exceeds a particular time limit.
I shall
according to our own arbitrary notion of time.
I shall inform him.
Be very short and give a rejoinder, and we'll give you a time for filing written notes of arguments as per your convenience. Both. Thank you. কালকে আবার থাকবে মিত্রকে আমরা সামলাতে পারবো এভিকশন যদি করে
I'm sorry, my lord. I detained your lordship. I also lost track. There was a 3:30 today.
No, we continue nowadays because of the heavy pressure of matters.
No,
we continue. If parties agree, one of the parties don't come, then we don't press it.
It's easier for us, my lord, if it goes.
Yes, exactly, sir. Chaudhary, you have to retain it in your mind. Other matters cannot. You cannot take up other matters. We cannot take up other matters.
Even if I take up other matters, I can't be physically present. I have to
That
finish.
too. That too. What call? Both side na thake na. Mr. Jain, if both sides are yes, then you can take.
May I start, my lord?
Yes, yes, absolutely, you may.
Very.
We would love you to start and end today.
Yes, yes.
Because please don't repeat whatever has been said. You understand the usual rider.
No, my lord, I understand.
Whatever you have to add, you add.
Yes, yes.
And in your written notes also, you will just add, the addenda will be there only.
I will only supply.
And you please coordinate between yourselves. The respondents, please coordinate while filing the written notes. That's my request, our request.
Yes.
Coordinate and don't repeat submissions. It becomes very cumbersome for us when we pass the judge.
Very.
Lord, before my learned friend commences his submissions, my lord.
Yes.
My lord, Lordship will recollect on last occasion, my lord, when Mr. Mitra concluded while he was concluding his submission, my lord, he relied on a written submissions, my lord, which was produced before your lordships for the first time, my lord. Written notes of submissions, which, my lord, according
in the trial,
which according to
yes,
Mr. Mitra, my lord, was
in the
filed
trial
by,
court, yes.
in the trial court.
Yes.
But we were never, my lord, we were never ever served about that. Lord, in that respect, my lord, I have served a notice. Lordship will kindly see. Lord, the mails.
No, while you give your rejoinder, you say that.
So, because if Lordship permit me, my lord, what has happened, my lord, after going through the written submission, my lord, I have found that, my lord, there are mails, my lord, which are truncated mails or mails which are in parts, my lord. So, my lord, what I have done, I have prepared a compilation, my lord.
No, is this supported by an affidavit? This written notes of argument?
My lord, no, my lord, that is the submission which was made, my lord. I am not very sure. Because it's a written submission, what Mr. Mitra submitted, my lord, it was supported by an affidavit. That was a submission, my lord.
Yes, yes, it was.
It says so, my lord, because
yes, it says so. The affidavit
it says so because I was never ever served with a copy, my lord. For the first time, I have seen this written submission and the documents.
Take that point in your rejoinder and also your written notes. Yes. Yes, Mr. Lagwani.
My lord, kindly for a moment, my lord, just consider.
After you, who else remains to argue? Mr. Brutinde has submitted.
Respondent number 5. Respondent number 5. My father.
Who is appealing
number
for?
5.
Who is appealing for?
Mr. Siddhartha Banerjee.
All right.
Mr. Siddhartha Banerjee.
Very.
And I believe they are the ones who had filed the written affidavit. It was the nomenclature was written submission, but it was in the nature of an affidavit, sworn affidavit. My lord, kindly consider for a moment page 90.
I just wanted to know for whom my learned friends appeal.
I am for my lord respondent.
He is for respondent 18.
18. Vithal Ganeriwal. My lord, kindly take page 90 for a moment. 90.
90 of this.
Of my lord, I am only referring, my lord, to the appeal that has been filed. So volume 1, page 90. My lord, at the outset, my lord, I say that I support the plaintiff who is similarly placed as I am, and I adopt Mr.
I mean,
Shiroji.
you mean the stay application? The stay application volume.
Yes, the stay application.
Right.
My lord, I support the plaintiff, my lord.
Obviously, yes.
And I adopt the submissions of Mr. Mitra, and I'm not repeating anything that he has stated.
Please. Thank you very much for that.
Now, kindly, my lord, take page 90 for a moment. Your lordship will, my lord, see at page 90, Vishwanath Ganeriwala is the patriarch, my lord, from whom, my lord, this stems. And Mr. Jain's client is to the extreme left, the eldest son, Pradeep Ganeriwala. Your lordship will, my lord, extreme left.
Yes,
your lordship will move to the right, the second last name, Manoj Ganeriwala.
You are him.
That is my father. And I am his son, Vithal Ganeriwala. My lord, today even I am quite aged. I also have, my lord, have a family of my own. Vithal, your lordship will see that. So I am the grandfather, my lord, of Vishwanath Ganeriwala. A grandson of Vishwanath Ganeriwala.
Yes.
And if your lordship will recall, my lord, in the will, I have also, my lord, my name has been inserted.
Yes.
In the will. As
yes,
my lord,
you shouted from behind that you are also a minor and.
Yes. So, my lord, I inherit under the will, even in the absence of a will, my lord, Mitakshara family. So, my lord, by birth, my lord, grandson, by birth, my lord, I acquire a right as a co-personer.
Yes.
So, both ways, it's undisputed, my lord, that I have a share. Now, if your lordship sees the deed, I straight away take your lordship to the deed, my lord, the partition deed, which is one of the subject matter of challenge in this suit. That is, my lord, at page 181. Just consider the deed for a moment, my lord.
Yes.
And in the deed, my
No,
lord,
the
your lordship,
181 of this.
yes, 180, 183, 184, my lord, there are some pages, but the relevant portion which I would like to take your lordship
Oh,
to, my
yes.
lord, is at page 190.
190. Let us go there.
Yes, kindly come to page 190, my lord. Volume 2.
Yes.
Yes, your lordship will see, my lord. 11. Right on top, my lord. 10 is Srimati Rashmi Ganeriwala.
Yes, you have been mentioned as a minor.
And 11, my lord, Master Vittal. That is me. Now, the deed is of 2nd December 2008. And I was born on 28th April 1990. Now, this, my lord, I must say, it's undisputed. But even then, there was a query which fell from the trial judge. So, pursuant to the query, I had, my lord, tendered my ID.
Birth certificate.
ID, Aadhaar, birth certificate, school passing certificate, I had put in by way of a fijisti. Upon, my lord, the query of the judge to satisfy that indeed who I am. So, my lord, this is really undisputed. 28th April 1990. So, my lord, in 2008, I had already become a major, attained the age of 18. I was about 18 years and 8 months of age.
So all the masters here were majors in this deed? Or some of the masters were actually masters or...
No, my lord, at least my client and the plaintiff.
Because all the masters whom we find, Master Rohan.
That's the plaintiff.
That's the plaintiff.
Yes. Then there is Master Vithal.
Master Vithal is you.
Yes.
Master Raghav.
Raghav.
Anant, probably they would also be coming.
I'm told, my lord, at least to the best of my knowledge, there were 5 persons who were masters. And one of them, my lord, is my first cousin, very close to me, who actually now has migrated to Germany. She has recently learned about this matter. And she has, my lord, asked us to do things
on her way. Not on her way, I mean.
Because she has migrated there, but she supports our cause. I don't know, maybe by the time this appeal ends, my lord, we may have some authority from her. But because she's personally very close to me. And she has learnt about these proceedings from me. So, my lord, because she has shown to be, my lord, a resident of India, but she actually is now living in Germany. So there are, my lord, a lot of persons.
If one of the masters succeed on that argument, then it vitiates.
Yes, yes. So, my lord, this deed. Now, my lord, why is it that, my lord, people are after this deed? I want to tell your lordship. My lord, if your lordship takes page 198. Yes. This is, my lord, what I have gathered after, my lord, interacting with, my lord, some persons. This is, my lord, kindly see 16.
16, yes.
On the dissolving and dissolution of the said Vishwanath Ganeriwala HUF, the immovable property in Mumbai has been allotted to Pradeep Ganeriwala, the second party herein. Pradeep Ganeriwala HUF, the second party herein, free from all encumbrances and or any claims or rights from the first. So, my lord, what happens is that there is, my lord, a partition deed, which is, my lord, purported deed, which is entered into, where, my lord, many of us, including myself, my lord, we are not parties. And, my lord, in the schedule, which contains all properties of the, my lord, estate, this Bombay property is excluded, but, my lord, it's thrown in between. And this Bombay property, my lord, is the meat of the estate. This is, my lord, a building in Juhu. Juhu, my lord, is that area of Bombay where all the film stars live.
That much we also.
Per square feet price of a flat in Juhu today would be around 1,20,000 to 1,30,000 per square feet. As compared to, my lord, Roland Row.
So you want to mean, I mean, basically, Mr. Jain argued that Mumbai property was not a subject matter of the schedule of this deed.
Yes.
So therefore, it's not one of the properties and you put that in the schedule. But you say that although it's not in the schedule, but it's there inside, it has been put inside.
Yes.
And by virtue of paragraph 16,
yes,
the title regarding this Mumbai property is also dealt with.
Yes. Which is why, my lord, the deed otherwise...
Although it's not in the schedule formally, but in the body, it has been incorporated that you are rather relinquishing your rights by saying that it has already gone to him.
If I may be candid before the court, today, out of the 6 brothers, 5 brothers are on one side and Mr. Jain's client is on one side.
Maybe.
Nobody is opposing the plaintiff apart from Mr. Jain's client. Among the sons of Vishwanath. My lord, this clause, if this clause is deleted, a lot of parties would be willing to call a truce. This is, my lord, what I have gauged, my lord, in the matter.
Because it all stems from, this is one of the main contention. Everything else, what is in this bank account?
If this property is this clause is deleted, then Mr. Jain won't be interested in his client won't be interested in the matter at all.
In that
this
also.
is the
This is this is
definitely that.
My lord, so this now such an important property which comprises,
so this is actually the
in terms of value.
Yes.
In terms of value, my
The
lord, the
beehive.
estate will turn on this.
The honeycomb.
Yes, because Roland Row is an equally large building, but what we would
Juhu
pay.
and Roland Row.
I'm sorry.
Juhu and Roland Row.
My lord, if Roland Row, my lord, one flat in
Shahrukh Khan and Prosenjit sort of.
My lord, one flat in Roland Row in Juhu, Lordship will struggle to get a toilet for that money. Frankly, I'm not.
I'll struggle to get a toilet even in Roland Row. So let us not go by those examples. But
Lord, if
generally speaking, yes,
anybody,
people would be having difficulty.
Yes, my lord, and this is not an exaggeration, my lord. It's
No, we
literally.
understand. Obviously, it's a very obvious.
A lavish flat in Baliganj today, Mandevilla Gardens, for example, my lord.
No, obviously, Juhu is Juhu.
Yes. So, my lord, this is, my lord, now, my lord, such an important asset, not, my lord, conspicuously mentioned in the schedule of the property.
That is very clear from the first sentence, the opening sentence of Mr. Jain.
No,
that
my lord,
this is the crux of the matter.
Now, my lord, I would like to tell your lordship.
There is no doubt on that.
My lord, now your lordship will now consider, my lord, where the difficulty arises. That my father filed a partition suit before the same learned judge. This partition suit was filed, my lord, 2 months prior to, my lord, this suit, which is the subject matter of the appeal before your lordship. Now, my lord, in that suit, my father prayed for a partition. And in that partition suit, saying that this entire estate of Bishwanath Gariwala is to be partitioned, in the schedule of that partition suit, this Bombay property was mentioned. And, my lord, the learned judge has granted an injunction on the Bombay property.
That is in Bombay. The suit is in Bombay.
No, suit in Calcutta.
Achha.
Because, my lord, the estate is very vast. This might be the main, my lord, property, but
there are
other things in Calcutta. So, which is why the suit has been filed before the same learned judge, my lord. And there is an order of injunction, my lord, which is operating. I would like to, my lord, just.
What about the Bombay suit? There is also a Bombay suit which was being placed. That was yes. And Mr. Jain's case was that you knew about the Bombay suit and you learned from the schedule of that.
Not my learned friend.
No, not him.
I will
Mr.
take instructions, my lord. Bombay suit, I'll have to take instructions. Anyway, my lord, kindly, my lord.
Bombay suit is by whom? I forgot.
By
you.
By my HUF, my lord. Not
Your
by me,
HUF.
my HUF.
He has, my lord, included one generation.
Yes, my lord, it is my HUF who is the owner of
Yes. As per this 14, 16.
Correct.
So, Lakshman, we are being candid. These loose papers you are handing up very well. We'll look into these, but these will lose. I mean, in the jungle of papers. So it's better cite it formally,
yes,
so that a copy is given to Mr. Jain, and he's put on notice that he was citing this.
Yes.
And you can add this to your written notes of argument with those things.
No,
but right now you can place it because formally, unless you
my lord, by heart remember this order.
no, but provided he sees what is there.
I will.
Very poor, my lord.
I'll hand.
Remember what I had this morning.
I will hand it over. So, my lord, this is the suit filed by my father, where my father gets an injunction on 3 properties of the estate. Because, my lord, in the plaint, there were several properties, but the learned judge was of the view that only those properties of which you can show me some documentation prima facie, only on those I'll grant an injunction. Luckily, my lord, he had, my lord, some papers of the Bombay property. So, my lord, on 3 properties, my lord, injunction has been granted. Your lordship will see the operative part.
Bombay is one of them.
Yes, Bombay is one of them. Kindly see, my lord, at page 3 of the order. Defendant numbers 1, 5, and 6 are hereby restrained from transferring, alienating, and creating any third-party interest in respect.
Same properties, Bombay, DMAT, and all.
Those three, my lord.
In the present.
Yes, the plaint. Now, this plaint, my lord, of my father is at page 96. This plaint, my lord, is at 96.
Your father is still alive.
Yes, he's respondent number 5. He's the last one to argue after me. Mr. Siddhartha Banerjee represents my father.
Achha.
Page 96, my lord. Your lordship will see the plaint. Manoj Kumar Ganeriwal, he's the plaintiff, my lord. And the defendants are, my lord, your lordship will see Pradeep Kumar Gariwala, that's Mr. Jain's client.
Yes.
Same members of the family, my lord.
Yes.
And, my lord, in the schedule, in the schedule of this plaint, my lord, one of these properties is the Bombay property.
This is an ex parte identity murder.
Yes, this was an ex parte identity murder.
Yes.
My lord, an order passed under an application under section 150.
Whatever provision, my lord.
Caption is immaterial.
No. When my turn comes, my lord, initially an application.
They must then
order
challenge
39,
this order if they have to challenge this order, and then we'll deal with it if they
There's
challenge.
an earlier 39-1-2 also.
1-2, which was rejected, refused. Then 150.
But this order is still there.
It is still.
It is a subsisting order. So even if in this appeal your lordship, my lord, vacates the Bombay injunction, it remains injuncted by virtue of the earlier order. Now, my lord, so this is, my lord, the plaint. And my lord, in the plaint, same, your lordship will see, my lord, the schedule of this plaint.
Yes, you can understand from the injunction order itself.
Pretty much. Pretty
Demat
much.
is there and these
Yes.
properties
And my lord, the Juhu property, my lord.
must be there.
Yes. Yes, the Juhu property is also there. Now, my lord, your lordship will now consider this. They, my lord, filed an application, Mr. Jain's client, under Order 7, Rule 11 for rejection of this plaint. Now, my lord, kindly just see their pleading. I want to show only one sentence in that application. Page 126 is, my lord, the application. Page 126. This is, my lord, page 126, their application under Order 7, Rule 11. And then your lordship would, my lord, kindly take paragraph 5 at page 129.
Yes.
This is, my lord, Mr. Jain's client speaking. The plaintiff, knowing fully well that there was a family settlement and partition in the year 2008 by and between the heirs of late Vishwanath Ganeriwala, when the parties had distributed, allocated, divided and demarcated their respective entitlement in respect of the properties left behind by late Vishwanath Ganeriwala, which came to Hindu undivided family by virtue of will left behind by late Vishwanath Ganeriwala. By such family settlement, the defendant number 1 was, inter alia, exclusively allocated the immovable property at Jurutara Road, Ganeriwala House, Juhu, Mumbai. Now, my lord, Mr. Jain has submitted before your lordship that the deed doesn't deal with Bombay. The deed doesn't even refer to Bombay in the schedule. In fact, my lord, there was a statement.
Oh, this family settlement is
Yes, yes.
Oh, acha.
Kindly, my lord, consider, my lord, Mr. Chaudhary was arguing on, my lord, approbate and reprobate and hot and cold. My lord, here before your lordship, my lord, they come and say, because the deed is, my lord, challenged here, and for the purpose of jurisdiction, to try and sort of segregate Bombay to suit their purpose for jurisdiction, they say that deed is one thing, Bombay is another thing, and the deed and Bombay have nothing to do with each other. And I have shown to your lordship, my lord, that the Bombay property is inserted in this deed, thrown in, my lord, out of nowhere, quietly, so that the registration or the signing goes through. And then, my lord, they are contending, my lord, in the other suit, which is a partition suit, that this deed is the document by which, my lord, the Bombay property is being allocated. And, my lord, kindly consider in law, what other document do they have? Mutation pursuant to a court order, where siblings give consent for a property to be mutated in favor of the Karta. How can that confer title? In the alternative, a declaration, a registered declaration. I can today, my lord, declare that I own Victoria Memorial and have it registered. How will that confer title upon me? My lord, the only document in this entire case, which perhaps, my lord, can give them a right on the Bombay property exclusively.
Mutation.
Mutation, my lord, can't confer title.
Not title.
Not title at all.
But what else do they have?
My lord, just the deed. If this deed goes,
No,
then
their best paper is that mutation, where you said that they will deal with the Bombay property on behalf of the others.
My father and my uncles.
No conferment of title, definitely.
No. But my father and, my lord, some other elder members of the family who, in their patriarchal mindset,
that is the only document they have.
Yes. So, my lord,
family deed of family settlement, although they have stated that it has, by virtue of that, it has been allocated to them, but that just carries a sentence whereby it has been rather expressed that it has been given to him previously. It recognizes a previous apparent allocation or transfer.
Yes.
It does not confer title by itself.
Yes. Now, my lord, may I just say two things? Firstly, that bunch of 4 or 5 patriarchs disregarding our generation cannot, my lord, give away something in which we have a right, just by, my lord, saying that, okay, it might be mutated or anything. And secondly, my lord, though I am not, my lord, a party to that, but my interpretation on the basis of it is that because he was the Karta, eldest brother, patriarchal Marwadi family, father died, will also said that the eldest son will be the Karta. And, my lord, they had people living in Bombay from his branch. So, my lord, in these circumstances, there was, my lord, he was allowed to, my lord, be the person in whose favor the property was mutated. So, my lord, mutation can't confer title. This purported declaration, my lord, can't confer title. What actually can confer title in law is, my lord, a deed of partition. Because, my lord, partition, lordship also is aware that stamp duty also on partition is, my lord, paid on the basis of conveyance if there is an exchange of hands. And there's a complicated method of calculating, my lord, stamp duty on partition deeds.
Sort of exchange.
Exchange, or, my lord, but if the exchange isn't, my lord, fair, if one is deriving much more.
So obviously, it's calculated on that.
Yes.
On the,
yes.
Like
So,
in a partition suit OLT.
yes, pretty much.
Same principle.
So, my lord, this document, this partition deed, if stays and if registered, my lord, gives them the Bombay property based on that clause, provided, my lord, the conditions are met, which is a second argument I have, that even that is not met. It says that the precondition would be for dissolution of the HUF, Bishwanath Gariniwala's HUF. And there is material on record, my lord, to show that the HUF has continued. And the HUF continues, my lord, to thrive and own, my lord, movables, which, my lord, was, and, my lord, how the HUF, my lord, is still surviving. This had been filed on affidavit by my father before the trial court, Mr. Banerjee's client, who will, my lord, argue after me. And I had adopted his submissions insofar as that is concerned, to show that this HUF was never discontinued. It has continued. So a precondition for giving the Bombay property is not met. So hypothetically, assuming for the sake of argument that the deed is a valid deed, even then what was to be done under the deed has not been done, and therefore the Bombay property hasn't transferred. So this was, my lord, a submission B, the second limb. So where I had adopted their submissions that yes, the deed has, and they had brought on because he's the elder person in the family who has correspondence with his brother. So he had brought on record certain documents to which he was privy. So I had adopted those submissions and accordingly stated that the firm has continued. The HUF has continued. So, my lord, kindly consider this. What Mr. Jain has stated before your lordship, that Bombay property has nothing to do with this deed, my lord, is completely contrary to their submission, my lord, in before the court below in the other suit.
Yes. That's
So,
your last bell.
This makes me reminiscent, my lord, of debates in school.
Yes.
There was an alarm keeper, and
You always jumped the time and then. So we'll continue tomorrow. Tomorrow is the hearing day.
Give me 1 or 2 more minutes,
Yes,
my lord.
yes.
In a rush, I may have missed out 1 or 2 points.
Definitely.
But I've covered the bulk of my submissions.
Right. Thank you. Heard in part for further hearing tomorrow. Yeah,
Grateful.
Thank you.
Great.